Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide, when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire, before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. This last paragraph I just read to you about Ms. Dixon's murder and the murder, she was pregnant at the time, and her unborn child. That information cannot be used by you in any way, shape, or form to determine whether or not he's guilty of these charges. It's a separate case. So we're going to be talking to you about your ability to put that aside, and we will have some questions about that relating to the death penalty, but we'll get to that in just a few minutes. So right now, as a group, what I want to ask you, and if you'll please just raise your paddles in it as an answer. Once I call out your number, you can put your paddle down. How many of you have heard about this case prior to today? All right, from panel 2, I have jurors 42 and 56. From panel number 6, I have jurors 39, 41, 42. You can put them down as soon as I call your number, 56, 60. And from panel 7, I have 1, 6, 11, and 13. Anybody in the back row? 24. 18 and 24. Is that it? All right. For those of you who raised your paddles, how many of you have formed an opinion, just raise your paddles again, have formed an opinion as to Mr. Loyd's guilt? All right, from panel number 2, I have 42 and 56. From panel number 6, I have 39. Somebody else raise their paddle. 56, did you raise yours? 56 and 60. Anybody else in the back row from panel 7? All right, so forming opinion, I have 52, 42, 56, 39, 56, and 60. Anybody else? All right. And then my next question is, does anyone have a moral, religious, or personal objection to the death penalty? If you do, raise your paddles, please. From panel number 6, I have juror number 60. And from panel number 7, I have 18 and 25. Anybody else I missed? All right, thank you all very much. If I'll have juror number 42 from panel 2, if you'll remain in the courtroom, the rest of you will retire to the jury room. There's coffee back there. We'll be with you just as fast as we can, folks. Thank you.
Yes, please.
All right, good morning, welcome back.
Thank you.
All right, I just want to confirm, you're juror 355?
Yes,
Is that
ma'am.
correct? All right. All right, so you said you'd heard about this case, is that correct?
Yes.
How much have you heard about it?
A lot.
Okay. Do you follow it pretty closely?
I do, and I also have, I work for the fire department. I have friends that were on that scene.
Okay. And did you discuss that with them?
A lot of us worked. We had to go into a lockdown in the fire department that day. So we were told why, we were told what happened.
All right. Did you know Lieutenant Clayton?
I had worked with her through the years at a couple events. Just knew her cordially, enough to where we would recognize each other and say hello.
So you formed an opinion as to Mr. Loyd's guilt or innocence?
I did, and
What is that opinion?
guilty.
All right. You have to be able to presume he's innocent until proven guilty. Can you do that?
I've tried. It's been 8 days. First came in, I've really tried each day that they go through it, and I already have an opinion.
Okay, thank you, sir. State.
We move, Judge.
Any objections? All right, thank you for your honesty. You're free to go. You're discharged as a juror in this case. Juror in seat number 56 from panel number 2. And that finishes panel number 2.
Morning.
Good morning, sir. Welcome back.
Good morning.
I just have a few questions for you. Let me
Okay.
start with, you indicated that you knew a lot about this case. Is that correct? How much did you follow? Okay. So have you followed it from the beginning to now, or?
Not in the last bit,
Okay. All right. Did you form an opinion as to Mr. Lloyd's guilt or innocence? And what is that opinion? All right. You must be able to presume that Mr. Lloyd is innocent in order to sit as a juror in this case. You're smiling at me. Do you believe you can do that, or do you can't put aside your feelings? State.
We move, Your Honor.
All right. Thank you, sir. We appreciate your honesty. You are free to go. You're discharged as a juror in this case. Thank you. All right. Moving on to panel 6. Oh, Lord. Juror in seat number 39, please. This is juror 101. Good morning, ma'am. How are you?
Good.
Okay. I know this isn't the most comfortable situation in the world for you, but try to relax. I'm just going to ask you a few questions. I just need you to be honest with us. All right, that's all
Yes,
we're
ma'am.
looking for. Not any particular answer, nothing like that. We just need to know if you can do your job as a juror in this case.
Yes, ma'am.
You indicated that you had some information about Mr. Lloyd's case. Is that correct?
Yes, ma'am.
How much do you know about it, or how much have you followed?
Recently I haven't, but when it first happened, I was pretty involved with it.
Okay, just watching it on the news.
Yeah, also, we have a family friend, a real close family friend was Norman Lewis, and he lost his life on that day as well in a motorcycle accident, reported to the scene, I believe it was.
Okay, so your family is friends with
Yeah, he was a close family friend.
Officer Norm, the officer who was killed in the motorcycle accident?
Yes, ma'am.
Okay.
So,
You understand that Mr. Lloyd had nothing to do with that motorcycle
yeah,
accident?
but I just followed it because of
Okay, all right. I just want to make sure that we were clear
Yes,
on what we were
ma'am.
talking about. So so I take it you were talking to other people about what was going on?
Yes, ma'am.
All right, based on all of that, did you form an opinion as to whether or not Mr. Lloyd is guilty?
Yes, ma'am.
And what was that opinion?
I believe he was guilty then.
Okay. You have to be able to presume him to be innocent when you start the trial. Do you believe you could do that, or would you believe he was guilty?
I believe I'm a pretty open-minded and like unbiased person when it comes to certain things. So, I mean, if I was selected, then I would definitely take it very seriously and form like unbiased opinions about everything.
Okay, so let me ask you a question. I'm going to give you 3 scenarios, and you tell me if any one of them applies to you, okay? If they don't, just tell me no, all right? The first one is you're selected as a juror. It's the first day of the trial. You've heard nothing, and you're sitting in that chair, and you're saying, okay, I presume he's innocent, and I'm going to wait and see if the state can prove he's guilty. The second scenario is you're sitting in the chair, and you're thinking, yeah, this guy's probably guilty, but I'm willing to see if I'm wrong. And the third scenario is, I think he's guilty, but if he can convince me otherwise, I'll acquit him. Which one, do any of those 3 apply to you?
I think 2 would be the most
All right.
relatable.
Thank you, ma'am. State.
We move, Your Honor.
All right, thank you, ma'am. We appreciate your willingness to serve. I don't think this is the case for you, so I'm going to release you as a juror. Have a good day.
Yes, ma'am. Thank you.
All right. So again, that was juror 39, panel 6. Juror 56, panel 6. Good morning, sir. How are you?
Good morning, how are you? I'm doing well.
Thank you. Sir, I have a few questions for you. There aren't any right or wrong answers to these questions. The questions are meant to determine whether or not you can do your job as a juror in this case. We need to know and you need to know. So just tell us the truth. Don't worry about what the answer is, okay? Just be honest with us. You indicated you knew something about this case. How much information do you have?
Going back to the time, all the news reports and everything that was there, even up until the conviction that you mentioned.
All right. So are you a pretty much regular watcher of local news?
Yes,
Do you also read the newspaper?
yes,
How about the internet, Facebook?
yes, yes,
So you got information from all of that?
yes,
And were you talking to other folks about it, family, friends, coworkers?
yes,
So based on all of that, did you form an opinion as to whether or not Mr. Loyd is guilty?
yes.
And can you tell me what that opinion was?
The opinion is based on what the and the news that I heard, yes, that brought me to my decision
And what is your decision?
that he's guilty.
All right. In order to be able to sit as a juror, you have to be able to presume Mr. Loyd to be innocent until and if the state proves he's guilty. Do you believe that you can do that, sir, or would you start the trial assuming he was guilty?
I cannot do that.
All right. Thank you, sir. State.
We move, Your Honor.
All right. Thank you, sir. You are excused. We appreciate your honesty. You're free to go. This
Thank
isn't the
you.
case for you. Thank you. Juror in seat number 60, panel 6.
Right here, please.
Good morning.
Good morning.
I know this isn't the most comfortable situation for you, but try to relax. I'm going to be asking you some questions. There's no right or wrong answers to these questions. The questions are meant, and the attorneys have a right to ask questions also. We're just here trying to determine whether or not you can do your job as a juror in this type of case. You need to know that, and we do too. So the only correct answer is the honest answer, all right? You need to tell us what you actually think, feel, and believe. Let me start with, you indicated that you have some information about this case. Is that correct?
Yes.
How much information do you believe you have?
Well, my brother-in-law is a Walmart store manager, and he knows the person who is managing the Walmart this happened at, so that's how I know.
Okay. So did your brother-in-law, without telling me anything he said, did your brother-in-law talk to that person?
The store manager?
Yes, ma'am.
Yes. Mhm.
And did your brother-in-law then talk to you all about it?
Yes.
Did you follow any of the news stories about this case?
Yes.
How closely did you follow it?
Pretty closely.
All right. And with news, did you read the paper also?
I didn't read the paper.
Internet, Facebook? any of
Internet,
that?
yes. Mhm.
And beyond your brother-in-law, did you talk to friends or family or coworkers about it?
Yes.
All right. Based on all of that, did you form an opinion as to whether or not Mr. Loyd is guilty?
Yes.
And what is that opinion?
Guilty.
In order to serve as a juror in this case, you have to be able to presume he's innocent until and if the state proves he's guilty beyond a reasonable doubt. Do you believe you would be able to do that, or do you believe you would start this trial thinking Mr. Loyd was guilty?
I would start this trial thinking he's guilty.
All right, thank you, ma'am. State.
We move, Your Honor.
Thank you, ma'am. This isn't the case for you. We appreciate your honesty.
Okay.
You are free to go.
Thank you.
Thanks. All right, I'm returning to panel 6, juror, and I only have 2 left, so I'm going to call juror in seat 41, please.
Sorry, Judge.
Juror in seat 41, panel 6. Good morning, ma'am. How are you?
Fine, thank you.
Let me just verify that you're juror 289, correct?
Yes, correct.
All right. I have a few questions for you, then the attorneys will probably have some questions for you.
Okay.
There aren't any right or wrong answers to these questions. The reason we're asking them is to try and determine whether you can do your job as a juror in this type of case. We need to know that, and you need to know that.
Yes.
All right? So the only thing that we ask is that you tell us the truth, and
Sure.
you just answer the question that you're asked.
Sure.
And hopefully we can get you out of that oh-so-comfortable mask in just a little bit. All right, let me start with, you indicated that you'd heard something about this case, is that correct?
Correct.
Can you tell me what you've heard?
That there was a shooting and the death of a sheriff. I don't watch the news. I just know that that was a big talk.
So you,
a
were
couple
you
of years
hearing it
ago.
from family, friends, coworkers?
Co-workers.
Coworkers? All right. Do you remember anything, well, let me clarify. So you didn't actually see it on the news, you just heard it from other people.
Correct.
Do you remember what they said?
That a guy had shot his girlfriend and then was in a store and shot a sheriff in cold blood, is what I remember them saying.
All right. Did you discuss it with them, or?
No, I just said, oh my God, that's terrible, and that was it.
Did you ever read any stories about it?
No, we don't get the paper, and I don't watch the local news.
So based on what you heard, did you form any opinions about Mr. Loyd's guilt or innocence at that time?
He was arrested, he was there, and so I just, kind of assumed that he had shot her, the sheriff, but that's all I've given it thought.
Right. In order to be able to sit as a juror in any criminal case, you have to be able to presume the defendant to be innocent until and if the state can prove they're guilty beyond a reasonable doubt. Do you believe that you can put what you heard aside and presume Mr. Loyd to be innocent?
Oh, absolutely.
Okay, so you don't have any doubts about your ability to start this trial believing him to be innocent and holding the state to their burden?
No, I believe everyone has that opportunity.
All right, so let's move on to the death penalty questions. First of all, you didn't indicate that you have any personal, moral, religious objections to the death penalty.
That's correct.
All right. As I explained, there is no automatic death in the state of Florida. So in order to get to the penalty phase, you have to have found someone guilty of first-degree murder, intentionally killing another person with no legal justification for it. You understand that so far?
I do.
If at any point I lose you, let me know, all right?
Yes, ma'am.
Are you someone who believes that if a person is convicted of first-degree murder, they should be sentenced to death?
Again, I listened to your instructions, and I would not be able to answer that unless I knew what the mitigating factors were.
Okay. Is the fact that this is a law enforcement officer, the person who died was a law enforcement officer, a police officer, would that change your answer in any way?
It does. There's more weight because it was an law enforcement officer. So that would weigh on my decision.
Right. So let me ask the question another way.
Okay.
Sitting, and don't let me put words in your mouth, because I'm not trying to.
Okay.
All right? Trying to ask the question as neutrally as possible. Sitting here, having heard nothing, is the fact that it would be first-degree murder of a law enforcement officer. You haven't heard any mitigators, you haven't heard any aggravators, that's just all you've heard. Would your vote automatically be for death just because it's a law enforcement officer?
No.
Okay. Same question as to the prior murder conviction for Ms. Dixon and the unborn child. Just hearing that, would that cause you to say, if I convict him of first-degree murder, I'm voting for death?
No.
All right. You heard me describe the process to you of weighing aggravators and mitigators. Do you believe that is something that you could do with an open mind?
Yes.
Can you listen to the evidence if we get to a penalty phase, can you listen to the evidence, wait till the end, hear everything, aggravators, mitigators, without closing your mind to what you're hearing, and then go in the jury room, deliberate, and reach a vote?
Yes.
If that process of weighing and listening led you to believe that life without parole was the appropriate sentence, could you vote for that?
Yes.
And if that process led you to believe that death was the appropriate sentence, could you vote for that?
Yes.
Then lastly, I want to ask you about the insanity defense. I told you Mr. Loyd's raised it. Their burden to prove it in the guilt phase. But assume that you've heard all the evidence in the guilt phase, and at the end of it, you are convinced that he was insane at the time this occurred. Would you be able to return a verdict of not guilty by reason of insanity?
I don't know, because I don't know what, I guess I'm thinking that there are circumstances and things that would have been presented that would have allowed this to prove the sanity or insanity. So I guess I don't
Correct.
understand the
So-
question, I'm sorry.
It probably wasn't a very clear question, all right? You're in the guilt phase of the trial. You're trying to decide whether or not Mr. Loyd is guilty. States put on all their evidence on. The defense has put on all their evidence, including their evidence of insanity. At the end of it, assume you believe all of that, and you are convinced based on their evidence that he was insane at the time of the offense. Would you be able to vote not guilty by reason of insanity?
You're saying if they proved it?
Correct.
Yes.
All right. And then the last question I need to ask you is the prior murder involving Ms. Dixon and her unborn child. Can you put that out of your mind when trying to decide guilt? In this case, they're two separate cases.
Yes.
All right, thank you, ma'am. I don't have any other questions for you, but I believe the attorneys might. Mr. Williams, you may inquire.
Thank you, Your Honor. Good morning, ma'am.
Good morning.
So I was looking at your juror questionnaire that you
Yes.
filled out, and it seems to me that you made a relatively significant career change from your prior employment to your current one.
Yes.
Can I just ask generally why that was, or what prompted that?
Yes. I was living in Gainesville, and my father came down with Parkinson's, and so we moved back here so I could take care of him. And so a teaching opportunity came up, and I started teaching, and it allowed me to be close to home and take care of him and so forth. So, and then I just fell in love with it, so I've stayed teaching.
Yes, ma'am. Okay, thank you for letting me know that. Your questionnaire also indicates that you previously served as a juror.
I have.
How long ago, or how many times?
I think 2 times.
All right. How long ago was the most recent?
I don't know, maybe 4 or 5 years ago?
All right. Was it here in Orange County or in Gainesville?
No, it was in Orange County.
All right. What was the nature of the case? Was it civil or criminal?
I believe it was civil. It was a gentleman, I think he was a felon and he had a gun.
That would be criminal.
Oh, okay.
To know the answer to that. Without telling me what it was, did you and your other jurors deliberate and reach a verdict?
We did.
Were you the foreperson?
No, I wasn't.
The other time that you were a juror, how long ago was that?
That was probably 8 years ago.
Also in Orange County, or was that Gainesville?
Orange County.
Right? Was it criminal or civil? You can tell me what it was about, maybe I
He
can help
was,
you.
the person was found with marijuana in the car, and before we were selected, but before we even went to trial, they settled out of court.
Okay, understood. Anything about your experience in either one of those cases, particularly the second one or the more recent one, that you think left a bad taste in your mouth about being a juror in a criminal case?
No, there was just times when, I felt like people weren't giving all the options at first and kind of just rushing into decisions without kind of just talking. So.
I'm picking up what you're putting down. So were you all able to resolve that?
Yes, I spoke up and said something.
So even if you weren't the foreperson, you took at least the way I'm hearing you say it, a vocal role in the decision-making process.
I did.
Okay. Any concerns about doing that, or did you feel good about doing that?
No, I did. I felt like it was the only fair thing to do.
Yes, ma'am. Because insanity has been raised as to the guilt, I need to ask you if anyone in your family or someone close to you, or even you personally, have dealt with mental illness.
I have not.
There are those in our community who believe that mental illness is not real, or that it is an excuse to justify behavior. Do you feel that way?
No, I believe mental illness is very real.
Okay. I assumed, but I wanted to make sure. And you answered the question the judge asked you about insanity, but do you feel you could fairly weigh any evidence that was presented to you on the issue of insanity, and if it were proven to you by the defense, find Mr. Loyd not guilty by reason of insanity? Could you do that?
Yes, I could, if they proved it, yes.
Yes, ma'am. So the last area I wanted to talk to you about very briefly was the death penalty, because I was listening when you said that you heard the instructions and that you listened to them, and your responses to the judge lead me to believe that you understood them. That said, it is a lengthy, I feel like I'm very loud with this microphone for some reason. That said, it's a lengthy process, and I want to make sure we understand. I understand what you're saying. So I did hear you say that something inside of you leads you to lend weight, was the word you used, to the fact that a law enforcement officer was murdered.
That is correct.
What is that based on?
I guess just my sense of security and knowing that law enforcement is our first line of defense.
Okay.
If we don't defend them, or, if there's nothing significant about their death.
Yes, ma'am.
Yes, so I guess it's just something I've grown up with.
Okay, and I wasn't trying to be rude, but I can't remember everything you say, so I try to take notes every now and then. I was listening. So I heard you tell the judge that you would not automatically impose a sentence of death or vote to impose a sentence of death just because it was law enforcement. Did I hear you say that?
That's correct.
And I think I heard you say that the reason was because you would want to weigh the mitigating circumstances.
That's correct.
The fact that the victim is a law enforcement officer is in fact a statutory aggravator in the state of Florida. So it is one of those things that if it's proven beyond a reasonable doubt that you can consider it, right? But what I've heard you say is that that would not automatically lead to a vote for a sentence of death. For you. It would not automatically lead.
Correct, because I have to hear the mitigating.
Right, yes, ma'am. And this part is confusing, and I want to make sure that we understand. I think I heard you say that you could set aside Mr. Loyd's conviction of the prior crime when determining whether or not he's guilty, right?
That's correct.
I'm telling you that the fact that he's been convicted of that crime is an aggravator in the state of Florida. So you would be asked to consider it, not forget about it, to consider it if selected as a juror and making a decision in the penalty phase. Does that make sense?
Yes.
How much weight you give it would be up to you, just like with everything else. Nonetheless, could you set it aside for purposes of the guilt phase? Could you not consider it when determining whether or not Mr. Loyd is guilty?
I guess now I'm confused about the...
So it is confusing because
All right, let me step in here, ma'am. All right. The conviction, the prior conviction, when you're trying to decide whether he's guilty of the charges I read off to you,
Yes.
that has nothing to do with this, all right? You
Okay.
have to forget about that and just focus on the evidence that's offered during the guilt phase.
Okay.
Can you do that?
Yes.
All right, thank you. Go ahead.
So this was regarding the death penalty? Okay, okay. I'm sorry.
apologize. Like I told you, it's not an easy thing to do. We're asking you to forget about it for one thing and consider
I
it.
remember it. Okay, yes.
Okay.
Yes.
You referenced the mitigating circumstances, and the defense would have the opportunity to present evidence to you of anything in Mr. Loyd's life or background or experiences that they believe are reasons why a life sentence is more appropriate than a death sentence.
Okay.
You would have the obligation, as you've referenced, to give it meaningful consideration. You don't have to agree with it. You may decide it doesn't deserve much weight. Well, you may decide it's very weighty, but you have to meaningfully consider it. So if they were to present evidence of the fact that he had experienced racism in his life, would you be able to give that meaningful consideration?
Yes.
Or that he had a difficult upbringing or abuse, would you be able to consider that as mitigation?
Yes.
Okay. Is there anything in your life or background or experiences that you think we should know about you, given that we're trying to select the most fair and impartial jury in this case, that we haven't discussed? So, for example, sometimes people say, you know, my loved one was the victim of a homicide 10 years ago, and I just can't get that out of my head. Usually if it is something that, is there anything like that for you?
No.
Okay. Thank you very much, ma'am.
Thank you,
Your
Mr.
Honor.
Williams. Ms. Miller, you may inquire.
Oh, thank you for moving the court. Good morning.
Good morning.
Excuse me one second. Nope. I want to talk to you a little bit about some of the first
Is your
things.
mic on?
It is.
Okay.
Can you hear me okay?
Not really.
Can you hear me okay?
I can now.
Okay.
Okay. I want to talk to you a little bit about some of the first things you discussed with Judge Marquez. She had asked you what you knew of this case.
Yes.
And I believe your words were, I mean, he was there and he was arrested, so I guess I assumed he was guilty. Is that fair?
That's correct.
Okay. I'm going to steal a page from the judge's playbook and give you 3 scenarios and tell me if any of them resonate with you. And if they don't, that's totally fine as well. Do you relate to any of these? 1, I presume Mr. Loyd to be innocent. I can sit here and wait to see if the state has met its burden and proven him guilty beyond a reasonable doubt. Scenario 2, I think he's probably guilty, but I remain open-minded and look forward to hearing the evidence. Or scenario 3, I think he's probably guilty and I'll wait to see if they can convince me otherwise. Do any of those scenarios resonate with you at all?
If I had to choose, I would say, because I truly only know the one thing that I've shared with the judge was, you know, it was spoken about at my work, I would say 2.
Okay. And that you think he's probably guilty, but you would like to remain open-minded and hear all of the evidence?
That is correct.
Okay.
May I see the attorneys at the bench, please? Ma'am, I want to thank you on behalf of all of us for your service and your willingness to serve. It's hard to find folks who are willing to serve on these cases. I don't think this is the case for you, so I'm going to strike. I'm going to excuse you as a juror in this case. Sorry, I've been talking for 2 weeks. You have a good day, and you can keep that lovely mask as a parting gift.
Thank you.
Thanks. Juror in seat 42, please. This is panel 6. This is the final juror from panel 6. Good morning.
Good morning.
How are you doing this morning?
I'm good.
All right, we have some questions for you. I realize this isn't the most comfortable situation for you, so try to relax. But I'm going to be asking questions first, then the attorneys. There aren't any right or wrong answers to these questions, okay? This isn't like a test where you're getting graded. We're trying to find out, in asking these questions, we're trying to find out whether you could do your job as a juror in this type of a case. You know, follow the law, put aside your personal opinions, that sort of thing. We need to know that, and you need to know that. So the only thing that we ask is that you be completely honest with us and not worry about what the answer is, okay? The correct answer is the truth, whatever it is you believe or feel. So let me start with, you said you know something about this case?
Yeah, I mean, I've heard it around, but I haven't really, looked into it.
Okay, so tell me what you've heard.
Just that someone shot and killed a cop, executioner style, and then that was about it. I didn't get any names or...
So you didn't hear any names?
No.
But what made you assume that what you heard is this case?
I mean, they sounded similar, so I just decided, just in case.
Okay. And did you hear this on the news? Did you hear it from other people? Read it on Facebook? Where'd you get it?
I heard it from a friend whose mom is in the corrections facility, I think. I'm not really sure.
All right, what else did that friend tell you?
That was about it.
All right. So based on what she told you, did you make any assumptions about whether or not Mr. Loyd is guilty?
No.
You have to be able to presume someone's innocent in order to sit as a juror in a case until and if the state proves they're guilty beyond a reasonable doubt. Can you do that in this case?
Yes.
All right. You didn't indicate to me that you had any objections to the death penalty. Is that correct?
Yeah.
Yeah, you kind of, when you do that side-to-side head thing, it tells me that you have some concerns. Why don't you tell me what your thoughts are about the death penalty?
I mean, I'm not really sure. I don't really think about the death penalty as much. I mean,
most people
I don't think,
yeah.
But I guess if you really, really do something really wrong, then yeah, it's a consideration, but in this case, I don't know.
Well, you're not supposed to know in this
Yeah.
case, all right? So you're fine. And I'm not asking you about this case. I'm asking you in general what your feelings are about the death penalty.
Just that if you really do something wrong, then yes, I support it. But
Okay. Let me explore that a little bit, all right? As I told you, first-degree murder is the only charge for which death is a possible penalty. It's never required, it's not automatic, it's possible, all right? First-degree murder is the intentional killing of another person without any legal reason to do it. It's not self-defense. You don't have any defense to it. You just set out to kill someone and you killed them, all right? So if someone was convicted of first-degree murder, do you believe that that person should be sentenced to death?
No, I don't think so. I believe that if you do if you commit murder, I feel like you should live with it and live with the consequences.
Okay. So in this case, the first count involves the death of a law enforcement officer, police officer. Is there anything about that that would cause you to think right now, having heard nothing other than the little bit I told you, nothing? If I convict this guy of first-degree murder, I'm going to vote for death.
No.
All right. The prior murder he's been convicted of that I told you about Ms. Dixon and her unborn child, is there anything about that that would cause you to think, if he gets convicted of first-degree murder, I'm voting for death right now without having heard anything else?
No.
All right. You heard me explain that in order to even get to a penalty phase, first there has to be that conviction for first-degree murder, and then the penalty phase, state's going to put on evidence of aggravators. There has to be at least one, beyond a reasonable doubt. Defense is going to put on mitigators. You're going to go back in that jury room with your fellow jurors. You're going to weigh those aggravators and mitigators, assign to them the importance you believe they have for you, not everybody else, you. And then at the end, you're going to vote. So if all of that process, you've heard the trial, you've listened to the penalty phase, you've listened to everybody with an open mind, led you to believe that life without the possibility of parole was the appropriate sentence, could you vote for that?
I could.
And if it led you to believe that the appropriate sentence was death, could you vote for that?
Yeah.
Right. Let me talk to you about the insanity defense. You heard me tell you Mr. Loyd's raised that. This is in the guilt phase, when you're trying to decide whether or not he's guilty, all right? Burden's on the defense, but pretend it's the end of the case. You've heard all the evidence the state's going to put on, all the evidence the defense is going to put on, and you're convinced that he was insane at the time of the offense. Would you be able to vote not guilty by reason of insanity?
No.
No, you said? I'm sorry.
Maybe.
Maybe?
I don't believe in the insanity case.
You don't believe insanity is a defense? Or I'm sorry, you don't believe in insanity as a defense, or you don't believe in insanity?
No, as a defense. I believe in insanity, just
Okay.
as a defense.
So when the defense was putting on their evidence of this, would you be able to listen to it and consider it, or would you be sitting there going, I don't believe people are insane enough to commit crimes?
I would listen to all of the evidence with an open mind.
All right, so what did you mean by I don't believe in insanity?
As in, like, I'll listen and see if I can get persuaded the other way, but as of right now, I'm, in general, I believe that everyone always knows what they're doing. And if you don't, then you'll feel like morally bad about what you did afterwards once you did hear about it or you do know. But I will always listen with an open mind, though.
Okay, thank you, ma'am. State. You want to inquire? I'm sorry, hold on.
No, we do not.
All right, you're moving. Any objection?
No objection.
All right, ma'am. Thank you for your honesty. It's exactly what we needed from you. I don't believe this is the case for you, so we're going to excuse you from this case. You're free to go.
Thank you.
Thanks. All right, next up is panel 7. Juror in seat number 1, please.
Morning.
Good morning, how are you?
Hey, ma'am, thank you.
All right, oh, you remembered the instructions from the first one. So let me start by asking you, do you have any issues that would make it really difficult for you to be sequestered for 2 to 3 weeks. All right. Second question, you indicated that you'd heard about this case. Tell me how you heard about it.
I saw it on television, during the news when it first happened.
When it
That's all.
first happened?
Yes,
How much of that did you watch?
just local news, and maybe a couple of days, and that was it.
Okay. So did you talk about it with family, friends, coworkers?
At the time?
Yes, sir.
Oh, yes, ma'am. We just discussed. I'm sorry. But we made no decisions. It was just passing news.
All right, so based on that, did you form any opinions as to whether or not Mr. Loyd is guilty?
No, ma'am.
All right. You are required to be able to presume Mr. Loyd innocent until and if the state proves he's guilty beyond a reasonable doubt. Can you do that in this
Yes, ma'am.
case? All right. Let me talk to you a little bit about the death penalty. Do you have a position on the death penalty, sir?
No, ma'am. It's neither for nor against it. I feel that the punishment fits the crime, but the person has to be found guilty first.
Okay.
Then penalty phase, that's when you decide as a juror.
Okay. So let me ask you some follow-up questions on that. As I told you, we don't have an automatic death penalty in Florida. There is no case for which the penalty is automatically death. But first-degree murder is the intentional killing of another human being without any legal justification, right? It's not self-defense. It's not anything. You just chose to kill someone and you killed them, all right?
Mm-hmm.
If you convicted someone of first-degree murder, would you automatically say death is the appropriate sentence?
No,
All right. If the death was of a law enforcement officer, would that change your answer?
no.
And then lastly, you heard me tell you that Mr. Loyd's been previously convicted of murder for Miss Dixon and her unborn child. She was pregnant at the time, all right? Would that change your answer?
No, I feel he's already been convicted for that crime, so it's in the past.
Okay. You heard me describe for you the process by which the penalty phase is conducted. Evidence of aggravators, mitigators, you go back there and you weigh it. You understood all of that?
Yes, ma'am.
If at the end of that process, you felt the appropriate sentence was life without parole, could you vote for that?
Yes, ma'am.
And if at the end of that process, you felt the appropriate sentence was death, could you vote for that?
Yes, ma'am.
Can you put aside the prior murder conviction during the guilt phase of this trial? It can be considered during penalty, but during guilt, can you put it aside and understand it's a separate case? It doesn't have anything to do with whether he's guilty of this case.
Yes, ma'am. This is focused on the
Correct. So last questions for you about the insanity defense. Mr. Loyd has raised that defense. Burdens on them to prove it. If at the end of the guilt phase, you're trying to decide whether he's guilty or not, you've heard the state's evidence, you've heard the defense's evidence, you are convinced that he was insane at the time of this offense, would you be able to return a verdict of not guilty by reason of insanity?
Yes, ma'am, as long as it's proved.
All right. Thank you, sir. I don't have any other questions for you, but I believe the attorneys do. Mr. Williams, you may inquire.
Thank you, Your Honor. Good morning, sir. What type of operational business are you a manager at?
So, this microphone. I'm at the USTA, States Tennis Association.
See, I assumed it was tennis, but I didn't want to assume, so, okay. Do you have an opinion on the death penalty generally? Because I know you've been talking about no objections, you're not favor or against it, but just when somebody raises that topic, not to comment on your age, but you're not 20, so you've been around long enough to know that this has come up. It's
Right. And I was in the military as well, sir, so I understand, under UCMJ and everything else, that the death penalty does exist. But I still feel that a person's innocent until proven guilty, and if the penalty fits the crime, then it should be considered.
You referenced UMCJ, Uniform Code of Military Justice.
Yes,
Did you
sir.
play some role in the legal process?
No, sir. I just was active duty, so you have to know that.
You knew what you could do and not do what the
Yes, sir.
consequences were. Okay. So as you sit here, is it a fair statement that you're not in favor or against a penalty of death generally?
Correct.
But you think it's appropriate in certain circumstances?
Yes, sir, and as long as it's proven.
Right, as long as it's proven. Okay. So the judge described the process to you. You said that you understood it. The part of that I want to highlight is, regardless of what you hear during the guilt phase of the trial, and regardless of what evidence we present of those aggravating factors that the judge described, the process still dictates that jurors give meaningful consideration to the mitigating circumstances.
Yes, sir.
Mitigating circumstances are anything about Mr. Loyd's life, background, or character that he or his counsel present to you as reasons why a sentence of life in prison without the possibility of parole is more appropriate than a sentence of death.
Yes, sir.
You decide how important that information is. That's when the judge talks about giving weight to something.
Yes.
Don't think that I'm talking down to you. I
I understand, sir.
want to make sure that we're on the same. Just like with the aggravating factors, you may find that one or two or all of them are not that significant. It's your decision to make that determination. But when it comes to the mitigating circumstances, you have to be willing to give meaningful consideration. So if the defense were to present evidence of the fact that racism played a role in Mr. Loyd's life or background, could you meaningfully consider that?
If that's what they are mitigating, yes, I would take consideration, yes.
Right. If they were to present evidence that he had a difficult childhood or upbringing, regardless of how much weight you eventually gave it, a lot or a little, would you meaningfully consider?
Yes, I'd have to consider all their mitigations, just as I would consider.
Okay, yes, sir. Well, you say that but not everyone feels the same, so that's why we ask the questions. Because the defense of insanity has been raised as to his guilt, I need to ask if you or anyone close to you have dealt with mental illness.
No.
There are those in our society or community who believe that mental illness is not a real thing and that it is used often as an excuse or justification. Do you feel that way?
No, sir, the evidence is not there.
So I take that response to mean that you understand it's real and you could meaningfully consider any defense that were proven to you. Is there anything in your life or background experiences that you think we should know about you, given that we're trying to select the most fair and impartial jury, since you're told us that you're prior military? Anything else like that that you think we should know?
No, sir, I'm just
An operation background. May I ask which branch? Air Force. And how long?
20 years.
20 years. You retired?
Yes, sir.
Thank you for letting me know. Thank you for your service. No further questions. Thank you, Your Honor.
Thank you, Mr. Williams. Ms. Miller, you may inquire.
Morning.
No.
Correct me if I'm wrong. I believe you told us before that you had some concerns about being able to care for your wife.
But my daughter only lives 5 minutes from us, and we've already made arrangements if I have to be sequestered, my daughter will take care of my wife.
Okay, that's what my recollection was, that you said you were going to follow up with to send the daughter, and so you were able to.
Yes, my daughter says that'll be fine.
Okay. You said a couple times about your feelings on the death penalty. The penalty fits the crime.
Yes.
Can you tell me what that means, please?
I believe whatever the law dictates for the penalty for that crime, whatever the judge or the Florida law says it should be, then it should be considered for that if that person is found guilty.
Okay. Let me clear up a couple things, right? If you are selected to be a juror in this case, you are going to get a lot of law, more than you probably care to, right? And the judge is going to give you exhaustive directions. But at the end of the day, death is never required in any case, right? It's an individual moral assessment, what your conscience says, and no one can tell you the right or wrong answer. And so I want to talk to you about your feelings. how you might have answered these questions a month ago, before you knew anything about Mr. Loyd's trial. Fair?
Fair.
So in a capital case where the death penalty is a possible penalty, there are two parts if we get to the second part. The first part, the state has the burden of proving Mr. Loyd guilty beyond a reasonable doubt, or we have the burden of proving he's not guilty by reason of insanity. And so if we're in this second part of the trial where you as a juror would be contemplating life or death, you have found him guilty beyond a reasonable doubt of the intentional, premeditated killing of an innocent victim. Does that make sense?
Yes.
Thought about it, he meant to do it, and he did it. No legal justification, excuse, or defense. And so some people say, yeah, I'm still an open book. And some people say, if I hear somebody is guilty of that kind of crime, then really the death penalty is the only appropriate penalty for that type of crime. And so I'm trying to figure out where you fit in there.
I'm still an open book. I would say I like to hear both sides again, because you have the state and the defense, and you have to prove no death penalty, basically, and he's got to prove there was a death penalty. So I want to hear both sides, and like the aggravators, like you said, and the mitigations. Mm-hmm. Yeah. I mean, there might be reasons out there still that he should not receive the death penalty, and he may be life in prison without parole, and that might be his. You prove that he needs life with parole, but I want to hear both sides and make sure that it makes sense, personally even.
Okay.
And
when you say there might be reasons, I just want to make sure we're on the same page. What do you mean by that?
Reasons are like mitigations. Like if you say, like the prosecutor said, racism was a mitigation. Well, how did, you're going to prove that racism was a factor that caused him to do it, or then I don't hear that. And if it was the problem, if that was part of it, and outweighs his, then yes, I would have to, go either way. Okay. So I mean, I would have to hear it. I'd still be an open book on it.
Okay. And that's where, again, I promise you're going to get all of this in writing in much greater detail. In the penalty phase, in the second part, if we get there, the state has to prove the existence of at least one aggravating factor. You have to decide if it's sufficient to warrant the death penalty, if the aggravation outweighs the mitigation, and even then, the last question is death the appropriate penalty? And that's where the answer never is required to be yes in any circumstance. That make sense?
Correct.
Okay, backing up. And I think you can appreciate why I'm asking you this is that I'm going to talk a little bit about the murder of a law enforcement officer, right? And some people say, listen, I hear the law, I want to follow that, I'm an open-minded person, but if I know somebody killed a law enforcement officer in a cold-blooded execution-style murder, standing over top that law enforcement officer, killing her simply because she was a police officer, the only real penalty for me in that scenario is the death penalty. Where do you fall on that?
It's a lot of soul searching. I mean, like I said, I'd have to hear everything and hear the soul search. To be honest with you, I'd probably pray on it. I see where I feel and listen to myself and my values and just go from that area. But I would still try to weigh out the factors that you're presenting. I mean, it's still a person's life. Yes, that person had taken another person's life, but it's my decision to take his life or give him life, but I want to hear the whole factors before I do that, because, I'm assuming any person that, you have to think of your moral self, and then say, oh my gosh, should I do this? But it's soul searching at that point.
Yeah, no, I totally understand. And that's why there is no right or wrong answer. And I wouldn't typically ask you this, but since you mentioned religion, may I ask what your religion is? Okay. My understanding is the Pope has said the death penalty is violating the Catholic Church's teachings. Is that something you believe in, or you don't prescribe to that?
That's my preference. I believe in what the Pope says, but I also know that if I'm chosen for for a civic duty, and it's my civic duty to do something, and if I have to vote for the death penalty, then I also know that I can go to confession and talk to a priest after the fact, and, you know, leave my sin to get reconciled.
Okay. So along the same lines, and I think you know where I'm going with this, is that the judge has told you Mr. Loyd has already been convicted of the murder of Sade Dixon while she was pregnant and the murder of her unborn child.
Yes.
And some people say, knowing he's already been convicted of murder and is serving life in prison for this other murder we're talking about, really death is the only appropriate penalty. Where do you fall in that?
I don't believe that. I believe, you know, I still believe that he's been convicted of a crime. That crime is the past crime. He's being tried for the new crime. He should be weighed against the new crime. Just like if he was a fresh person coming off the street with no other convictions, no other nothing, he still should have the process as everybody else does.
Mm-hmm. And I agree. And the judge has already instructed you whether or not he's guilty of that murder has nothing to do with his guilt. But you are, as Mr. Williams said, allowed to consider that as an aggravating factor. Right? He's been previously convicted of another murder. And so some people just say, hey, listen, if he's already doing life.
If he's already doing life, then it's another sentence is he's going to die in prison. He dies in prison or he gets executed. I'm sorry to say it that way, the death penalty.
No, that's true.
But that's for us to figure out at the penalty phase.
Okay. And then the last sort of series of questions was about the insanity defense. Mm-hmm. And you are a person that, of course, recognizes mental illness to be a valid thing.
Yes.
And really, the judge had asked you initially, could you find somebody not guilty by reason of insanity if the defense had proven the defendant was insane? And some people, again, say, I hear you. I believe mental illness is a real thing, but I am not going to be able to find somebody not guilty if the crime is the murder of a police officer in a cold-blooded execution-style manner. Where do you fall on that?
I still believe mental illness is an illness. And if I back really in the military background, because I've seen people with PTSD, and I know that insanity acts after and can happen. I never knew anybody personally, but you know, when you first get out, you have your transition and we talk to you about different things. But I do believe if it's proven insane, and that's your job to prove that basically, then it's a factor. I mean, it's how I have to think another time to don't know that I even think how, you know, this person is mentally ill, he probably didn't know what he was doing. That's the easiest way to say it.
Right. I mean, that's what overly simplifying insanity is, did not know right from wrong.
Yes.
And you don't have any issue with that, given the nature of the case.
No.
You would not be surprised, I suspect, to learn that people sometimes have differences of opinions on these sort of things, right?
Yes.
And that's totally okay. The law contemplates that, and that's why the judge says, you know, you guys can talk about it, but at the end of the day, only you get to decide.
And that's for you to prove. And that's the whole thing. If you prove it, then it's a factor. If you don't, then it's not a factor.
Right.
That's how you have to think about it, openly.
Yep, and I'm changing topics just a little. So insanity, the state has to prove beyond a reasonable doubt Mr. Loyd's guilt, and then that's first part of the trial. And the second part, same. They have to prove beyond a reasonable doubt the existence of at least one aggravating factor. Insanity is a much lesser standard. It's called clear and convincing evidence. And the same with mitigation in the second part of that trial. It's by the greater weight of the evidence, more likely than not. And so that's why I just want to talk to you a little bit about mitigation generally. It doesn't have to be unanimous. It can be unique to each individual juror, and it can be even something seemingly small, like a smile that one juror observes between a defendant and a family member. And that juror says, you know, I saw that, and I'm going to assign that the weight of life, and I'm not giving a death penalty today. And that's okay. With me?
Yes.
Okay? And that's because death is never required in any circumstances, not the worst conceivable case you can imagine. With me?
Yes.
And if one juror decides that life should be the verdict, then life will be the verdict.
Yes.
Are you okay with that?
Yes.
Sometimes folks can get a little contentious in the back, right? Strong opinions, strong feelings. You would certainly never badger or bully anybody to changing his or her opinion to agree with you.
No, ma'am.
And you would never expect anybody to do that to you.
No, ma'am, because that's their opinion.
Right. And it would be a miscarriage of justice if not all 12 individual moral assessments were reflected in this courtroom on the verdict form. Make sense?
Correct. Yes, ma'am.
All right. May I have just a moment, Your Honor?
Yes, ma'am. Either side need to approach?
No, Your Honor.
All right, sir. We're going to send you through to the last round of questioning. And what that means is a couple of things. First of all, I don't know what the date of that's going to be because I don't have enough people to set a date yet. So we're going to change your color dot. If you'll give the deputy your badge, please. We're going to change you to a purple dot. So I told you there's too many of you for us to call numbers, so we call colors. So now what you're listening for is the date the purple dots are to return. It's unlikely to be this week, but just to be safe, start calling Wednesday afternoon after 5. Okay. And what you're listening for is purple dots return on this date or and time. Like I said, I don't think it's going to be Thursday or Friday, but it might be, so just in case. The day you come back, that is final questioning. We are going to pick the jury that day, and we're going to sequester the jury that day. So you need to have packed your suitcase. Just leave it in your car. If you need it, we'll go get it. If not, no worries. We're giving you a packet that includes a slip with a phone number that you can call to find out when you're supposed to come back. And it's got a sequestration package. It explains a lot more about being sequestered, gives you a suggested list of things to bring. And lastly, we have a letter for your employer telling them that you've been called back for another round. Do you have any questions?
No, ma'am.
Thank you so much for coming in today. We appreciate your time. You're excused for now. We'll see you next time.
Thank you, ma'am.
Thanks. Have a good day. All right, juror in seat number 4, please. He's late? Okay, never mind, skip that one. Juror in seat number 6, please. No, you're right, 4, 19, and 23 are here, but they were late and not instructed, so I've left them to the end.
Yes, please.
Go ahead, sir.
Have a seat, yes, sir.
Good morning, sir. How are you? Just fine, thank you. All right, we have a few questions for you this morning. There aren't any right or wrong answers to these questions, all right? The point of the questions is to try and figure out if you could do your job as a juror in this type of case. And as I told you, set aside your personal feelings, follow the law of the state of Florida. We need to know that, and you need to know that, all right? The only correct answer is the truthful answer. So don't worry about what your answer is, just answer our questions. We're trying to find out what you actually think and feel. Let me start, by asking you, you indicated you had heard something about this case?
Yes.
Can you tell me what you heard?
Well, it was like on news. I heard that he actually shot the officer over at the Walmart.
Okay. Was this back when it first happened? Or
Yes.
did you follow the story since then?
The only thing I know he did shoot her, and the day they caught him over in Carver Shores.
Okay. Did you follow anything about that?
Other than they caught him and he was wounded, I did find that out. But other than that, no.
Is there anything about I'm sorry, were you also talking to friends or neighbors or coworkers about it?
I mean, yes, we spoke, most of the people in the neighborhood do speak about it, yes.
Sure. Do they still talk about it?
Actually, honestly, I haven't heard anybody speak about it. The only time they spoke about it, like you might, when you see it on news, when they say, oh, they figured to have his trial, but other than that, no.
So based on all of that, did you form an opinion as to whether or not Mr. Loyd was guilty?
I did at first.
And what was that opinion?
I did think he was guilty.
Okay. Did you change that opinion?
Well, I used to work corrections, so one thing I did learn was, the streets and the news will give you stuff that's not accurate. So, a lot of times I'm like that. I won't really form an opinion. I'll say, but deep down inside, you're going to ask yourself, is it really true, or is that possible,
Okay. So you have to be able to presume Mr. Loyd is innocent until and if the state can prove he's guilty. Can you do that in this case?
Yes, ma'am.
Okay. Do you have any doubt about your ability to do that?
No.
Even though you originally thought he was guilty?
I don't have any doubt.
Okay. The death penalty. What's your position on the death penalty?
The death penalty to me, I used to say, let me do it like this. I always thought that the death penalty was harsh because I felt like, as a Christian man, you're not giving a person a chance to, if you kill someone in jail, you're not giving them a chance to give their life to God.
Okay.
To ask for forgiveness and give their life to God. But also, in the same time, because of certain family things, I do feel certain people need to get what they get.
Okay. So do you have a religious, moral, or personal objection to the death penalty?
No, honestly, no. I mean, I feel, like I said, if, it's certain things I'm just going to be straight up, you get it because you was wrong.
Okay. So let me ask you about some questions about this case, all right? First of all, to even get to the death penalty, Mr. Loyd has to be convicted of first-degree murder.
Right.
Premeditated, intentionally killing another human being. No legal defense to it. He's been convicted, and it's been proven beyond a reasonable doubt.
Mm-hmm.
That's the requirement to even get to this conversation. So are you someone who believes that if you convict someone of first-degree murder, you're going to vote for death for that person?
Not in every case, no.
Okay. This case involves the death of a law enforcement officer. Are you someone who would that change your answer?
No, it'll still be the same thing. I believe it depends on the circumstances.
Okay. And I told you all about the prior conviction for murder for Ms. Dixon and her unborn child.
Yes.
Would that situation cause you to think, if he gets convicted of first-degree murder, I'm going to sentence him to death?
No, but I thought in that case, I thought he should have, but the jury voted different.
Okay.
So
you thought
I
he should have
can't-
gotten death in that case?
Yes. For the death of the baby, I thought that way.
For the death of the baby?
Right.
Okay. Do you think you can put those feelings aside in this case, or do you think that would be influencing your decisions?
I don't think it influenced my decision. I think, like I said, you have to hear I believe you have to hear all the evidence.
Okay.
The streets and the news, like I said, they're going to say things that they're not going to give you all the evidence, but, without all the evidence, you can't really make a full decision. You can make a decision, but not a full, honest decision.
All right. So you did say that you were a former corrections officer,
Yes.
right? Here in Orange County?
Yes, ma'am.
And when did you retire from that?
No, I didn't try. I left there, and I work with Orange County Parks and Recreation.
Okay, when did you leave?
It was about 20 years ago, because I've been with Parks and Rec about 22 years.
So is there anything, did you know anybody that's involved in this case? Did you know Lieutenant Clayton?
No.
Did you know her family or anyone?
No, ma'am.
Do you know law enforcement officers?
I mean, I know officers, but I'm not like the question was, are you close friends? I'm not close friends, but I do know some officers, yes.
Is the fact that you served as a corrections officer and know some law enforcement officers, do you believe that would influence your decision-making in any way?
I don't think so. I mean, I also work with the police department as a TCS, a traffic control specialist. And I mean, no, I don't think so, because I'm ex-military also. So I try to do it the right way.
All right. You heard me describe the process of deciding whether to vote for death or life. You have to listen to all the evidence. You have to have an open mind about it. You can't sit there and listen saying, yeah, I'll listen, and then I'm going to vote the way I was going to vote to begin with. You have to actually be able to listen to it. Consider it, weigh it out, decide what's important to you, what isn't. If that process led you to believe that life without parole was the appropriate sentence, could you vote for that in this case?
Yes, ma'am.
And same question, could you vote for death if that process led you there?
Yes.
Right, the insanity defense that's been raised by Mr. Loyd, they have to prove it, and that's when you're trying to decide whether he's guilty or not. If you listen to all the evidence in the guilt phase, states and defense, and at the end you were convinced that he was insane at the time, would you be able to return a verdict of not guilty by reason of insanity?
Yes, I could.
And then lastly, can you put the murder of Miss Dixon and her baby aside when you're trying to decide whether he's guilty of these charges? Because they're two separate cases.
Yes, I could do that.
All right, thank you, sir. I don't have any other questions for you. State, you may inquire.
May we approach, Your Honor?
You may. All right, sir. We appreciate your time. I'm sorry. Okay, I haven't forgotten in days. This was the first time. We appreciate your time and attention. This probably isn't the case for you, so I'm going to excuse you as a juror in this case. You have a great day. Thank you.
Ma'am. You too.
Juror in seat number 7, please. Good morning. How are you?
Good.
I have some questions for you, and then the attorneys are going to have some questions for you. There aren't any right or wrong answers to this. The point of these questions is to determine whether or not you can do your job as a juror in these cases, all right? We need to know it, and you need to know it. The only correct answer is the truth. You need to tell us exactly how you feel and what you think. Don't worry about what the answer is, okay? Now, to confirm, you've never heard anything about this case, is that correct?
Yeah, I haven't.
Okay. Do you have a position on the death penalty?
No, not really. I don't really care about it.
Okay. Are you someone who has any kind of religious, moral, or personal objections to death?
I mean, my mom doesn't like it.
Okay. And have you and she talked about it?
Yeah, but I don't really care about it.
What do you mean by I don't care about it?
I mean, I don't like killing people, so I don't think we should kill people.
All right. So you do have an objection to the death penalty, a personal one?
Yeah, I guess so, yeah.
Is your objection so seated that you could never vote for death, regardless of what the law or the facts, the evidence, any of it?
Yeah,
So you would always vote for life?
yeah.
All right, thank you. State.
We move, Your Honor.
Any objection? Sure. All right, this isn't the case for you, but we appreciate you coming in. You're free to go. Thank you. Juror in seat number 11, please. We're still on panel 7, folks. We'll be on panel 7 for the rest of the morning. Actually, for the rest of the day. Good morning, sir. How are you?
Good, ma'am. How are you?
I'm well, thank you. I have some questions for you. I'm going to start, then the lawyers will have a chance to talk to you. There aren't any right or wrong answers to these questions. The point of these questions is to find out whether or not you can do your job as a juror in this case. We need to know, you need to know. The only correct answer is the truth. So just tell us what you actually think and feel, okay?
Yes, ma'am.
Let me start with, you indicated you knew something about this case.
Yes, ma'am.
How much do you know about it?
Not a lot. I try to stay off of social media as much as I can. And TV-wise, I just watch sports most of the time, so.
All right, so tell
Just
me
limited.
what you've, I guess social media, you would have read it. So,
I just kind of saw updates, like, because it's right when I got hired kind of at the fire department, so.
okay.
I remember, I was on Facebook because everybody was congratulating me on my job and stuff, and I remember just like seeing the name. Not really, I don't really care much to click the article or anything because it doesn't really interest me, but
Did you read any of it?
not much, no ma'am. Just
Okay. Do
the
you remember
name sounded
any-
familiar.
Do you remember anything that you read?
Just about finding him, really, is all I remember.
Just about what, I'm sorry?
Capture, like finding him.
Okay. What do you remember about that?
Just like on like the news, breaking news, somebody has been found,
Okay.
really.
Based on what you heard, or also, I'm sorry, did friends and family or coworkers talk about it with you?
No, ma'am, not really.
All right. Based on what you heard, is there anything, did you form an opinion about Mr. Loyd being guilty or not?
I don't know anything really about each side of the story or what happened, so I wouldn't be able to say I formed an opinion.
All right. I noticed that you work for the fire department,
Yes, ma'am.
so I'm going to assume you have a lot of contact with law enforcement.
I do, but not really locally, I would say. I don't even really hang out with any of them that work at my city, but I know some that work in the city where I work. I don't hang out with or off
Okay?
shift hang out with it.
Is there anything about your contact with law enforcement that would impede your ability to be fair and impartial?
Not to my knowledge, no, ma'am.
All right. So let me ask you about the death penalty. You didn't indicate you have any moral or personal or religious objections to it, is that correct?
Yes, ma'am.
How do you feel about the death penalty?
If the crime fits the penalty, I think you need to be open-minded to the decision to, agree to that. I think every case is probably different, so you need to take in consideration all the facts, but if the crime fits, then I think you should consider it.
All right, as I told you, there is no automatic death penalty in the state of Florida.
Right.
Okay? And death is never a required sentence. Jurors don't have to vote for death. You're not required to.
Yes, ma'am.
Death is only a possibility if someone is convicted of first-degree murder. First-degree murder is intentionally killing someone without a defense to it. You had no legal reason, no legal justification, you just killed someone, and you did it intentionally. Follow me so far?
Yes, ma'am.
You cannot even begin discussing the death penalty unless you've convicted someone beyond a reasonable doubt of first-degree murder.
Yes, ma'am.
So are you someone who, if someone is convicted of first-degree murder, you would be thinking that person should get death, having heard nothing else, just they were convicted of first-degree murder?
Oh, that's a tough one. Sorry. I would believe so, but I would also want to get the facts. I mean, if the facts state that that's what happened and that for the death penalty, and I would agree that I would think about option.
Okay, when you're talking about the facts, are you talking about the aggravators or the facts of the?
The aggravators, if they meet the qualifications of the death penalty, then sure, I would think that would meet the qualifications of the death penalty.
All right. So let me change my question a little bit.
Yes, ma'am.
Sitting here right now, having heard no aggravators, no mitigate, nothing, all right? If you convicted someone of first-degree murder, would you be thinking, I'm going to sentence this person to death?
Not all the time, no, ma'am.
All right. Let me add the factor that it's, in this case, it's a law enforcement officer. So if you convicted someone of murdering a law enforcement officer, would you be thinking, I'm voting for death?
Not right away, no, ma'am.
Okay.
Yeah, both sides to each story, so.
Is that a factor you would consider?
Yes,
The
ma'am.
death
I
of a
would-
law enforcement, all
Yes,
right.
ma'am.
Would you be able to, with the death of a law enforcement officer, listen with an open mind to the mitigators? It's all right. Listen. It's all right. It's a nice break in the morning. You ready? Okay. I forgot what I was saying. Would you be able to listen with an open mind to the mitigation in the case?
Yes, ma'am.
And an open mind doesn't mean you're sitting there going, yeah, okay, I'll listen to you, and then I'm going to go vote for death. That's not an open mind.
Right.
An open mind is, I'm listening to what you're saying, I'm really thinking about it, and I'm going to go back there in that jury room and weigh it and weigh the aggravators, figure out what I think is important and isn't, and then vote. Could you go through that process?
Yes, ma'am. I'm a
The
strong-
same question as to the conviction on the prior murder of Ms. Dixon and her unborn child. Is there anything about that that would cause you to think, if I convict him of first-degree murder and he's already been convicted of another one, I'm voting for death? I don't care what else happens.
No, ma'am, I don't even know anything about the first.
Okay. So could you go through that process of listening to the mitigators, the aggravators, and weighing them with an open mind?
Yes, ma'am.
And if it led you to believe that the appropriate sentence in this case was life without parole, could you vote for life without parole?
So that was the appropriate, and I thought that was what I believed to be the best case for this situation, then yes, ma'am.
And same question as to death. If you believe that death was the appropriate sentence, could you vote for death?
Yes, ma'am.
Is there any doubt in your mind about either one of those?
No, ma'am.
The insanity defense, I told you Mr. Lloyd's raised that defense.
Yes, ma'am.
They have to prove it. It's in the guilt phase when you're trying to decide whether he's guilty or not. Burden's on the defense. But let's assume, for purposes of my question, at the end of the guilt phase, they've convinced you. You believe he was insane at the time of the offense. Could you vote not guilty by reason of insanity?
Yes, ma'am.
And lastly, the prior murder of Ms. Dixon and the unborn child. Can you put that aside in deciding whether or not he's guilty of these charges?
Yes, ma'am.
All right, thank you, sir. I don't have any other questions for you, but I'm sure the attorneys do.
Yes, ma'am.
Mr. Williams, you may inquire.
Thank you, Your Honor. Good morning, sir.
Good morning, sir. How are you?
I am well. So because of the, I'm just going to say, somewhat confusing nature of the process, I'm going to go through it step by step. Don't think that I think you're unintelligent and that's why I'm doing this. I want to make sure that I understand your responses in the proper context.
Yes, sir.
Okay? So let's start with the insanity because that is part of the guilt phase. Have you ever personally or someone close to you dealt with the issue of mental health?
I would say I deal with it almost on a weekly, monthly basis with my career. We deal with a lot of issues when it comes to mental health and that aspect.
Does that mean you deal with it personally or you deal with individuals who are having a mental health crisis? Or
I
both?
deal with individuals, myself, no, but I
All right.
deal with individuals that have mental health crises and situations.
So you've seen it up close and close.
Yes, sir.
So do I take your response to mean that you believe mental health issues are real?
Yes, sir.
So given that experience, if it were proven to you beyond a reasonable doubt, if it were proven to you by the defense by clear and convincing evidence, not reasonable doubt, it's clear and convincing evidence, which is a lower standard. If they prove that to you, could you find Mr. Lloyd not guilty by reason of insanity?
If I believed it, he
They
was.
proved it.
Yes, sir.
Even if it meant he wouldn't be responsible for a crime that you believed he committed.
Yes, sir.
So if and only if Mr. Lloyd is convicted of first-degree murder, then we have this larger conversation and evidence about what the sentence should be. And as the judge, I believe, told you, the two punishments for first-degree murder in Florida are life without possibility of parole or death.
Yes, sir.
We would present evidence of aggravating factors, and those are things just like they sound. Things about the nature of the victim or how the crime was committed that make a first-degree murder, this one, above and beyond a first-degree murder that lacks those aggravators.
Yes, sir.
Make sense?
Yes, sir.
So by way of example, one of the aggravators in Florida is that the victim was a child under the age of 12. Can you appreciate why that would be an aggravating factor according to the legislature?
Yes, sir.
Another aggravating factor that's been raised is that the victim in this case was law enforcement. Now, you cannot consider that during the guilt phase of the trial. Does that make sense?
Yes, sir.
But you can and will be, if it's proven beyond a reasonable doubt that she was a law enforcement officer, will be asked to consider it during the penalty phase if necessary. Does that make sense?
Yes, sir.
All right. So we would present evidence of those aggravating factors, and if at least one of them were proven beyond a reasonable doubt, you would go on. And then you would weigh evidence of what are called mitigating circumstances, and that is anything the defense chooses to present evidence of that about Mr. Loyd's life, background, or character, anything at all. And the way the process works that you've alluded to is jurors are obligated to listen and give meaningful consideration to that evidence. Make sense?
Yes, sir.
You decide how important it is, just like you decide how important the aggravators are, but you have to be willing to meaningfully consider it. Can you do that?
Yes, sir.
And more importantly, can you give meaningful consideration to the mitigating circumstances prior to making a decision as to whether death is appropriate?
Yes, sir.
What I'm really asking is, even if you find that the aggravators are proven and that you think they're very important, would you still be willing to consider the mitigation?
Yes, sir.
So again, by way of example, if the defense were to present evidence to you that Mr. Loyd experienced the effects of racism in his life as a mitigating factor, would you be willing to consider that?
Yes, sir.
Or that he had a very difficult childhood or even suffered abuse during his childhood, would you be willing to consider that
Sure. Yes, sir.
prior to making any decision on the death penalty?
Yes, sir.
All right. Anything about that process that, as I've described it to this point, that you don't understand?
No, sir.
If we proved at least one aggravating factor beyond a reasonable doubt, and after listening to the mitigating circumstances, you would weigh the aggravating factors against the mitigating circumstances. And if you individually believe that the aggravating factors outweighed the mitigating circumstances, you would be authorized at that point to vote for a sentence of death. And only authorized if you went through all those steps. Make sense?
Yes, sir.
The law in Florida is that a juror is never required to vote for death. So even if you found the aggravators were proven beyond reasonable doubt, even if you believe that the aggravating factors outweigh the mitigating circumstances, you could still vote for life because that's what you decided to do. Understand?
Yes, sir.
Ultimately, your decision, the final decision, will be based on a reasoned moral judgment. You will have guidance from the law, but it can't take you all the way there. That last step is a decision you have to make.
Yes, sir.
That's the process. I told you it was complicated, and I hope I didn't overcomplicate it, but is there anything about that process that you think you could not go through that you'd have a difficult time going through?
No, sir.
Now that I've described it, and you know that you'll be sequestered if selected, can you tell me on a scale of 1 to 10, 1 being you can't wait to get out of here and do anything but this, 10 being you're excited about the prospect of being a juror, where you fall on a scale of 1 to 10 as to your desire to be a part of this jury?
Probably an average answer is 5.
5, okay. No problem.
Pretty in the middle.
I don't have any other questions. Thank you. Thank you, Your Honor.
Thank you,
Yes,
Mr.
sir.
Williams. No remaining inquiry. Yes, ma'am.
Hello.
Hello, ma'am, how are you?
Oh, I'm great. How are you?
Good.
Someone's laughing at me. I want to back up to the very beginning when the judge asked you what you knew about Mr. Loyd's case.
Yes, ma'am.
And I believe you said, that's what I was just trying to confirm in the transcript, something about being familiar with law enforcement finding him,
Yes,
which
ma'am.
I took to mean Mr. Loyd.
Yes, ma'am.
If you could tell me more about what you know, please.
I just remember it was like a big ordeal, like people, saying, oh, they found him, they finally got him. That's pretty much, I just remember I heard that a lot, they found him, and I don't really pay much attention to the news and try to stay out of all that, so I was like, oh, okay, they found him, but that's about it. That's really all I really kind of knew about it. They found him, and it was a week. Well, judge said it was a week, so around that time, I remember it took a little bit of time.
How about any of the circumstances of Mr. Loyd's arrest? Did you hear anything about that?
No, ma'am. No. I know they found him. It was like a long process, I guess, a process to find him, but I don't know really anything about it, how they found him or what they did to find him or
Okay.
anything along those lines.
Did you see any videos from when he was arrested?
No, ma'am.
Okay. I want to skip to when the judge asked you about if somebody was found guilty of premeditated intentional killing of a law officer.
Yes, ma'am.
And she said, would you be thinking that that was automatically the appropriate penalty, right?
Mm-hmm.
So I want to talk to you just about your, not about the law, how you, juror, feel about this.
Right.
And you answered, that would be a tough one, after some hesitation, right?
I believe I said no, but
Right, but at first when the judge initially said, I want to talk to you about the intentional premeditated killing of an innocent victim, but now I want to talk to you about if that victim were a law enforcement officer.
sure.
And you initially said that would be a tough one to that question. Do you remember saying that?
I do not, but okay.
Okay. Tell me what your feelings are about somebody who is found guilty of the intentional premeditated killing of a law enforcement officer. Thought about it, meant to do it, and did it. And I want to talk to you about in an execution style, standing over the officer, killing her because she is a police officer.
Mm-hmm.
Is that something for you, that death is the automatically appropriate penalty?
If they are found guilty for that and they did that, I would have to consider it, yes, ma'am.
Sure, you would have to consider it. And I think you can appreciate why I'm asking this, right?
Right.
And I promise, there are no right or wrong answers. We're just truly trying to get at how you feel. Is some people say, if I find somebody guilty of that crime, they get the death penalty,
Right.
right? And I just know for myself that I'm not going to be able to consider like the effects of racism on somebody who committed that crime.
Right.
So I want to know how you feel.
Objection asked and answered.
I'll allow him to answer this one question. Go ahead.
You could answer that one.
I'm sorry, can you repeat the question, please?
Sure. So I think you can probably get where I'm going, that some people, if they hear about this type of crime,
Okay.
the execution-style murder of a law enforcement officer in those circumstances, right? That they're going to think death is really the only appropriate penalty for that crime. I don't think I could consider like the effect of racism on somebody who committed that crime. And so I want to know how you feel.
I think there's two sides to every story. You got to know the reason why the person did that, what was going through their head, what led up to that. I think there's a lot of, when you're making a decision about that and a decision about the consequences of an action, I think you have to think about a lot of things that go into that. You can't just take one thing, oh, they did this, this is how I feel, this is no matter what. I think you have to take in consideration of the facts leading up to why the person did what they did and, the thought process behind it. And I know it's premeditated, as in your case you said, but what was the reason for that? What led up to that? What made him think that way? So, I would think you'd have to take in the facts before you can make a judgment call just to say, yep, that's what I feel.
Sure. And I get that. As we sit trying to talk to you like as if you were a human a month before you knew anything about this case. If I just said, hey, how do you feel about somebody in these circumstances? Does that make sense?
Right.
And so in finding somebody guilty of this crime, if you were selected as a juror, you would have rejected the defense of insanity. Make sense? So insanity is a defense to the crime. If somebody is found not guilty by reason of insanity, they're found not guilty.
Right.
You don't even get to this second part. And so you talked a lot about what was going on in somebody's mind when he committed this type of crime, just wanted to do it without defense, excuse, or justification.
And insanity is off the...
Objection.
Sustained. Move on.
I think you can probably get to why we talk about insanity, the defense of insanity, right? Because it is somebody saying, I did this, but I was so mentally ill, diseased, infirmed, or defected, I couldn't decide between right and wrong, essentially. I'm paraphrasing. And some people say, you know, yeah, I understand that. I understand mental health is a real thing, and mental illness can play a role in these things, but I don't think I'm going to be able to find somebody not guilty of the crime of the execution-style murder of a law enforcement officer, even if I hear, by clear and convincing evidence of insanity. Does that make sense?
Yes, ma'am.
Tell me how you feel about that.
Like I said, I deal with it a lot. Mental health issues. I've seen people do things that, you know, you would never think they would do, ever. You'd see them 1 minute, they're talking to you, having a great time. You've seen them 3 weeks before, then they do an action that you're like, what's going on? And they have something wrong, you know, in their head. So I've seen it happen. I mean, I've not quite this, but I've seen situations and incidents happen where people have mental problems, people have health crises where they make decisions or do things and don't really, you know, understand or figure out why they did it.
Have you ever seen anybody like so out of it he or she didn't know where they were?
Oh, yes, ma'am, all the time.
Okay. Let alone what they were doing?
All the time.
Okay. So obviously that's something that you know how you would look for evidence of something like that.
Yes, ma'am.
Okay. You work for the Apopka Fire Department?
Yes, ma'am.
And so fair to say you talked about your city, the fire department in Apopka interacts with the Apopka Police Department.
Sure. Yes, ma'am.
So the question is, you know, why we ask about your role as a firefighter and your interaction with law enforcement is, do you think it would be tough if you found Mr. Loyd not guilty by reason of insanity to go back to the firehouse or to see your colleagues that are law enforcement and say, you know, they're going to know you're gone 3 weeks. So,
Right.
and that, yeah, I found this man not guilty of this crime. Is that going to be hard for you given your background?
Personally, the fire station, it's a brotherhood. It's a second family. No matter what I do, they're going to support me. They're going to, you know, love me. I know it sounds cliche, but it's true.
No, it's not.
We spend a third of our lives together. So no matter what, they know process that, you know, they know if I'm gone for 3 weeks and they know what process I was in. They're not going to judge me, or I've already been through, you know, a lot. They're not going to judge me or come down on me, or, you know, they're going to open me with welcome arms. And it's just the way our fire department is.
How about the second set of that questions? And that's lovely.
Yeah.
I don't want to undermine that. But the second set of that questions is, do you feel pressure if you find Mr. Loyd guilty and you're in this penalty phase because of your background to give him the death penalty?
No, ma'am.
Okay. Knowing that you got to go back to the firehouse and work with the cops and all of those things?
No, ma'am.
Okay. You can appreciate that folks have often differing opinions on these sort of things,
Very much so.
right? Then they're often strong opinions, one way or another. And the law's okay with that. In order for a just verdict to be returned, in this case, all 12 jurors' individual moral assessments have to be reflected on the verdict form. Okay?
Yes, ma'am.
So the foreperson writes down the verdict, but that foreperson's job is really to say that these are the individual moral assessments of all 12 jurors reflected on this form.
Yes, ma'am.
With me? Death is never required, not in any case, not in the worst conceivable case you can imagine. If one juror votes for life, then the verdict will be life. You okay with that?
Yes, ma'am.
All right. We talk about mitigation a lot. It is really why one juror would choose life or not choose death. It can be unique to each individual juror. It does not have to be unanimous. It does not have to be proven beyond a reasonable doubt. And it can be even something seemingly small, like a smile observed between the defendant and a family member. And for that juror says, I assign that the weight of life, and I'm not imposing a death penalty today. And that's okay.
Yes, ma'am.
Are you okay with that?
Yes, ma'am.
Sometimes things can get contentious in the back, right? You're certainly not going to bully or badger anybody to agree with your opinion.
No, ma'am.
I didn't think so. And you wouldn't expect anybody to do that to you.
No, ma'am.
Okay. May I have just a moment, Your Honor?
Yes, ma'am. I'll see the attorneys at the bench.
No questions, I do have a motion.
All right, sir, we're going to send you through to the final round of questioning in this case. We will be picking the jury at the next day that you come in. I don't know what day that is because I don't have enough people to call everyone back yet.
Yes, ma'am.
I strongly suspect it'll be next week.
Okay.
Just in case it's Friday, Thursday or Friday, we're going to give you a packet. You're going to need to start calling in. Don't start before Wednesday, tomorrow after 5.
Okay.
You're listening. I'm changing your color to purple.
Yes, ma'am.
So if you'll give the deputy your badge, they could attach the new dot. So you're listening when you're calling in for the purple group or the purple dots to return.
Yes, ma'am.
That day, we are picking the jury, and we will sequester the jury that day. So you need to pack your suitcase and leave it in your car. If we need it, we'll go get it, all right?
Yes, ma'am.
This package that we're giving you includes the slip that gives you the number to call to find out when you're supposed to come back. It gives you a sequestration package that explains sequestration in more detail, gives you some suggested things to pack and bring with you.
Yes, ma'am.
And there's a letter in there for your employer also. Do you have
Okay.
any questions?
No, ma'am.
All right, thank you so much, sir. We'll see you next time.
Thank you,
You're free to
ma'am.
go today.
Thank you.
I'm sorry, what? Yeah, the real time, I was going to tell you, your real time has stopped. And this is a good time since we're having a glitch. We're going to take a 10-minute break. We'll be back at 11:30, court's in recess. All right, we're back on the record on State versus Loyd. He's present with his attorney, state attorney's office is present. The juror in seat number 4 is downstairs in the jury room. She arrived, I don't want to bring her into this jury room. She was part of the Sade Dixon jury selection. She made it to general voir dire in Sade Dixon's case. State, any objections to her participating in this one?
No, Your Honor.
Defense? It's juror number 4, panel 7, 226.
Seat 4.
Seat 4, yeah. Seat 4, the juror number is 226. She went through general voir dire, so she would have gone through individual questioning in the Sade Dixon case, went into the to general voir dire. I have no idea if she was struck or if we just didn't get to her, because we did not get to all of the jurors in general voir dire. But she has informed us she was part of that. Just staying? All right, that's fine. Okay, she needs to remain. Juror in seat number 13, please. Yeah, you can send those 3 to lunch. 1:15. With the 2 o'clocks. Just, at this point, just put them in with the 2 o'clocks.
Thank you.
Good morning, how are you?
I'm doing well, thank you.
I'm doing well, thank you. All right, we have a few more questions for you. I'm going to start, then the lawyers may have some questions. There aren't any right or wrong answers to these questions. The point of the questions is to find out whether you can do your job as a juror in this case. It's something we need to know, and it's something you need to know. So the only correct answer is the truth, all right? Just tell us what you actually think and feel. Did you, you said you heard something about this case, correct?
That is correct.
Can you tell me what you heard?
I heard, I don't normally watch the news, but I recall just kind of walking by the TV screen and, you know, at the beginning of every news broadcast, there's kind of a cursory, hey, this is what's going to be going on in the program type of thing. And I remember seeing the defendant's face and some comments made about him potentially being involved with some police officer. I didn't really get any other details other than that because it was just kind of the beginning of a news broadcast.
Okay. Was it something that was being, you're a firefighter, correct?
That is correct.
All right. Was it something that was being discussed at the station among everyone?
No, it was at home.
It was at home?
Yes.
Do you recall any discussions with friends, neighbors, coworkers, anything?
No, I do
No?
not.
So other than that one blurb that you saw, do you remember seeing, reading, or hearing anything about this case?
No, I remember seeing the gentleman's face, but I don't,
Okay.
nothing else.
Did you form an opinion as to whether he was guilty or not based on what you saw?
No, I try not to develop opinions based on, I'm sorry.
It's okay, you're not the first one to say it, so.
Don't mean to offend the gentleman on camera.
So you have to be able to presume Mr. Loyd to be innocent until and if the state can prove he's guilty. Do you believe you can do that in this case?
Yes.
All right, so let me talk to you a little bit about the death penalty. So I told you there is no automatic death penalty in the state of Florida. And to even have a conversation about the death penalty, someone has to have been convicted of first-degree murder, meaning a jury has to have found that the state proved someone guilty beyond a reasonable doubt. First-degree murder is premeditated murder, intentionally killing someone without any legal justification for it. Follow me?
Yes.
Okay. Is there anything about that that would cause you to automatically vote for death?
No.
Do you believe that if someone is convicted of first-degree intentional murder, they should be sentenced to death?
With only those cursory details, I can't say should,
Okay.
but
All right.
potentially.
If I add to that the fact that the person in this case who died was a law enforcement officer, would your answer change in any way?
No.
Okay. And if I add to that the fact that Mr. Loyd has been previously convicted of murder, as I told you, Ms. Dixon and the unborn child, would your answer change in any way?
No.
Okay. You heard me describe what the process is in a penalty phase. All right, again, someone's been convicted already, so now it's the penalty phase. State's going to put on aggravators, defense going to put on mitigators. It's your job to go back there and weigh those out. Figure out which ones are important to you, which ones aren't. They may all be important to you. It's up to you. You can talk to your fellow jurors, but in the end, you're going to have to vote. You're going to weigh those out. You've listened to everything at the trial. If that process led you to believe that life was the appropriate sentence without parole, would you be able to vote for that?
Yes.
And if that process led you to believe that death was the appropriate sentence, would you be able to vote for that?
Yes.
Right, the insanity defense, Mr. Loyd has raised it. It's in the guilt phase of the trial where you're trying to determine whether or not he's guilty. The burden's on the defense. So if at the end of the guilt phase, the state's put on all their evidence, defense has put on all their evidence, the defense's evidence convinces you that he was insane at the time this occurred, would you be able to return a verdict of not guilty by reason of insanity?
I believe so.
Okay, do you have any doubt about that?
I've never really even thought about it. I don't think so.
Okay. And then lastly, the previous conviction for murder, can you put that aside in determining whether or not he's guilty in this case? They're two separate cases.
You gave me an order to do so, and I can do so.
All right. Thank you, sir. I don't have any other questions for you. I believe the attorneys do. Mr. Williams, you may inquire.
Thank you, Your Honor. Good morning, sir.
Good morning.
So, given that the process we have, while sensical is a step-by-step process, I'd like to make sure that I go through it with you so that you have proper context for the questions I'm going to ask, okay?
Understood.
I don't think you're dumb. I know you listen to the judge. It's just, I want to make sure that we are on the same page. So,
I've been called worse.
fair enough. So let's start with, because it's related to the guilt phase, when the jury decides whether or not Mr. Loyd committed first-degree murder, the insanity defense. Have you personally or anyone close to you dealt with the issue of mental illness in the past?
Yes.
All right, without telling me too much detail, can you tell me who that person or persons were to you that dealt with that issue?
Brother, father.
Did they actually seek treatment of some sort for that illness?
Yes, sir.
In your view, based upon what you know, did that treatment help?
Yes and no.
Yes and no. Okay. Based upon your personal experience, do you believe that mental illness is real?
Yes, sir.
I ask you that because maybe you know there are members of our community who do not believe that it's real and would even say that it can be used as an excuse. I assume, but if I'm wrong, tell me that you don't fall in that category.
I believe almost anything can be used as an excuse. So, that being said, it's difficult to answer the question with no details
Yes,
based
sir.
on the situation.
So I'll ask a better question. Well, would you agree that you believe mental illness is real, and that because you believe that, you fairly weigh a defense of insanity if it were proven to you?
Absolutely.
Okay, thank you. So if Mr. Loyd were convicted of the first-degree murder of a law enforcement officer in this case, which means that the jury, by the nature of that verdict, would have rejected the insanity defense, then this conversation about what the penalty should be, what the punishment should be, would take place. And it's a separate phase. The jurors would return a short time after the verdict in the guilt phase. And the first thing that would happen is both sides would present evidence. We would present evidence of aggravating factors. The defense, if they wished, would present evidence of mitigating circumstances. Aggravating factors are anything about the crime, the way it was committed, sensitivities of the victim, that the legislature has said aggravate or make more severe this particular first-degree murder above and beyond one that lacks those aggravators. Because it's relevant to the conversation and your ability to be fair and impartial, I will tell you that the death of the murder of a law enforcement officer is an aggravating factor in Florida. Make sense?
Understood.
Right. So you'll be asked to determine whether or not we proved at least one beyond a reasonable doubt. If the jury unanimously finds that at least one aggravating factor has been proven beyond a reasonable doubt, then the next step would be to go forward and weigh and consider the mitigating circumstances that have been proven. And that would be anything about Mr. Loyd's background or life. At the end of, after determining which ones you believe have been proven and what significance, by weight we mean how important you think it is. And you would make that determination both for mitigation and aggravation. Then you would weigh the aggravating factors against the mitigating circumstances. And if and only if you believed that the aggravating factors outweigh the mitigating circumstances, then you, this individual decision that you make, would be authorized to vote to impose a sentence. Make sense?
Yes, sir.
All right. So the key part of this whole process is that you can't skip steps. In other words, does that make sense? I mean, you're a firefighter and I saw a battalion chief. I can imagine that there are things that you all do where the sequence is important. And if you skip around, things get missed and there's a problem. And this is one of those situations. I ask that because there are some people who say that there are certain aggravating factors, certain types of murders where if they hear this type of evidence, they just cannot consider the mitigating circumstances fairly because they are so offended, that's my word, so offended by what happened, that they're not going to be able to consider mitigating circumstances. And you've already been told that the victim in this case is a law enforcement officer. Can you imagine a set of circumstances where the aggravators would be so weighty in your mind that you could not consider the mitigating circumstances?
The simple answer is no, I cannot imagine a reason that I could not consider mitigating circumstances.
Okay. What's a more complicated answer?
I've been told I'm long-winded, so I don't know. No, based on the nature of knowledge itself, I understand that I cannot know everything or understand everything all the time. Therefore, if I'm going to sit here and consider the millions of hypothetical reasons for this or that, it would...
Right. In other words, you can't consider
possibly
the universe of possibilities. Understood.
that number of 2 points.
Yes, sir. I understand what you're saying, and I appreciate you explaining your answer, and I get it, so we're good. Going back to this idea of, are you picking up the distinction between meaningfully considering something and how much weight to give it? you see the difference between those two things in this process?
Please repeat.
Sure. It's one thing, you're going to be asked to meaningfully consider the aggravators and the mitigators. And then you're also going to be asked to give them weight or significance. Do you see the distinction between meaningfully considering something and then deciding how much weight to give it?
Yes, sir.
Is there, if the defense were to present evidence to you that Mr. Loyd had been the victim of racism or had suffered the effects of racism in his life, could you give meaningful consideration to that as a piece of mitigating evidence, regardless of how much weight you gave it, a lot or little, at the second part of that process?
I can absolutely consider that because it is my duty to do so.
Same thing if he had been abused as a child, or any other fact you heard about him, could you consider it as well as give weight?
Yes, sir.
Anything about the process, that lengthy process that I just described to you, you think would provide any problem or present any problem to you going through the process as a juror?
No, sir.
Can you tell me on a scale of 1 to 10, 1 being you really don't want to be here, you're going to run out screaming if you get the opportunity, and 10 being you really want to be here, where you fall on that scale 1 to 10 as to your participation in this trial as a juror?
Well, are you familiar with the ontological work ethic?
No.
Basically, breaking it down to
Simple.
I am in this position, therefore it's my duty
To do what is right, and that is my desire. Therefore, if I am here to act or conduct myself a particular way, then I will do so, and that is my desire. So, how do I numerically rate that?
You don't need to. You've answered my question.
Okay.
Thank you. Is there anything else in your life or background of experiences that you think we should know about you, given that we're trying to select the most fair and impartial jury to hear this important case? By way of example, sometimes people say, several years ago I had a loved one who was murdered, and I went to the trial, and that had a lasting impact on me. Hopefully nothing like that is in your past, and usually there is something that pops into your mind right away. But is there anything like that you think we should know about before I sit down and don't ask any further questions?
No, sir.
Thank you very much. Thank you, Your Honor.
Thank you.
You're welcome.
Mr. Miller, you may inquire.
Good morning.
You were just talking about, if I heard you correctly, ontological processing or theory development?
Deontological. Latin deos meaning God.
Okay. And it is your duty to follow the law as a part of that sort of working theory?
Correct.
Okay. And so this is tough, right? But I want to have a conversation about what your feelings are on these topical areas without thinking, well, I heard the judge tell me the law and it's my duty to follow that law. I want to just know how you feel. Does that make sense?
Absolutely.
You think you can do that? Okay. When you were answering the judge's questions about the defense of not guilty by reason of insanity, and that's what I just wanted to get my notes, and if it had been proven, that defense, could you find a defendant not guilty by reason of insanity? And your answer was, I believe so. Which suggests to me some equivocation, right? It's not a yes or no answer. So tell me what you were thinking when you say, I believe so.
Because without any detail, it's difficult to say, 100%.
Absolutely.
Without details. Not everything in life is
Copy paste, so to speak.
Therefore,
informed decision or an informed yes or no. It's depending on details. And that,
Right. Go ahead, I'm sorry.
No,
I
go ahead.
I appreciate your long-windedness. I have also been accused of the same. So if there's something else that I interrupted, please finish.
no, go ahead.
Okay. The reason we ask, or I ask this question, right, is I think people fundamentally understand the idea of finding somebody not guilty by reason of insanity. That mental health is real, it can affect people, their ability to understand right or wrong. With me?
I'm with you.
But the idea of actually finding someone not guilty, not legally responsible for the crime of first-degree murder, which is the intentional premeditated killing of an innocent victim, and in this case, a law enforcement officer. Right? And so that is what we're asking you, not in a hypothetical scenario, but in a real-life courtroom scenario. And this is my only opportunity to speak with you. And it is our job to find folks that are the right fit for this case, and it's not a value judgment on any particular juror. And so the question is for you, knowing that this case involves the murder of a law enforcement officer in a cold-blooded execution-style way, stood over her and killed her because she was a law enforcement officer, is that something that you could find a defendant not guilty by reason of insanity?
Yes, if the details, in my opinion, prove that.
Okay. And that's what, it is our burden. It's the defense's burden to prove that by clear and convincing evidence. And so you will hear testimony about the defense of insanity. It's a lesser standard than beyond a reasonable doubt. Does that bother you? Should we be held to the same burden as the state?
Doesn't bother me.
Okay. Get one other thing. When Mr. Williams asked you, understanding what this crime entails, the intentional murder of a law enforcement officer in a cold-blooded way and all of those things, right? If there was a scenario or a circumstance that you could contemplate, you wouldn't give meaningful consideration to. Do you remember that question?
Yes.
Yes, your answers were my favorite. So you said the simple answer is no, there's nothing, and there was a more complicated answer, and you said knowledge is infinite. Is there something you were thinking of specifically, though, when you were answering that question?
Well, I believe knowledge itself is not necessarily infinite. However, circumstances that we encounter, I can't possibly think of every potential circumstance sitting here right now. Therefore, you know, I can answer in the positive that, or rather negative, unless I'm getting hungry and not confused.
I follow.
That there would be circumstances that could either, you know, I could go this way or that way.
Sure. And that's sort of the idea of meaningful consideration. Is it something you could hear, contemplate, internalize, and it potentially, it doesn't have to, but potentially compel you or motivate you as to what the appropriate verdict is. And so when you were answering that, though, is there something that was coming to mind specifically that you were thinking I either could or could not consider this?
Mm-mm.
Is that a no? I'm sorry.
No, I was trying to avoid a discussion on natural law and the connection to morality. That's all.
That would be a first in this jury selection process.
Understood.
So, and Mr. Williams discussed with you the effects of racism on the defendant. And again, understanding what we're talking about as far as the crime, cold-blooded murder of a law enforcement officer, the effects of racism, do you believe that is something you could meaningfully consider when deciding what the appropriate penalty is?
Sure.
Okay. You are a battalion commander at the Ocoee Fire Department.
Yes, ma'am. We just got a bunch of great details you remembered from the other day.
Yes, they give us cheat sheets, I'm going to be honest. And so I assume as part of working for the Ocoee Ocoee.
Yep.
You were previously with Longwood. Lots of details.
Yeah, lots of details.
Working for the Ocoee Fire Department, I assume that you have interaction with the law enforcement agencies that service Ocoee. Is that fair?
That is correct.
Do you have friends and colleagues who are law enforcement officers?
It depends on how you define friends. However, I do work with the police department in Ocoee, Orange County Sheriff's Office, FHP. I do not encounter Orlando Police Department, though. I could only tell you, 2 or 3 by name, the officers with the Ocoee Fire Department. I don't work, I don't know them on a personal basis.
Okay.
So,
Well, and understanding, again, you're going to be gone for 3 weeks. And so
sure.
fair to say that your colleagues may know where you are, or at some point learn of the fact, if you are selected, that you were selected as a juror in this case.
I would have to extrapolate because I certainly am not telling anyone.
Oh, no, I know. The judge has instructed everyone, and I have no reason to think. And when the case is done, you can talk about it as little or as much as you want, once it's all over. But again, understanding that at some point you're going to go back to work and your colleagues may say, hey, where were you? Right, and this come up. And so the conversation I want to have with you is, what are your thoughts on going back to work at the fire station with your firefighters and colleagues who are in law enforcement if you were to find Mr. Loyd not guilty? Do you think that that would be difficult given your employment?
I don't believe my employment would make a difference.
Like, do you understand sort of where I'm getting at? Is like, do you think that you would feel pressure knowing that you continue to work with law enforcement and that they're your colleagues to either convict Mr. Loyd or to sentence Mr. Loyd to death?
I don't think so, but almost anything's possible, but I don't think so.
Okay. Your answer suggested a little bit of hesitation. Is there anything beyond just,
No, I'm trying to imagine. Trying to put myself into the future, assuming whatever happens, and in this fictitious, then whatever world that I am now hypothesizing, what everyone's going to think. So it's a difficult question. However, I can't imagine that I would feel any pressure.
okay.
So.
And sort of envisioning yourself deliberating, thinking, if I don't convict this man, I'm going to have to go back to work with all of these cops. And that's where envisioning that scenario, would it affect your deliberation either as to guilt or innocence or to life or death?
Absolutely not.
Okay. You can appreciate that folks often have differing opinions on these subject matters. Fair?
Absolutely.
And that's why the law in Florida, death is never required. Not in any case, not in the worst conceivable case you can imagine. Death is not required, okay? And so that's what Mr. Williams discussed, that process where the state has, if we're in the penalty phase, that second part of the trial, the state has to prove the existence of at least one aggravating factor beyond a reasonable doubt, that it's sufficient to warrant the death penalty, that aggravation outweighs mitigation. And the last question is death the appropriate penalty in this case? And the answer is never required to be yes, right? So you could check yes, 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 and still say, no, I'm not voting for death in this case. Does that make sense?
Yes.
If one juror decides that life should be the verdict, then life will be the verdict. Are you okay with that?
Yes.
We talk a lot about mitigation. It is why any juror would choose life or not choose death. It does not have to be unanimous. It can be unique to each individual juror, and it can be even something seemingly small, like a smile observed between the defendant and a family member, for that juror saying, I saw that, and I assigned the way to life, or I'm not giving the death penalty today because of that, and that's okay. With me?
Absolutely.
I mean, in a philosophical sense, I imagine you understand all this, yes?
Yeah, it's an essential component of our common law system.
Right, and so that's what, in order for a just verdict to be returned in this courtroom, all 12 jurors' individual moral assessments about whether or not Mr. Loyd lives or dies have to be heard in this courtroom. That's your duty, your right, and your responsibility, okay?
Yes.
And that oftentimes folks can get heated or contentious, and you have the right to engage in a deliberation process or engage with other jurors, and you also have the right to say, we're done, right? I've reached an individual moral assessment. And so you certainly aren't going to badger any other jurors to agree with you, correct?
That is correct.
And not going to, you wouldn't expect anybody to do that to you.
Yeah, I have no necessarily any trust that anyone else isn't going to try to, manipulate me. However, I can assure you I will not try to manipulate anyone else.
Okay, and so that's a fair point, that maybe someone would, you can appreciate that if you have reached an individual moral assessment, and it's for life, and that's not being respected, you have the right to say, we're done, deputy, please get the judge, we're going home. Can you do that?
Absolutely.
Can I have just a moment, Your Honor?
Yes, ma'am. All right, either side need to approach?
No, Your Honor.
All right, thank you. All right, sir. We're going to send you through to the final round of questioning. The next time you come, we are going to be picking the jury from that group. I don't know what day it is. I don't have enough people yet to determine that. So a couple of things are going to happen. If you would hand your juror badge to the deputy, we're going to change your color to purple. And what that means is in this package that we're giving you, there's a slip of paper for a phone number that you call to find out when you're supposed to report back. You're now listening for the purple dots to return, okay? Don't start calling before tomorrow after 5. It's unlikely that it'll be this week. It's much more likely it'll be next week, but there's an outside chance it might be Friday. So just call after 5 on Wednesday, then Thursday. Just keep calling till you hear the purple dots are coming back. We're picking the jury that day, which means we're sequestering the jury that day. So when you come back, you need to have packed your suitcase. Just leave it in your vehicle. If you're picked as a juror, we'll go get it for you. If you're not, then not a problem. You just take it back home with you. There's also a sequestration package in there that explains in more detail what it's like to be sequestered, what the rules are, and what we suggest you pack and bring with you. And lastly, there's a letter for your employer to let them know that you're being called back for another day of jury selection. Do you have any questions?
I do not.
All right, thank you so much for your time. Have a great day. You're free to go today. We'll
Thank
see you
you.
next time. Thank you. All right, folks, we're going to break for lunch. Return at 1:15, please. I've sent the other jurors out. Court's in recess. All right, we're back on the record on State versus Loyd. Mr. Loyd's present with his attorney. State Attorney's Office is present. Let's bring in the juror in seat number 14, please. Still on panel 7. Jean, you're in room 1? Room 1? Thank you. I figured that out. Good afternoon, ma'am. How are you?
Good afternoon, Your Honor.
How was your lunch?
It was very nice. It's very nice outside.
It's beautiful out, yeah. Well, welcome back.
Thank
We
you.
have a few more questions for you. Try to relax. I know this is not the most relaxing atmosphere you've ever been in, but there aren't any right or wrong answers to the questions that we're asking you. The questions are meant for us and for you to be able to determine whether or not you can do your job as a juror in this type of case. Right? So that's why you're being asked these questions. There's no wrong answers. There's no right answer. There's just the truth. That's all we want to hear from you. So tell us what you actually think and believe, okay?
Yes, ma'am.
Let me start with, I don't have any notes indicating that you have heard anything about this case.
Correct, I have not.
All right. Has anybody talked to you about it, anything like that?
I think some friends have put some things together, but otherwise I have no details and I've not given details.
When you say they put some things together, what do you mean?
I told my best friend that I was called in for jury duty for a big to-do case, and she thought she knew what it was. I didn't give names. I did not ask for names. So she has her own thoughts of suspicions, but I have not confirmed or denied anything.
Has she said anything to you about Mr. Loyd specifically?
No.
Okay. Jurors have to be able to begin all trials presuming the defendant to be innocent until and if the state can prove they're guilty beyond a reasonable doubt. Do you believe you can do that in this case?
Honestly, I do not.
Okay, tell me why.
I am engaged to a police officer, and it is no fault of the defendant. But my heart bleeds blue, and so I do not feel that I could give him the benefit of the doubt.
Thank you. You've done exactly what I asked you to do, which is be honest. State?
State moved, Your Honor.
Any objections? All right, you're right. This isn't the case for you, so you're free to go. Thank you very much. Have a
Thank
good
you,
day.
Your Honor.
Juror in seat number 16, please. Good afternoon, sir. How are you?
Very good.
Good, thanks. Sir, we're going to be asking you some questions, and I'm going to start, and then the attorneys will have a chance to ask you questions. Let me tell you that there aren't any right or wrong answers to these questions. There's just the truth. We're trying to figure out, by asking you these questions, whether you could do your job as a juror in this case and follow the laws of the state of Florida. And it's something that you also need to know, is whether or not you can do your job. You follow me so far?
Yeah.
Okay. So that's why we're asking you the questions. So just tell us the truth, be honest. Don't worry about what your answer is, okay?
All right.
Let me start with, you don't know anything about this case, is that correct?
Yeah.
Okay. Have you heard anything about the case?
No.
No. Do you watch the news at all?
No.
Okay. Do you have any opinion as to whether or not Mr. Loyd is guilty?
No, because I don't have more information.
Okay. Do you have an opinion about the death penalty?
No.
No? Are you someone who has a religious, moral, or personal belief against the death penalty?
No.
No? Are you a person who believes that in some cases the death penalty is appropriate?
You can repeat the question?
Okay. Do you believe that in some cases the death penalty is appropriate, an appropriate sentence?
No.
No? Okay, so you don't believe that in any case should a person ever be sentenced to death?
Yes, correct.
Okay. Do you believe, actually, I think that's enough. State?
State moves, Your Honor.
Defense? All right, sir. Because of that belief, this isn't the case for you, so I'm going to excuse you. All right? Thank you so much. Have a good day.
Okay, you're welcome.
All right, 17 is not back yet. He's also one of the ones, okay. So we'll skip him. He might, okay, go ahead, see if he's there. He's got a vacation from the 18th to November 1st.
Yes, he's here, Judge.
Okay, bring him in. He has very good timing.
Find something to do.
I'm sorry?
You might be the one that said, I'm going to find something to do, something like that.
Oh, this is the staycation gentleman.
I think maybe.
That's who this is, yes. Oh my God.
Thank you.
Good afternoon, sir. How are you?
Doing all right.
All right, let me start by asking you this. You had told us that you had some time off planned from October 18th to November 1st?
Yes, you are.
And what are the plans that you made for that time?
Excuse me. Just, I never had one. I didn't really make one.
Okay.
But just the time off has been good. You ought to probably find something to do, But,
Okay. So, do you need me to have him take the mask off? Yeah. I can. Sir, can you take off your mask?
Sure.
We're having trouble understanding.
yeah, I know, okay.
These masks make it very difficult to
okay.
understand folks.
Yes, sir.
So, you're just going to go find something to do?
Well, I need to work around my apartment, because I had a problem with somebody taking the place at the job site, so if they finally got it straightened out to where I could take my, they call it pool time at the health center, so they had to straighten out to where I can, good person to come in and use it up.
So if you had to use this time to be a juror in this case, would you lose it completely?
Oh, yeah, I think I would, yeah.
So you couldn't take another vacation unless it was unpaid, correct? Let's say
Right, I think that's a very right.
if you went 2 or 3 weeks without being paid, can you afford to pay your bills?
Well, Your Honor, what I do at the health center, department comes, because I'm a caretaker or a property manager where I am. So a little apartment comes with the job. So I don't pay rent.
Okay. So you could make ends meet if you weren't getting paid?
I figure somebody would get fired.
They can't fire you for being on jury duty.
Okay, well, okay.
Okay. Are you worried that they would try?
I don't know. I doubt it.
Well, let me ask you, have you heard anything about this case?
No, just on I thought I was going to the news one day. I haven't known.
Okay. So do you remember anything on the news about it or anything like that?
No, not really.
Have you formed any opinions as to whether or not Mr. Loyd is guilty?
No, I have no opinion, no.
Do you have an opinion or a position about the death penalty?
Right now, I don't have much knowledge of how to, no.
All right. As I told you, the death penalty in Florida is not automatic for any case. There are cases where it's a possible penalty. The first thing that has to happen before that even becomes a possibility is a jury has to convict someone of first-degree murder, and they have to find them guilty beyond a reasonable doubt. And first-degree murder would be premeditated murder, intentionally killing another person without any legal justification for it. You don't have any legal reason to do it, all right? You follow me so far?
Yes, Your Honor.
So, for purposes of my questions, assume someone's been convicted of first-degree murder, okay? So, if you convicted someone of first-degree murder, intentionally killing someone else, are you someone who believes that that person that killed someone should be sentenced to death? With no other information than what I just gave you.
I couldn't give an answer. I can't give an answer. I don't know.
If the person that was killed was a police officer, would that change your answer?
No.
No? Okay. And so in this case, if you found Mr. Loyd guilty of first-degree murder, would you be open to considering, meaningfully considering, like giving it serious thought, either a life sentence without possibility of parole or a death sentence, depending on what, after you heard all the evidence, what you believed was the appropriate sentence?
Your Honor, I have reading problems and writing problems. I don't read right well. I don't read right well.
Do you think that would make it difficult for you to serve as a juror in this case?
Yes, most definitely.
All right, thank you, sir. State, any objections?
No, Your Honor.
Defense? You may. All right, sir. I appreciate your honesty. You enjoy your vacation. You're free to go.
Thank you, Your Honor.
Thank you.
I sure will.
All right, have a nice day.
Juror in seat number 18, please. Good afternoon, ma'am. How are you?
I'm good. How are you? Good afternoon.
I'm doing well, thank you.
Before
Yes,
I
ma'am.
start, can I mention something real quick?
Yes, ma'am.
Okay. I talked to my supervisor on Sunday, and the first day that I came, I was off, which I basically not familiar with jury duties my first time. So I was asking my company if they pay for it or not. They say they pay partial. They don't pay for the full day. So basically, I cannot afford like the rest of the couple weeks like on because they won't pay me like the full day of work.
All right, so if you serve as a juror for 2 to 3 weeks, will you be paid for those 2 to 3 weeks?
They basically partial not.
All right, and the part that's not being paid, if you don't get that money, can you afford it? Can you pay your bills?
I gotta pay my mortgage by the end of the month.
All right, State?
State moves, Your Honor.
All right, thank you, ma'am. We appreciate you checking. You're free to go.
Sure. Okay, thank you.
I'm skipping 19 because they haven't been instructed yet. Juror in seat 23, please. That's another one that wasn't instructed. Juror in seat 24.
Thank you.
Good afternoon. How are you?
I'm good, and you?
I'm well, thank you. So I have a few questions for you.
Yes, ma'am.
There's no correct answers to this. There's no right or wrong. The only correct answer is the truth. The reason we're asking you these questions is because we need to determine, and you need to know, whether you can do your job as a juror in this case. You know, as I told you, follow the law, set aside your personal beliefs and feelings. We're not looking for a particular answer. It doesn't matter what your answer is as long as you're telling us the truth and it's what you really believe and feel. So let me start with, you said you had some information about this case, is that correct?
Yes, ma'am.
All right, how do you know about the case?
Only thing I know is from the television before I received my jury notice.
All right, how much did you watch on TV?
Only a little bit, only because I listen to it in the morning time before I go to work. When the TV is on, the TV is on.
Okay. Did you hear any conversations, or did you have any conversations with anyone about it? Family, friends, coworkers?
No.
No. How much do you remember of what you heard on TV?
That the trial was coming up. That's what I heard before I received my jury sermon, that the trial was coming up.
Okay. Based on what you heard on television, did you form any opinion about whether or not Mr. Loyd is guilty?
Not at that time, because I'll be honest, it didn't affect me, so I hadn't paid no attention.
Okay. No, there's nothing wrong with that. I mean, so as you sit here today, can you presume Mr. Loyd to be innocent until and if the state proves he's guilty beyond a reasonable doubt?
Well, with that question, I would say he deserves a fair trial. And the only reason why I say that is because I have a child, and I would want him to have a fair trial.
Okay.
The best that he could get.
All right. That's fair answer. All right. So let's move on to the death penalty. Do you have any objections, personal objections, or moral or religious to the death penalty?
No.
Are you someone who believes that if a person is convicted of first-degree murder, which is the intentional killing of another person without any legal defense to it, that person should be sentenced to death? Knowing nothing but what the two things I just said, convicted of first-degree murder. That's it.
Without knowing the facts, it would be hard to come up with an answer.
Okay.
I mean, but I think depends on the crime to me.
All right. So in this case, I mean, in order to get to a penalty phase where you're talking about life or death, someone has to have been convicted by a jury beyond a reasonable doubt of having committed a first-degree murder, intentionally killing another person. If that person was a law enforcement officer, would your answer change as to the death penalty?
Yes.
Okay, what would your answer be if that person was a law enforcement officer?
And it probably would be the death penalty.
Okay. Do you believe that you would be able to listen to any kind of mitigation that was presented by the defense? And when I say listen, you have to have an open mind as to both sentences. and be willing to meaningfully listen to people and the evidence that they present. And then you have to weigh out all those factors. Do you believe that you could do that, or do you believe that upon conviction for first-degree murder of a law enforcement officer, hearing nothing else, you would be, I'm going to vote for death?
I could do my job if I would have to know the facts and do it. I could do my job and put away my feelings and do it.
Okay, so you could put aside your personal feelings about it?
Yes.
Because the law says that, I mean, although that is an aggravating factor, right now, as you sit here today, you have to be willing to listen to both sides and consider both sentences. Can you do that?
Yes, ma'am.
All right. You heard me describe the process to you about weighing aggravators and mitigators, determining which ones are important to you and which ones aren't. You remember all that? Do you believe that you could, with an open mind, weigh the aggravators and mitigators, and if you believe that the appropriate sentence was life without the possibility of parole, could you vote for that?
I could.
If you believe the appropriate sentence was death, could you vote for that?
Yes.
All right. If I add in the factor, remember I told you that that Mr. Loyd's been previously convicted of the murder of Ms. Dixon and her unborn child. Right now, hearing nothing else, are you someone who would be thinking, if I convict him of first-degree murder, he's getting the death penalty?
Let me be honest with you, I really hadn't thought about it.
That's why we ask you these questions. Take a minute, all right?
Not hearing any evidence, I probably would say give him life. But if I had to hear the evidence and knew and followed everything, then I could make up my decision then.
Okay. So, do you have any doubts about your ability to go through the process and listen with an open mind to both the guilt phase and the penalty phase?
No, ma'am.
All right. Guilt phase, all right? That's what I'm talking about now. Mr. Loyd's raised the defense of insanity. Remember I told you that?
Yes.
It's their burden to prove it. But if at the end of the guilt phase, you've heard all the state's evidence, you've heard all the defense's evidence, you were convinced that he was insane at the time of the offense, could you vote not guilty by reason of insanity?
No.
No? Did you say no? I'm
No.
sorry. All right. Can you tell me why?
I mean, even with that, a life was taken, and I guess I would still be thinking that a life was taken, even though it's the insanity plea, and I understand mental health. I do understand that portion, but in the end phase, a life was taken.
All right. Thank you, ma'am. State.
State moved, Your Honor.
Any objections? Yes, ma'am. All right, this probably isn't the case for you, ma'am, but we really appreciate your time and attention and your willingness to serve. You're excused as a juror. Thank you. See the juror in seat 25, please. Good afternoon. How are you?
I'm good. How are you?
I'm well, thank you. I just have a few questions for you, and then the attorneys may have some questions. There are no right or wrong answers to these questions, sir. The only thing we're looking for is for you to tell us the truth. The questions are designed to figure out whether or not you could do your job as a juror in this case. And not only do we need to know that, but you need to know that, all right? So just be honest with us. Let me start with, you indicated to me that you have either a personal, religious, or moral objection to the death penalty. Is that correct?
Yes.
All right, which one is it?
Religious.
All right, what religion are you, sir?
Christianity.
All right, and what is your belief about the death penalty?
I would say that I don't consider it
I don't know if fair is the right word for it,
Okay.
considering it that I will put someone through the same thing that I'm accusing them of,
Okay.
and based on my beliefs as well, it's something that I don't have the right to decide upon someone.
All right. How long have you held this belief?
Since I was a child, I was raised in Christianity.
All right. The law in the state of Florida is that the death penalty, while it's not mandatory, it's not automatic, and nobody has to vote for the death penalty. You have to be able to consider imposing it. Is your religious belief such that you could never even consider imposing a death penalty?
Probably not.
All right. Can you envision any circumstance in which you would consider imposing death?
No.
Thank you. State?
State moves, Your Honor.
Defense? All right, thank you, sir. Not the case for you. You're free to go. Thank you very much. We appreciate your time and attention. Can I see the juror in seat? Yeah, because I want to see the juror in seat number 4 who served on the previous case. All right, thanks. I'm going to talk to the juror in seat number 4 who was in general voir dire for the first trial and see if there's an issue with that. This juror has not been instructed, so I'm just going to talk to them about that issue and then bring them back with the, if they survive that, I'll bring them back with the group to be instructed. So give me number 4, please. Thank you. Good afternoon. How are you?
I'm doing well. How are you?
I'm doing
Can
well.
you hear
Thank
me?
you. I can hear you.
Okay.
Yeah. I'm amazed how many of you remembered to put it to the side. It's the weirdest thing to do, isn't it? It's just
It really
strange.
is.
I have a few questions for you.
Yeah.
And I brought you in because, well, let me tell you, there aren't any right or wrong answers to the questions that you're asked. There's just the truth. That's all we're looking for. We're trying to determine whether or not you could do your job as a juror in this case. And we need to know that, and you need to know that, okay? But a little bird told me that you were in the venire, in the jury panel for the first trial of Mr. Loyd. Is that correct?
That is correct.
Okay. How much do you remember about all that?
I remember quite a bit.
Okay. And so you went through individual voir dire also?
I believe so. I came in a second day for more questioning.
Okay. this may make you laugh, but honestly, ma'am, I don't remember what you were told or not told at that time. That was 2 years ago, but, and I've tried a lot of cases since then. Have you been a juror since then?
I have not sat on a jury before, but I have been summoned, yes.
Okay. Based on the first trial, what you heard, everything that went on in the first trial, have you formed an opinion about whether or not Mr. Loyd is guilty in this case?
Yes, I can.
And what is that opinion?
That verdict is that he would be guilty of his crimes.
Okay. Do you think you could put that opinion aside and presume him to be innocent?
I would not be able to, no.
All right. State.
State moves, Your Honor.
Object. All right. Thank you. I'm excusing you as a juror.
Okay.
All right.
I
Thank you.
appreciate
Have a
it.
good
Thank you.
afternoon.
Thank you. You too.
Well, since I have 10 minutes before the next group, let me have the juror in seat 19, please. She had all kinds of issues, so I'm going to go ahead and talk to her about that. Welcome back. How are you?
I'm doing okay. How are you?
I'm well, thanks. So last time we talked, you were telling me you have 8-year-old twins.
I do.
You have all kinds of things going on. So since then, you've had a little bit of time to think about this. Would you be able to serve as a sequestered juror for 2 to 3 weeks in this case?
It would be difficult to.
Okay, tell me why.
Well, I just can't imagine being away from my family for 3 weeks.
Okay. Beyond that, I mean, I know it would be tough to be away from your family, but you said your husband helps with the children?
He does.
Would he be able to cover all of the child care for those 3 weeks?
He's working on his master's as well. So my mom is in the area, so she can help as well. I believe she has travel plans in November, but she'll probably be able to help us as needed.
Did you ask her?
So I stated to her that I might need her help, and she's, of course, she'll do her best. I didn't ask her when she was leaving. I just know that sometime in November she's planning to leave.
Okay. Have you heard anything about this case?
Very little. Because I have young children, I really don't really watch the news.
Okay. So what have you heard?
I've just heard that he is, I don't even know what's more recent than in the past, but just on trial for murder of his girlfriend, pregnant girlfriend. I don't know if this is the same thing, but police officer. I remember the alert that went out, I believe, summertime.
Okay. And based on what you've heard alone, have you formed any opinions as to whether or not Mr. Loyd is guilty?
I honestly heard very little.
Okay.
So I don't know enough to say, oh, wow, he's guilty or not.
All right. Is there anything, all right, jurors have to be able to listen to the evidence, presuming Mr. Loyd is innocent until and if the state can prove he's guilty. Can you do that in this case?
So, like, I try to stay, I don't even really watch a lot of intense movies. So I would, if I'm chosen, yes.
Are you worried about being picked and what would happen in the trial?
Yes.
You said something about intense movies. What is your concern?
So, yeah, just a lot of details that might make me uncomfortable.
All right, let me ask you some more pointed questions, which is, in cases where the charge is first-degree murder, there are photographs sometimes of a body, blood, that sort of thing. Is that something that you believe you would, no one likes looking at it, okay? That's not the question I'm asking you, but could you look at those photographs and not become overwhelmed by emotion?
Probably not.
And do you think that your emotion would interfere with your ability to be fair and impartial?
No.
No? What do you think the effect would be on you of becoming emotional about those photographs?
I think, well, I mean, I think you'd still hold it together. I just the discomfort level, I suppose.
Okay. Do you have any personal, religious, or moral objections to the death penalty? Is that a no?
No.
Okay. Are you someone who believes that if a person is convicted of first-degree murder, intentionally killing another person without any legal reason to do so, for example, like self-defense, that that person should be sentenced to death?
No.
All right. Here's what I'm going to do with you. I have some lengthy instructions I have to give the next group, then they're coming in at 9. You missed it this morning because you were running a little bit late. So I'm going to send you back into the jury room and bring you back out when they're doing those instructions, and then we'll finish up with your individual questioning. Please don't discuss what we've talked about in the jury room, okay?
Okay.
So we'll bring you back out in a minute. Thank you.
Thank you.
I'm sorry? You got to turn on your mic and tell me what your reasons are.
Sure, I would move to strike that juror for cause. There's several issues in addition to what was discussed today that was previously discussed. She has the 8-year-old twins that obviously presents somewhat of a hardship caring for them. She also discussed previously that she is a teacher and has conferences on the 25th and 26th. In addition, she has clear hesitation and some emotionality talking to the court about more graphic evidence. And not only does this case include the photographic evidence the court discussed, it includes a video of Lieutenant Clayton being shot and killed. And so given all of those circumstances, we're moving to strike juror number 55 for cause.
State.
I don't think there's any record evidence at this point that said she can't be fair. She said she can keep it together as far as the photographs. She indicated the child care issues are not a problem anymore with the assistance of her family members. I don't think she rises to the level of the cause challenge.
She's on the edge here, so I'm going to bring her back in and ask her some more questions. I left out the video part with her because I needed to catch up with the others. So I'm going to bring her in, do the whole instruction with her, and then I'm going to bring her back out first and have a further conversation with her about, well, just all the questions, including the video, because I left that out on purpose because I don't want her going back there getting upset and upsetting the other jurors. So, all right. So she's, at the moment, I'm going to reserve ruling on your cause challenge. All right. All right. You got 5 minutes before we bring the rest of them. Go ahead. Thanks.
You solemnly swear or affirm that you will answer truthfully all questions asked of you as potential jurors upon the law?
All right, have a seat, folks. Is anyone having trouble hearing me or understanding me through this mask? Yeah, okay. All right, I'm removing the mask in order for the jurors to be able to hear me. How about now? Everybody hear me? Okay. Welcome back to day 2 of jury selection. As I told you, this is a capital case, meaning it's a death penalty case, where death is a possible sentence in the case. So we conduct the jury selection in phases. Today's the second phase for you all. We will be asking you individual questions once I finish instructing you as a group. I'm going to give you some more information about this case, give you some instructions about what your job is as jurors. Then we're going to send you back to the jury room and bring you out one at a time to ask you some questions. We will move through this as quickly as we can, but as I'm sure you understand, this is a very serious case, so we have to give it our time and attention. I'm going to start by telling you that what it is that Mr. Loyd is charged with. The information I'm giving you today is for purposes of today's questions. So Mr. Loyd was charged by indictment in this case. This is a copy of the indictment in my hand. An indictment is basically paper that tells someone this is what you're being accused of doing. You need to tell people what you're charging them with doing, what you're accusing them of doing. This is how Florida does it. You cannot use an indictment as evidence of guilt. In other words, the fact that someone's been charged with a crime is not evidence that they committed the crime. And jurors are not allowed to consider that. So in this case, Mr. Loyd is charged with first-degree murder with a firearm of a law enforcement officer, attempted first-degree murder with a firearm of a law enforcement officer, aggravated assault with a deadly weapon, carjacking with a firearm, and possession of a firearm by a convicted felon. The first count, first-degree murder of a law enforcement officer, is what's called the capital count. It is the only count that carries the possible sentence of death if convicted as charged, and I'll get to that in just a second. Let me explain to you how these cases are tried. They're tried in 2 phases. Phase 1 is the guilt phase. The guilt phase of a capital case is the same as every other criminal case, all right? That is the portion of the trial where the jury has to determine whether or not someone is guilty or not guilty. You're going to be asked to return a verdict of guilty or not guilty on all the counts. Your verdict has to be unanimous on all the counts, meaning each juror must agree to the verdict on each count. And the burden of proof on the state in these types of cases is the same as in every other criminal case, which is beyond a reasonable doubt. The instruction that you will be read, the reasonable doubt instruction that you would be read in this case is identical to the one that's read in every other criminal case. The burden is not higher on the state because of the possible penalty. Jurors sit in those chairs that you're in. If you're sworn in as a juror in this case, in the guilt phase, you sit in those chairs and you listen to testimony that comes from this witness stand right next to me, this box. The witnesses sit there. They're placed under oath. The attorneys have the opportunity to examine them and cross-examine them, which means ask questions, ask follow-up questions. That's what that means, all right? You also would be presented probably with some physical evidence, video, photographs, documents. There's physical evidence that's introduced in the case. At the end of all of that, I give you the jury instructions. I give them to you orally and I give them to you in writing. The jury instructions are the law the jury is required to follow in the case. It's not an option. It's the law in the state of Florida and you must be able to follow it. The jury determines the facts. I tell you what the law is. You apply the facts to the law and you reach a verdict. That's how that works in the guilt phase. So what we're asking you to do is listen to all of that and then determine whether or not the state has proved beyond a reasonable doubt that the defendant is guilty or not guilty on the charges, including first-degree murder, on their own merits. You have to consider each charge. and you will be told to disregard the possible consequences of your verdict. The only question you are to answer during the guilt phase is whether the defendant is guilty of murder in the first degree, as well as any of the other offenses charged, or guilty of a lesser included offense, or not guilty. We expect you to carefully consider the facts before you reach a decision, and the fact that a defendant might face a death penalty is to play no part at that stage of the proceedings. Now, if and only if the jury returns a verdict of guilty of murder in the first degree, then you reconvene for the purposes of deciding a verdict as to the sentence, either life in prison without the possibility of parole or death. That second phase is referred to as the penalty phase. Most of the questions we'll be asking you today will be about that penalty phase. So I'm not going to give you the detailed instructions. There are detailed instructions and rules that I would give you if a penalty phase was reached in this case. But today I'm just going to give you a broad overview. Murder in the first degree is the only class of crime for which death is a possible penalty. The automatic sentence in Florida for murder in the first degree is life without the possibility of parole, which means exactly what it sounds like. The defendant will die in prison. Florida does not have parole. It doesn't exist in this state for life, for first degree murder. The legislature has created special rules for juries to consider in reaching a verdict in a penalty phase, right? The legislature recognizes that not all first-degree murder cases deserve the death penalty, so they created a list of circumstances which juries are to consider in reaching a verdict in a penalty phase case. The circumstances are referred to as aggravators. The state has to prove at least one aggravator beyond a reasonable doubt for death to be a possible sentence in a first-degree murder case. There are 16 statutory aggravators. They have to prove at least one. A jury must unanimously find that they have proven at least one before death becomes a possible sentence. The defense in the penalty phase, all right, so the state in the penalty phase would put on their evidence of the aggravators. Then the defense would put on their evidence of what are called mitigators or mitigating circumstances. Mitigating circumstances do not need to be proved beyond a reasonable doubt. A mitigating circumstance need only be proved by the greater weight of the evidence. It's a lesser burden. Mitigating circumstances are not limited by statute and may include matters that are relevant to the defendant's background or character or circumstances surrounding the offense. They're offered as a basis for a verdict of a sentence of life in prison without parole. Before you may vote to the court impose a sentence of death, the state must prove one or more aggravating factors beyond a reasonable doubt. So you're in the penalty phase, you listen to the state's aggravators, the defense's mitigators. I give you the jury instructions. Again, the law that has to be followed at this stage. Then you're going to go back in that jury room with the same jury room you've been sitting in all this whole time, but with your fellow jurors. You're going to go through a process known as weighing the aggravators and the mitigators. That is not a mechanical or mathematical process. You're not going back there to count and say, well, I think this many aggravators were proved and this many mitigators, so this side wins. That's not how that works. Weighing aggravators and mitigators is a process each juror must go through individually. You're welcome to discuss this as a group. We don't dictate how you do this, but you're welcome to discuss it as a group. But each juror gets to weigh these individually. So one juror may decide that this aggravator is very important to them, but they don't care about another one, or they may decide that this mitigator is critical to their decision. You may decide you don't believe anything or everything. Some of them may be less important to you. It's truly up to you individually. But you have to weigh all of those aggravators as part of your decision-making process. And you alone individually decide what weight to give to each of these factors and aggravators and mitigators. Regardless of your findings in this respect, you are never compelled nor required to vote for a sentence of death. But once you've gone through that whole process, the final phase in this step of the trial is for each of you to determine whether the defendant should be sentenced to life in prison without the possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. In other words, for the court to impose a sentence of death, all of the jurors must agree that death is the appropriate sentence and vote for it. It has to be a unanimous vote. The vote for life does not have to be unanimous. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility of parole. Again, that is a broad outline of what happens in the penalty phase. I know this is a lot of information. It can be a little bit confusing. We'll explain it more as we go along. Let me say something else. The fact that I'm talking about the death penalty is not to be taken by any of you as an indication one way or another as to whether or not this is a case that justifies a death penalty. I don't know that, and you don't know that. We're only discussing this because it's a possibility, and we need to determine whether or not, if you were called to make this kind of way, to go through this process, this penalty phase, you are able to comply with what you need to comply with and follow the law and your oath as jurors. We're going to be asking you some questions about the death penalty in this process. I'm going to tell you what some of them are now to give you a time to think about it while you're in the jury room waiting, because honestly, folks, some of this you may never have thought about. So we're going to ask you about your position on the death penalty, whether you're someone who is so opposed to death that you could never impose it for any reason at all, or whether you're someone who thinks death should be an automatic sentence if someone is convicted of first-degree murder. The law in the state of Florida says there is no automatic sentence for death in Florida. Jurors must be willing to consider both life and death openly, fairly, and honestly. You're going to be asked about whether you can go through that process I just described with an open mind, whether you can listen to both sides, not make a decision until you've weighed it all out and gone through the process that we've discussed with you. A lot of people have strong feelings about the death penalty, both for and against. Those feelings in and of themselves do not disqualify you as a juror if you can set your personal feelings aside and follow the law as I instruct you. In other words, you have to be willing to be bound by your oath as jurors to obey the laws of the state of Florida in delivering a sentencing verdict. Switching gears slightly, Mr. Loyd has raised the defense of insanity in this case, which is insane at the time of the offense. So there's a long jury instruction about this, which is read to jurors. I'm not going to read that to you. You don't need that for today. I'm going to tell you what the definition is of insanity, because we are going to be asking you questions about this defense. A person is considered to be insane when he had a mental infirmity, disease, or defect, and because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. Now, the defense of insanity has to be, this is in the guilt phase when you're trying to decide whether or not he's guilty of the charges against him. This is the one time the defense has a burden of proof. They have to prove insanity by what's called clear and convincing evidence. So the questions about insanity are going to be about whether you can accept this type of a defense and you can listen to the evidence with an open mind. So you need to think about that. And then lastly, I'm going to read you a statement about this case, and I'm going to have some instructions and some questions about it. On the morning of January 9, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide, when it is alleged that Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. That last paragraph I just read to you about Ms. Dixon, that information cannot be used by you to determine whether or not Mr. Loyd is guilty in this case. I will be explaining to you individually what you can use that information for, but you have to be able to set that aside in determining whether or not he's guilty of the charges he's facing now. It's two different cases. So let me ask you a couple of questions as a group. I need you to raise your paddles in response to this, please. How many of you have heard about this case prior to coming to jury duty? Well, it'd be easier to just ask, is there anyone who hasn't heard about the case? Okay, so not heard, I'm sorry, I didn't see yours. Keep your paddles up till I call your number. 51, 60, and from panel number 8, juror number 4. Okay, thank you. Of those of you who've heard about the case, how many of you have formed an opinion as to Mr. Loyd's guilt? Raise your paddles. All right, when I call your number out, you can put it down. 29, 30, 31, 35, 37, 44, 45. From panel number 6, I have juror number 20. No, it's panel number 7. Yeah, I have juror number 23. All right, thank you. 57, 58. From panel number 8, I have 2 and 38. Did I miss anybody? All right. Is there anyone on this panel who has a religious, moral, or personal objection to the death penalty that would lead to you not being able to impose death regardless of what the law is? You would not even consider a death sentence. Anyone on this panel that falls into that one? Juror number 45 and 34. All right, so 34 and 45. Anybody else I missed? And then is there anyone on this panel who believes that if you're convicted of first-degree murder, you would automatically impose death? Jurors number 29, 31, 37, and 44. Okay, folks, thank you very much. We're going to be calling you back out independently. Don't talk about the case. Make yourself some coffee. Juror number 4, if you'll, not 4, sorry. Number 19, if you'll stay in the courtroom, please. Thank you. Okay, you're back in the hot seat. All right, so now you've heard a lot more about the case with the instructions and everything. Do you have any, you expressed some concerns about sitting on this case. Now that you've heard all of that, have any of your answers changed?
I'm going to go with yes, I have formed an opinion that he is guilty.
Okay. And what caused you to form that opinion?
Just reflecting on it a little bit more.
Okay. As I told you, you have to be able to presume Mr. Loyd's innocent in order to sit on this jury. Do you believe that you can do that? Remember what I told you, the answer, give me the truth.
No.
Okay, State.
State moves, Your Honor.
All right, thank you, ma'am. You're free to go. Juror in seat number 23, please. I'm going to go through all the obvious, well, on its face, obvious cause challenges, and then I'll leave the remainder for later. Good afternoon. How are you?
I'm well. How about yourself, Judge?
I'm doing well, thank you. Sir, I'm going to be asking you some questions. There aren't any right or wrong answers to these questions. They're being asked to determine whether or not you could do your job as a juror in this type of case. We need to know it. You need to know it. The only correct answer is the truth. Okay? So, you said that you had heard about the case and that you formed an opinion about the case. Is that correct?
Yes, ma'am.
Can you tell me what the opinion is that you have?
Based on the news coverage that I've seen, I feel that Mr. Loyd is guilty.
All right. Jurors have to be able to start the trial assuming Mr. Loyd is innocent until and if the state can prove him to be guilty. Do you believe that you can do that or not?
At this point, I do not.
All right. State?
State moves.
Thank you, sir. You are free to go. Appreciate your service.
Thank you.
Juror in seat 29, please. Good afternoon. How are you?
Good. No, I don't know.
It's a little strange being in this situation, I'm sure.
Yes, I was in Pine Hills that day, and I was under, like, lockdown when the roads were closed, so it's been like a rough weekend.
Your voice is shaking and you're near tears.
Yeah.
Let me just get
All
to
weekend.
it. Have you formed an opinion
Yes.
as to Mr. Loyd's guilt? What is it?
Guilty and death penalty.
Okay. State?
State moves, Your Honor.
All right, this isn't the case for you. Good luck to
I'm
you.
sorry.
You're free to
Sorry,
go.
I
You
couldn't
don't need to
use better
apologize.
judgment. Thank you.
Have a good day.
Yeah.
Juror in seat number 30.
Do I need to stand? Or?
Good afternoon, ma'am. How are you?
I'm fine. How are you?
I'm fine, thank you. Just have a few questions for you. Aren't
Yes,
any
ma'am.
right or wrong answers.
Yes, ma'am.
We're trying to find out whether you could do your job as a juror in this case. We
Okay.
need to know, you need to know.
Right.
The only correct answer is the truth.
Yes,
okay?
ma'am.
So you know about this case, correct?
I do.
And you formed an opinion as to Mr. Loyd's
I
guilt?
have, yes.
Can you tell me what that is, ma'am?
From what I saw 3 years ago, or almost 4 years ago, I believed he was guilty.
All right. Jurors have to start the trial believing or being able to presume Mr. Loyd to be innocent until he's proven guilty.
Right.
Do you believe you could do that? Or would you start the trial believing he was guilty?
It would be very difficult. I'm not going to lie.
And remember what I told you, the only correct answer is the truth.
Yes, ma'am.
So if you can't presume him innocent, you just need to tell me that.
I would like to believe that if I was in his shoes, I would be able to have others to do that for me. So I would do my best.
But you're not sure you can do it?
I'm not.
All right, I'm going to give you 3 scenarios. You start the trial, you're a juror, okay? You're sitting in the jury box and you're thinking, I think this guy's guilty, but I'm willing to see if he can prove otherwise. I think this guy's innocent and the state needs to prove he's guilty. Or maybe, he's probably guilty, but I'm willing to see what he says. Which one are you?
Probably the first.
All right. Thank you, ma'am. State?
State moves.
Any objection? All right. Thank you, ma'am. This isn't the case for you. Have a good afternoon. You're free to go. Juror in seat 31. Good afternoon. How are you?
Well, yourself?
I'm doing well, thank you. Sir, I'm going to be asking you some questions. There are no right or wrong answers to my questions. There's only the truth. The questions are meant to determine whether or not you can do your job as a juror. We need to know it. You need to know it. So just answer the question truthfully, okay?
Yes, ma'am.
Let me start with, you indicated you know something about this case. Is that correct?
That's correct, yes.
And that you formed an opinion as to whether or not Mr. Loyd is guilty.
That's correct, yes.
What is your opinion?
Guilty.
Right. Jurors must begin this trial presuming Mr. Loyd to be innocent until and if the state can prove him to be guilty. Do you believe that you can do that, or would you begin the trial believing him to be guilty?
I will not be able to do that now.
All right. State?
State moves.
All right. Thank you, sir. You are free to go.
Thank you.
Juror in seat 35. Good afternoon. How are you? Okay. I have a few questions for you. There aren't any correct answers, or there's no right or wrong answers. There's a correct answer, and that's the truth. All right? The questions are being asked of you to determine whether or not you can do your job as a juror in this type of case. We need to know, and you need to know. All right? So just tell us the truth. Let me start with, you said that you've heard about this case. Is that correct?
That is correct.
And that you have formed an opinion as to whether or not Mr. Loyd is guilty. Is that correct?
That is correct.
What is the opinion?
That he's guilty.
All right. Jurors must begin this trial being able to presume him to be innocent until and if the state proves he's guilty. Do you believe you could do that?
Not from what I read in the newspaper articles and heard on. I followed this case in the newspaper articles when it was unfolding.
Thank you. State.
State moves.
All right, sir, this isn't the case for you. Thank you very much. You are free to go.
I thank you.
Juror in seat number 37. Good afternoon, sir. How are you?
Doing good.
All right, I have a few questions for you. There are no right or wrong answers to these questions. The only correct answer is the truth. We're asking you the questions to determine whether or not you can do your job as a juror in this case. We need to know that, and you need to know that. Okay, so just tell us what the truth. So let me start with, you indicated that you know about this case. Is that correct?
Yes.
And that you have formed an opinion as to Mr. Loyd's guilt. Is that correct?
From what I've seen,
And what is your opinion?
that he's guilty.
All right. Jurors have to be able to start a trial presuming that a defendant is innocent until and if the state proves he's guilty. Can you do that in this case, or would you start presuming he's guilty?
Right now, I'm presuming he's guilty.
All right. Thank you, sir. State?
State moves.
Defense? All right, sir. This isn't the case for you. Thank you very much. You're free to go. You got, that's all right. Juror in seat number 44. Good afternoon. How are you?
I'm good. How are you?
I'm fine, thank you. I know this can be a little intimidating and nerve-wracking. Try to relax, okay? I'm going to be asking you some questions. You okay? You're tearing up. What's wrong?
I just feel very uncomfortable being in the same room. I'm sorry.
Being in the same room with us or with Mr. Loyd?
Mr. Loyd.
Okay. Any objections?
No, Your Honor.
All right, ma'am, you're free to go. Thank you very much.
I'm sorry.
It's all right. No need to apologize. Juror in seat number 45. Good afternoon, sir. How are you?
Pretty good.
All right, I have a few questions for you.
Okay.
There aren't any right or wrong answers. The only correct answer is the truth, all right? The questions that we're asking you are meant to determine whether or not you can do your job as a juror in this case. It's something we need to know, and it's something you need to know. So just tell us the truth, okay?
Okay.
You indicated that you knew something about Mr. Loyd's case, is that correct?
Yes.
And that you had formed an opinion as to guilt, is that correct?
Yes, from the news coverage, yes.
What is your opinion, sir?
That he's guilty.
Jurors must begin this case believing Mr. Loyd to be innocent until and if the state can prove him guilty, or presuming him to be innocent until the state can prove him guilty beyond a reasonable doubt. Can you do that in this case, or would you start the case assuming he was guilty?
I would start the case assuming he's guilty.
All right, thank you, sir. I asked you to tell me the truth. State.
State moves.
All right, sir, thank you very much. You're free to go. Juror in seat 57.
Thank you.
Good afternoon, sir. How are you?
Good afternoon, ma'am.
I have a few questions for you.
Yes, ma'am.
There aren't any right or wrong answers to these questions.
Okay.
The correct answer is the truth.
That's
okay?
correct. Yes, ma'am.
We're asking you the questions to determine whether or not you're able to do your job as a juror in this case. It's something that we need to know and something you need to know. So just tell us the truth. All right?
Okay.
You indicated to me that you'd heard something about this case. Is that correct?
That is correct.
And that you had formed an opinion as to Mr. Loyd's guilt. Is that correct?
Yes, ma'am.
And can you tell me what that opinion is, please?
Yes, ma'am. Just to give you the background, I look at the news continuously. That was part of my profession, knowing what's going on locally and internationally. So that's just a part of my routine every day.
Okay.
So from various stations, I've heard, seen, and the results. So yes, ma'am, I believe that he in fact did do it, and he. What's the question again?
Guilty?
Yes, ma'am.
All right. In order to sit as a juror in any criminal case, actually, you have to be able to presume the defendant to be innocent until the state proves they're guilty beyond a reasonable doubt. Do you believe you can do that in this case, or would you start the trial believing Mr. Loyd to be guilty?
Ma'am, honestly, I could not. I could not do that. I cannot.
So you can't presume him to be innocent?
That's correct.
All right. Thank you, sir. State.
State moves.
Thank you, sir. You're free to go. Juror in seat 58. Good afternoon. How are you?
Hey, can you hear me?
All right, sir. I'm doing well, thank you. I have a couple of questions for you. There aren't any right or wrong answers to these questions. The only correct answer is the truth. We're not looking for a specific answer. The reason we're asking you these questions is to determine whether or not you can do your job as a juror in this type of case. It's something we need to know, and it's something you need to know. So just tell us the truth. You indicated to me that you know something about this case prior to this being called to court. Is that correct?
Yes.
And that you had formed an opinion as to Mr. Lloyd's guilt or innocence. Is that correct?
Not necessarily. I just, going by the news.
Okay. So did you form an opinion?
Not really. I mean, it's facts are facts. You know what I'm saying?
What do you mean by facts or facts?
I don't know what you see on the news, whether it's true or not. Media,
Okay, because when I asked, have you formed an opinion, you raised your paddle.
Yeah, after I did it, I said, maybe I shouldn't have done that.
Well, I mean, if you formed an opinion, you formed an opinion.
No, not really.
All right, so I'm going to give you 3 scenarios, and you tell me if any of these apply to you. Okay. Scenario number 1, and assume you've been selected as a juror. It's the first day of the trial. You haven't heard a word of evidence, right? You're just sitting there waiting for it to start. Are you sitting there thinking, I think this man is innocent, and I'm going to wait and see if the state can prove to me that he's guilty beyond a reasonable doubt? That's number 1. Number 2, yeah, I think this guy's probably guilty, but I'm willing to listen and see if I'm wrong. And 3, this guy's guilty, but if he can convince me otherwise, I'll listen.
Number 2.
Number 2? All right, State.
State moves.
All right, thank you, sir. You are free to go. This isn't the case for you. You're done, unless you really want to stay here all afternoon.
Hang out.
All right, thank you. See you. All right, from panel number 8, I need the juror in seat number 2, please. We'll be back to 7 in a minute. Good afternoon, sir. How are you?
Doing well.
All right. Welcome back. We have a few questions for you this afternoon. There aren't any right or wrong answers to these questions. The questions are designed to find out whether or not you could do your job as a juror in this case. We need to know that, and you need to know that. The only correct answer is the truth. You need to tell us what you actually think and feel. You indicated to me that you knew something about this case. Is that correct?
Yes.
And that you had formed an opinion as to whether or not Mr. Lloyd is guilty. Is that correct?
Yes.
And what is that opinion?
I believe he's guilty.
All right. Jurors must be able to start trials presuming someone to be innocent until and if the state proves they're guilty. Would you be able to do that in Mr. Lloyd's case, or would you start the trial thinking he was guilty?
Honestly, I would try, but I don't think I could do it.
All right. Thank you, sir.
State moves.
All right. Thank you. All right, sir, you're free to go. Thank you very much. We appreciate your service. Juror in seat 38. This is still panel 8. Good afternoon, sir. How are you?
Good. How are you today?
I'm doing well, thank you. I have a few questions for you. No right or wrong answers to these questions. The point of the questions is to find out whether or not you can do your job as a juror in this type of case. We need to know that. You need to know that. So the only correct answer is the truth. Just be honest, all right? You indicated to me that you'd heard about this case. Is that correct? And that you had formed an opinion as to whether or not Mr. Lloyd was guilty. Is that correct? Okay, so tell me what your opinion is right now as to whether he's guilty or not, without hearing anything else, just based on what you saw. Okay, so in order to be able to sit as a juror in these cases, you have to presume someone to be innocent until and if the state can prove they're guilty. Can you do that, or would you start the trial thinking, this guy's guilty?
No, I would not.
All right, so I'm going to give you 3 scenarios. You tell me if any one of these applies to you. Scenario number 1, it's the first day of the trial, you haven't heard a thing, you're just sitting there waiting for us to start. Are you thinking, okay, this man is innocent until and if the state proves to me he's guilty? That's number 1. Number 2, I think this guy's probably guilty, but I'm willing to sit here and listen and see if I'm right. Number 3, I think this guy's guilty, but I'll listen and see if he can prove to me he's not. Do any of those 3 apply to you?
First one.
The first one, you can presume he's innocent? Okay. Tell me how much information you have about this case or heard about this case.
Happened, I think a lot.
Okay. Now, I'm going to need more details from you. So tell me what you heard that you remember.
I remember abandoned house or something. I think that's where they ended up finding him. And I knew somebody got shot at the...
You need to get that mic closer to your mouth. Sorry. Yeah.
At the Walmart.
Okay. Was this something that you were talking about with family and friends?
I'm sure my wife and I had probably...
Okay.
But I can't...
Do you remember talking about with coworkers or hearing about it from other people? Anything like that?
Not really.
No? Okay. Did you follow the case over the years or just then? When's the last time you saw, heard, or read anything about this case? Okay. All right, so let me ask you about the death penalty. Do you have a position on the death penalty? Okay. Most people don't think about this until they're called into one of these cases and we talk to them about it. Let me start at the beginning. As I told you, in order for a discussion of the death penalty to even occur, someone has to have been convicted of first-degree murder, intentionally killing another person with no legal justification. You with me so far? And that finding has to be made beyond a reasonable doubt.
Correct.
Okay. So, are you someone who, if you find someone guilty of first-degree murder beyond a reasonable doubt, you would be thinking, I'm giving that person the death penalty, that's what they deserve?
I would take it very...
No, but my question is that the sentence that you, in your mind, without hearing anything else, you would say, first-degree murder, you should get death? Okay. If I add to that that the person who died was a law enforcement officer, does your answer change?
My answer, I thought about this, my answer would be, was and a wife, a police officer, it wouldn't, I don't think the fact that it was a police officer is a deciding factor for me.
All right. You heard me tell you that Mr. Loyd has previously been convicted of the murder of Miss Dixon and her unborn child. She was pregnant at the time.
Correct.
And serving life for that.
Correct.
Conviction for first-degree murder and a prior murder. Would you be done listening and you're thinking death is the appropriate sentence? You don't know anything else?
Do I know that he killed her? I know he killed his pregnant girlfriend and...
Yes, ma'am. Yes, sir.
And he
Sorry.
killed a policeman.
It's been a long week. Yes, sir.
I would probably say he's guilty, yeah. I mean, what's the question again?
Would you, not hearing any mitigation or anything, be thinking, if I convict you of this, you're getting the death penalty? That's what I'm voting for. All right. So the rules are these. Let me go over them with you one more time. If you get to a penalty phase, the state's going to put on aggravators. Reasons they believe you should vote for death. Defense is going to put on mitigation. Reasons they believe you should vote for life. You have to be able to sit there, even though someone's been convicted of first-degree murder, you have to be able to sit there and honestly and fairly listen to both sides. It's not listening going, okay, I'm listening until I can get to vote for what I was going to vote for anyway. It's honestly and fairly listen to both sides, listen to that evidence, then go back in that jury room and weigh it. You can assign whatever weight you want to aggravators and mitigators. It's personal for each person. It can be important to you or not important to you at all. And then once you've weighed everything, thought about everything, then you vote either life or death. So my question number one is, can you sit there with an open mind, listen to both sides' presentation in a penalty phase?
Yes.
And can you weigh those aggravators and mitigators, and if you believe the sentence should be life without parole, could you vote for life without parole? If you believe the sentence should be death, could you vote for that?
Absolutely.
Mr. Lloyd's raised the defense of insanity. That, as I told you, is in the guilt phase. When you're trying to decide whether he's guilty or not, they have to prove it. The defense has to prove it. If at the end of the guilt phase, you've heard all the state's evidence, you've heard the defense's evidence, you believe he was insane at the time, would you be able to return a verdict of not guilty by reason of insanity?
If I felt like he was insane by what the instructions you gave me or the definition, I could do either way.
Okay. And then last question, the murder of Ms. Dixon and her unborn child cannot be considered by you as part of determining whether or not Mr. Lloyd is guilty of these charges. It's a separate case. Can you put that out of your mind in the guilt phase?
As well as anybody could, yes.
Okay. Thank you, sir. State, you may inquire.
Thank you, Your Honor.
Good afternoon, sir.
Good afternoon.
When you first started talking with the judge about the information you received from the media, you mentioned something about an abandoned house.
Correct.
What do you remember about that?
I think they were looking for him for a while, and they found him in an abandoned house. I believe it was near Silver Star. I couldn't tell you any more than that.
Okay. You remember any of the circumstances surrounding how they found him or what went on, or just that he was found at this place and you kind of moved on?
Really, just the first part, that they found him there, and that's where they captured him.
Okay. I want to start with a couple questions about insanity. And that is something that would be an issue in the guilt phase of this case, whether or not he committed the crimes that he's accused of committing. Because insanity involves a mental health issue, questions about your experience with mental health issues. Have either you or a close friend or a family member dealt with any kind of mental health issues in your life?
No.
Some people in society are of the opinion that mental health issues are not real, they're kind of bogus. Other people obviously don't think like that. What are your thoughts about it? Are mental health issues real in your opinion to some people in society?
I think that some are. I think that most mental health issues are probably drug-related, is my opinion, but that's all I know.
Would you be able to hold off judgment about whether a mental health issue exists in this case, and if so, what the ramifications are, until you hear all the evidence surrounding the insanity defense?
Can you repeat that one more time?
Sure. Would you be able to hold off judgment until you hear all the evidence about a mental health issue and insanity, until you get all that evidence and you mull it over? Can you hold off judgment until you receive that evidence before you make a decision?
Yes.
All right. Shifting gears a little bit to the penalty phase. So under this set of questions, we've established that the jury has found the defendant guilty of the crime of first-degree murder, and that the jury has rejected the insanity defense. Okay?
Okay.
Once we get into that penalty phase, I'm going to touch on a few things that the judge mentioned, not to go through everything because she did a pretty thorough explanation. But once we get into that penalty phase, the state will present evidence of aggravating factors, which are factors that make this murder worse or more egregious than other murders. Okay?
Correct.
And the judge mentioned the fact that this victim here, Clayton, was a law enforcement officer. And that, by law, is an aggravating factor that if proven, a jury could use to weigh to decide that this case is worthy of the death penalty.
Correct.
So if that aggravator was proven to you, you can use that and give it whatever weight you feel it deserves in deciding the appropriate punishment. Okay?
Okay.
With me?
Yes.
Likewise, the judge indicated that you can't use evidence of that prior murder of his girlfriend in the guilt phase to determine whether he's guilty of this crime. But it may become relevant in the penalty phase to determine what a proper punishment should be. Okay? It may be used as an aggravating factor for you to consider and weigh if proven to you in your ultimate decision of what the proper sentence should be. Okay?
I understand.
So in this case, if it's proven to you that the victim was a law enforcement officer, you could weigh that, and that might move the pendulum over towards death in your decision-making process.
Correct.
If it was proven that he had a prior conviction for murder, that could move your decision pendulum a little further towards death. No matter how far that pendulum goes towards death, would you be able to listen to evidence of mitigating circumstances, evidence of the defendant's life, background, character, and fully examine that before you make a decision of the proper punishment?
I believe I would, but
Do you think that Mr. Loyd and the criminal justice system as a whole deserves to have a jury who is open-minded and can listen to all evidence presented to you?
yes, I believe he deserves a fair trial.
Would you be able to listen and truly consider mitigating evidence presented to you, even if at first blush you hear something and you're thinking, I don't know if that really is mitigating? Can you hold off judgment until you hear the details and the evidence surrounding that piece of mitigation before you make a final decision?
You know, sir, I feel like I could do everything that it was asked of me. I would try to keep my personal opinion out of it and do the best I could. You know, I mean, I'm not sure how other people, but I would do the best I could do.
For instance, let me just give you an example. If you were to hear that the defendant suffered effects of, say, race, or had a bad childhood, maybe even abusive childhood, now's not the time to talk about the details and the actual circumstances. But if you heard that evidence, would you be able to listen to it, mull it over in your mind, truly consider that evidence before making a decision?
Again, I believe I could.
Thank you, Your Honor. Thank you, sir. No other questions?
Sure.
Hello.
How are you?
Oh, I'm great. How are you?
I'm doing fine.
I know, and I apologize for having to ask you this. You had discussed with us the other day, perhaps, that you had a PET scan scheduled tomorrow?
I do.
And are you expecting the results of the PET scan shortly thereafter?
I think immediately.
Okay, and would that affect, like, depending on the results, might you need treatment or follow-up appointments?
I've had a couple tests. I'm slightly clogged in a couple arteries, and they're thinking of putting a stent in, and I'm sure they're going to tell me tomorrow whether that needs to be done.
Okay, and again, I apologize for getting into your detailed medical.
That's okay. I just told you. So
Okay. Do you know if they say, yes, you need to have a stent put in, when that would be happening?
I believe they do it immediately.
Okay. And so obviously, if they tell you tomorrow you need to have a stent, you're going to be unable to participate in a 3-week trial starting hopefully sometime next week.
I'm not really sure on that. I have heard every time on stents is you feel better immediately, but I honestly couldn't answer that.
Okay. Fair to say you've never had a stent put in before? Okay. All we know is going to have the PET scan tomorrow, have some expectation it's going to require follow-up immediately.
Am I expecting that?
Yes.
I honestly don't know if they'll put a stent in or not. I'm clogged. That's all I know is I'm clogged, and I think they go in and look, and if they feel a stent's the thing to do, they do it.
Okay. I just have a couple more questions for you. I don't think anyone in here doubts that you are doing everything you can to follow the law and the instructions as the judge has given it. And you talk about wanting to set aside your personal opinion. I only want to talk to you right now about your personal opinion.
Okay.
Okay? The only oath you've taken as a juror thus far, or excuse me, as a prospective juror, is to tell the truth.
I agree 100%.
Right? And so when the judge was talking to you about Mr. Loyd having previously been convicted of the murder of Sade Dixon and her unborn child, right? She was pregnant at the time, and then asking you your thoughts on this murder case that you're here for now, potentially as a juror, your answers were, I would probably say he's guilty. Do you recall saying that?
Yes.
And then when the judge asked if you could put that murder of Sade Dixon and her unborn child out of your mind, you said, as well as any. And I want to ask you more about that.
Okay.
So what I took to mean from that is, as well as anybody could, in that I'm not going to be able to put it out of my mind. Nobody really would be able to, knowing that.
I would say that, I mean, what I know just can't go away. I mean, I know that he killed his girlfriend and pregnant girlfriend. I know that. So I would say that that's probably not going to go away, but I would follow the instructions.
Sure.
And I'm sure it's, in a death penalty case, I'm sure it's very specific, you know, what to do and what not to do, and that's what I would try to do to the best of my ability.
There's some people that say to me, I can't unring that bell. Like once I've heard it, you know, as much as I would like to follow the instructions, if I'm being honest in my heart of hearts, when I'm thinking about whether the state has proven him guilty of this murder of Lieutenant Clayton, in the back of my mind, I'm still aware and thinking about the fact that he's been convicted of the murder of Sade Dixon while she was pregnant.
I think I could let it go. I mean, that's why I'm giving you my honest opinion. I think I could not base the decision on the previous murder.
Okay.
I understand it is a separate trial just for the police officer.
Okay. You would agree with me, though, instinctively when the court asked about this case that you're here for now, your answer was, I would probably say he's guilty.
I feel like I'm being interrogated, but I wouldn't sentence anybody to death unless I knew they did it.
Okay.
That case.
Well, good. That's a good segue, okay? Because the first part of the trial is deciding, if you're selected as a juror, is deciding whether the state has proven the defendant guilty beyond a reasonable doubt, okay? And the only crime that we get to this penalty phase for is first-degree murder, which in Florida is the intentional, premeditated killing of an innocent victim. That defendant thought about it, he meant to do it, and he did it, okay? So the only way we're even considering life or death is if he's been found guilty of first-degree premeditated intentional murder. With me?
Correct.
And so that's what the judge was asking you. Some people say, if I am finding this person guilty of that crime, death is really the automatic or only penalty for me.
Well, I don't believe it's the automatic or only penalty. It's obviously the life or death. I would actually look at it like I would be choosing that, but maybe I would. I would have to, I would just be set to say he did or he didn't do it.
Nope, you are 100% picking life or death, okay? So that's what we're here talking about.
Okay.
If you are selected as a juror in this case, the first part of the trial, right, it's one big trial, but there's two parts of it if we get to the second part.
Okay.
The first part of the trial is deciding, has the state proven Mr. Loyd guilty beyond a reasonable doubt? Or has the defense proven him not guilty by reason of insanity? Okay? With me? The second part of this trial only if we get there, right? They may not prove him guilty. We may prove him not guilty by, we may prove him not guilty by reason of insanity. But assume that they do prove him guilty, or you don't believe that we proved he was insane at the time. Then, as a juror, you're going to be asked to decide if the appropriate penalty is life or death.
Correct. I understand.
Okay? And so that's why everybody wants to follow the rules the judge gives, myself included. Okay? It's not I get it. And that's why we have to take this opportunity to just talk about your feelings, because ultimately, if you are asked to make this decision about whether Mr. Loyd lives or dies, it's you voting your individual conscience. And nobody can tell you what the right or wrong answer, right? You know, that's up to you.
Maybe I'm not understanding correctly, but if everything said he was guilty and all the mitigating circumstances, and I made all the mitigating circumstances on both sides, and said, okay, the police, he's a police officer, check there, however I did it, however I was supposed to do it, I would weigh that, and I'm not quite sure what you really asked me to tell you. I think I could set somebody down. I could set them if they were guilty, if they were found guilty.
Right. Okay, so here's the second question. Is knowing that the victim is a law enforcement officer. It's the intentional, premeditated killing of a law enforcement officer. That defendant thought about it, he meant to do it, and he did it. The circumstances of that crime, execution style, defendant standing over the victim, shooting her because she is a cop.
Okay.
Right? And some people say, if I find somebody guilty of that, death is really the only appropriate penalty. Does that make sense? Yes. Tell me what you think.
I don't know the order or the rules that dictate whether that's I don't know the rules well enough.
Let me intervene.
If it checks the boxes to me, and are you asking me if you gave me that case that you just said, would I say death or innocence?
All right, let me intervene here, because this is becoming confusing for you, all right? First, there's a conviction for first-degree murder,
Correct.
right? Now you're in a penalty phase.
Correct.
What we're trying to determine is this, sir. As I told you, there's no automatic death penalty in Florida. You have to have an open mind. Is the fact that the victim in this case would have been a police officer, okay?
Yes.
And there's a prior conviction for murder. Would that cause you to just refuse to listen to the mitigation and be someone who's thinking, I'm going to sentence this man to death if he's convicted of first-degree murder? That's the question you're being asked.
No.
All right. So you could listen to the mitigation with an open mind and weigh it all before you made a decision?
Yes.
Thank you.
The answer to the judge's question was no. So my follow-up question is, why not?
I guess it would be, I actually am very confused. If I felt he was guilty of the death penalty, I would convict him of the death penalty. If I felt like there was circumstances where that didn't cause that were unfortunate for the defendant, I'm sure that one side's trying to pull at your heartstrings and say, he was this, this, and this, and I feel like I'm a compassionate person. I could do it that way, but I also am compassionate for the police officers also and the victims. So, I'm for the blue, if that's what you're trying to get at. Maybe that's the question I'm for police officers. I think they do a good job. But again, as I said earlier, it would matter to me if somebody came and shot you in the head or that officer in the head. To me, it's all a person, and Your family's sad and his family's sad. They're both the same.
Okay.
Now, under the law, maybe being a police officer is more a higher sentence, and I would obey that.
Right, I get it. And we're kind of talking about two different things, right? There's the law the judge is going to give you if you are selected as a juror. Right? And so I'm just trying to talk to you about your feelings right now. And you can appreciate some people say to me, if somebody kills a police officer, I'd like to be open-minded, I'd like to follow the rules the judge has given, but I know myself better than anybody else, and death is the only appropriate penalty for somebody who kills a cop. Does that make sense?
Yes.
Okay.
If, but I guess maybe this might help you. If somebody stood over a police officer and shot him in the head, I don't really can't remember what happened, but if somebody, I would say that would be a bigger penalty to me. That meant that would be just cold-blooded rather than maybe possibly being in a shootout. And again, I don't know the circumstances, what happened.
Got it. So then, describing that scenario, if I say, you know, you have to give meaningful consideration to that defendant who did that, of suffering the effects of racism, right? And meaningful consideration means hearing it, internalizing it, and it potentially impacting your verdict as to life or death, right? It's not just hearing it and dismissing it. Truly, do you think you could consider that defendant experiencing racism that committed the crime we just discussed?
Could I consider that he was, that there was racism against him?
Yes.
Of course.
Okay. But in a way that meaningfully consider it, in a way that could potentially impact your verdict as to life or death.
Objection, that's an answer.
Sustained. Let's move on here.
You can appreciate that people have differences of opinion on these sort of things?
Absolutely.
Okay. And so what the law requires, if you are selected as a juror in this case, if we get to the second part of this trial, is for each juror's individual moral assessment on whether the defendant should live or die to be heard in this courtroom. Okay? Death is never required. Not in any case. Not in the worst conceivable case you can imagine. And if one juror says that life should be the verdict, then life will be the verdict. That makes sense?
Yes.
And sometimes these things can get a little contentious in the back.
Yes.
Right? But you certainly wouldn't bully or badger anybody else to try to change their opinion just to agree with you, right?
I've never been on a jury. I imagine you would talk and say, this is what I feel, this is what I feel. If I felt strongly one way or the other, I would certainly give my point of view, and that's how I would do it.
Sure. And the law certainly encourages folks to talk about it, but it's not required, right? So in the in the penalty part of this, the second part, if you're deciding life or death, it's each individual voting his or her conscience, right? And some people, like you and I, have no problem articulating that and how we feel. And some people say, I can't articulate it. I don't know why. I just know the verdict for me is life. And that's okay too, right? So as a juror, you have the right to be respected and have your opinion be respected. Make sense?
Yes.
And so the point is, of course, share your opinion, discuss it. But if somebody says, I've reached a verdict here and it's for life, you're not going to badger that person into changing his or her opinion.
I wouldn't call it badgering, no. I wouldn't, I would, no.
Okay.
I mean,
May I have a moment, Your Honor?
Yes, ma'am. All right, let me see the attorneys at the bench. We'll be right back with you, sir. You can just relax for a few minutes. All right, sir. We don't have any more questions for you today. What we're going to do is this. I'm going to send you through to the next round of questioning, which is the final round. However, I need to know after tomorrow, or tomorrow you're having the PET scan. If they tell you that you're having a stent put in, you need to call my office, all right, and let us know. Call the jury room and they'll let me know
Okay.
that you're having the stent put in, because that's a different situation.
Okay.
I don't know whether you're getting a stent or not, so I'm going to proceed.
I don't know whether I'm hoping for one or not hoping for one, to be honest.
I can't help you with that. All right, so I just wish you good health. How's that? So here's what I'm going to do. For right now, I'm going to send you through for the next round, which is the final round of questioning. Now, that means you become a purple dot, not a yellow dot. 'Cause remember, we call people in by colors?
Yes.
I have no idea when that's going to occur. It's probably going to be next week, is my best educated guess. You need to start calling in tomorrow after 5, but you also need to let us know what the results of your PET scan are. And they'll eventually tell you to come back in if you're not getting stent put in.
Okay.
All right? I'll take the mystery out of this for you. If you're getting a stent put in, I'll excuse you, all right? So I don't want you worrying about that on top of everything else. We're giving you a package. It includes a slip with a phone number that you're supposed to call to find out when you're supposed to come in. And additionally, I've got in there instructions for being sequestered. The next time you come in, we're sequestering the jury. We're picking the jury and sequestering them that day, so you need to bring a suitcase with you. And there's instructions in there about, suggestions for what to pack. There's also, explanations about what it's like to be sequestered and what the rules are and all of that, and a letter for your employer if you need it, letting them know that you're being called back for one more time. Do you have any questions?
No, I don't know.
All right, thank you so much, sir. We appreciate you being here today. You have a good afternoon and good luck tomorrow. I hope it all works out for you.
Thank you, you too. Have a good day.
All right. I'm going back to panel number 7. The next 2 jurors indicated to me that they could not impose death because of religious, personal, or moral reasons. So that's why I'm bringing them in now. Juror number 34, please. And this is also a juror who's not sure whether they were being paid or not. So I'm going to inquire as to that first. Welcome back. All right, I have a few questions for you. There aren't any right or wrong answers to the questions you're being asked. The correct answer is the truth, because all we're trying to find out in asking you these questions is whether or not you could do your job as a juror in this type of case. Something we need to know and you need to know, so just tell us the truth. But with you, I want to start with, you were supposed to check and see if you get paid for 3 weeks if you're a juror. Do you get paid?
Yes.
You do? All right, you're going to need to have that mic way closer to you.
Yes, I do.
Okay. So having asked you that, you also indicated to me that you have either a personal, religious, or moral objection to the death penalty. Is that correct?
Yes.
Which one is it?
Personal.
It's what?
Personal.
It's personal. How long have you held that belief?
All my life.
Okay. And is this a belief, is your belief such that faced with the, choosing between life and death, would you ever be able to vote for a death penalty?
No.
Okay. State?
State moves, Your Honor.
You want to? Yes, ma'am.
Hello.
Hello.
You would agree it would not be fair on these kind of cases if everybody on the jury was an enthusiastic supporter of the death penalty, right?
Yes.
Same for the state. It wouldn't be fair if everybody on the jury was somewhat opposed to the death penalty, right?
Right.
And so in order to serve as a juror in this case, the law requires that you be able to give meaningful consideration to both possible penalties, life or the death penalty. Do you think you could do that?
Can you repeat the question one more time? I'm having a hard time staying awake. I'm a night shift nurse. I only had 2 hours of sleep, so I am doing my best.
Okay.
Yeah.
What's your schedule? When do you have to work?
Well, I worked this morning. Well, I worked the last night shift and I got off this morning, so I only had 2 hours of sleep, and then I came here.
Okay, and obviously if you're selected and you're sequestered, you'll be sleeping non-nocturnal hours. Yeah. No, you'll be sleeping at night is what I mean to say.
Well, yeah, it's kind of hard because I usually sleep through the day, work at night, so.
I gotcha.
Yes.
So the question is, the law allows jurors to serve on a case where the death penalty is a possibility, even if that juror has conscientious objection, religious scruples opposed to the death penalty. What the law requires for you to serve is to be able to give meaningful consideration to both possible penalties for first-degree murder. Life in prison without the possibility of parole, or the death penalty. Do you think you could do that?
Yes.
I have nothing further, Your Honor.
All right, ma'am. Let me explain. Do you know what meaningful consideration to the death penalty means?
Would you care to explain?
Okay. So here's what you have to do as a juror. In order for the death penalty to even be a possibility in cases like this, you have to have found someone guilty of first-degree murder, meaning the intentional killing of another human being with no legal reason for having done it. It's not self-defense, it's not anything. And that finding is beyond a reasonable doubt. You with me so far?
Yes.
All right, now you're in a penalty phase. The state's going to be presenting aggravators, which are reasons that they believe your vote should be for the death penalty. The defense is going to be presenting mitigators, which are reasons they believe your vote should be for life without the possibility of parole. Okay. If I lose you at any point, let me know, or if you just need us to wake you up a little.
I'm here.
All right. You have to be able to listen to the evidence both sides are presenting, the state and the defense, with an open mind, and you have to be open to both sentences. When you go back into the jury room, you weigh the mitigators and the aggravators fairly and openly. You're never required to vote for death, but you have to be able to at least consider it and be open to voting for death. So if you were back in that jury room after listening to all this evidence, you were weighing the aggravators, you're weighing the mitigators, you're deciding what's important to you and what's not important to you. And that process leads you to believe that the sentence should be life without the possibility of parole. Can you vote for that sentence?
Yes.
And if that process leads you to believe that the sentence should be death, can you vote for that sentence?
No.
Okay, thank you. State?
State moves again.
Defense?
No objection.
All right, ma'am, you're free to go. Thank you very much. Get some sleep. That was 30, you're 265, right?
Yeah.
Just for a second, our simultaneous.
Yeah, mine's gone, mine's gone down too.
Okay.
We have a glitch in this thing. Is yours gone down? Yeah, mine froze.
Yeah, you stepped down, so sorry.
All right, she's going to restart, and then the transcript will pop up for you, okay? What's your-
We haven't done start coming up to the bench with me. I can't remember everything they're saying when I'm arguing the cops challenges. I'm bargaining this fucking state, and Ted is fucking worthless. I'd rather him not be there.
Ready to go? Okay. All right, everybody log back in.
Because that's what, like with that last juror, I felt cumulatively he had said enough stuff.
All right, mine's back up and running.
Okay, thanks, Judge.
All right, everybody ready? Okay, I have a note-taking problem. I wrote down 2 jurors that told me that they could never consider death, and I wrote down 34 and 45, but I have 45 as already having been excused.
That's correct, but he also said he couldn't vote death.
Oh, is that what it is? So, okay. All right, that concludes the cause portion of our questioning for this afternoon. So go back to panel number 7. Here's who I think is left. Juror in seat 33, 51, 53, and 56, and 60 from panel 7. Everybody on the same boat?
Yes.
That was a lot of jurors that got excused. So juror in seat 33, please. Who was? Good afternoon, sir. How are you?
Doing well, thank you.
Is it Jean? Okay, take this off so you can hear me. I have some questions for you, and then the attorneys will have some questions for you. There aren't any right or wrong answers to this. The questions are designed to figure out for you and for us whether or not you can do your job as a juror in this type of case. So the only correct answer is the truth. It's what you actually truly think and feel, all right?
Okay.
So let me start with, you've heard something about this case, is that correct?
Correct.
Can you tell me what you've heard?
I think the basics, I don't follow news too closely.
Okay.
But I am aware of the details of the 2 murders.
Right. Tell me what you believe those details to be, based on what you've heard.
That Mr. Loyd is being accused of murdering his ex-girlfriend who was pregnant, and a police officer that was trying to apprehend him.
Okay. Anything else that you can remember?
Yes, he was kicked in the face and I believe lost vision in one eye.
Okay. And did you have any information about who kicked him in the face?
Yes, it was a police officer.
Okay. Anything else you can remember about this case?
No,
How much coverage did you watch?
not much. I heard it on the radio.
Okay. Did you talk to anybody about it? You know, just water cooler talk at work or friends, family, anything like that?
Yeah, I'm sure I did.
Do you remember any of those conversations?
No, I wasn't in any detail.
Okay.
It was something that was on the news and on the radio constantly, so it's kind of unavoidable.
So based on what you heard on the radio and any whatever you might remember, have you formed any opinion as to whether or not Mr. Loyd is guilty?
I mean, if we're being real, it's hard not to. But I've been in management for 20 years, and one of the valuable lessons that I've learned during that time is to try not to form an opinion until you hear all the facts on both sides.
Right.
As difficult as that is sometimes.
It can be difficult, and I understand that. So, and remember what I told you, the only correct answer is the truth. In a criminal case, in any criminal case, The defendant is entitled to the jurors who, before they've heard any evidence, you have to be able to presume him to be innocent until and if the state proves he's guilty beyond a reasonable doubt. Do you believe that you can do that in Mr. Loyd's case?
Yeah, absolutely.
All right, so I'm going to give you 3 scenarios, and you tell me if any of them apply to you, okay? The first one is, it's the first day of the trial. You're waiting for the trial to start. You haven't heard anything. You're sitting in that box. And what you're thinking is, all right, we're here to see if the state can prove this man is guilty of anything. At the moment, I don't think he's guilty of anything. I'm presuming he's innocent. Scenario number 2, I think this guy's probably guilty, but I'm willing to sit here and listen and see if the state can prove it to me. And scenario number 3 is, I think he's guilty, but I'm willing to listen and see if I'm wrong about that. Do any of those 3 apply to you?
Yeah, like I said, scenario 1, being in management as long as I have, is difficult as something.
Okay.
It's something that I've acquired over the years.
You didn't indicate any personal, religious, or moral objections to the death penalty, correct?
No.
Are you, as I told you, first-degree murder in the state of Florida is intentionally killing someone with no legal justification. It's not self-defense. It's you just killed someone, and you intended to do it. Are you a person who believes that if you convict someone of first-degree murder, you're going to vote for the death penalty, knowing nothing else, just that? It's first-degree murder, I'm giving you death.
I don't think there's a one-size-fits-all or a one-scenario-fits-all.
Okay.
I believe in most cases that would probably be the immediate reaction, but hearing the details of the case specifically would be needed.
Sorry, I'm trying to ask questions and keep notes at the same time. So let me add to that factual scenario. Someone's been convicted of first-degree murder. Again, the standard's beyond a reasonable doubt. And the person is a law enforcement officer. Does that change your answer in any way?
No. I believe every life is just as equal as every other, so I don't think there should be a more severe or less severe penalty based on someone's position.
Right. So let me add one more fact to that, which is the person that's been convicted of first-degree murder was previously convicted of another murder. Does that change your answer in any way? You haven't heard anything else, just that. Conviction of first-degree murder, previous conviction for murder.
Sure.
Okay, how does it change your answer?
It would, I guess, lean me in the direction that they were more than likely guilty.
No, I'm not talking about guilt, okay? Because I'm talking about death penalty. Does it lean you towards death penalty, saying, look, if I find you guilty of first-degree murder and you've been convicted before of a murder, I'm not really interested in what else you have to say. I'm voting for death.
I would definitely hear the case out. Okay. It wouldn't be a definitive.
All right. So you heard me describe the process. Number 1, you don't even get to a penalty phase unless someone is convicted of first-degree murder. So the jury's already decided someone's guilty beyond a reasonable doubt of intentionally killing someone else. You with me so far?
Yes.
Then there's a penalty phase in certain cases, like this one, where the state is going to put on evidence of what are called aggravating factors, the reasons they believe your vote should be for death. The defense is going to put on evidence of mitigating factors. And again, this is at the penalty phase. Person's already been found guilty. They're going to put on evidence of mitigating factors, reasons they believe that the vote should be life without the possibility of parole. To sit as a juror in these types of cases, you must be able to listen to both sides with an open mind, meaning you can't be sitting there listening and going, okay, I'll listen to you, and then I'm going to vote the way I was going to vote anyway. It has to be, I'm willing to listen to all this information and process it. Go back in that jury room and weigh those aggravators, weigh those mitigators, figure out what I think is important and what's not important. Number 1, can you go through that process with an open mind?
Yes.
All right. And can you do that regardless of the fact that you've convicted someone of first-degree murder?
Yes.
And then if that process leads you to believe that the appropriate sentence is life without parole, can you vote for that? And if that process leads you to believe the appropriate sentence is death, can you vote for that?
Yes.
Right. Mr. Loyd has raised the insanity defense, as I told you. This is in the guilt phase. They have, when you're trying to decide whether he's guilty or not, the defense has to prove it by clear and convincing evidence. So it's the end of the guilt phase. You've heard all the state's evidence, you've heard the defense's evidence as to whether or not he committed these crimes. You are convinced by the defense's evidence that he was insane at the time this occurred. Can you return a verdict of not guilty by reason of insanity?
If I believe that they proved their case, yes.
Okay. And then my last question to you is, before I turn this over to the lawyers, the conviction for the murder of Miss Dixon and the unborn child, you can't use that to determine whether or not he's guilty. It's two separate cases. Can you put that out of your mind during the guilt phase?
Yes.
All right, thank you, sir. I don't have any other questions for you. Mr. Buxman, you may inquire.
Can we approach, Your Honor?
Yes. All right, sir. We appreciate your being here today. You have some information about this case that is not admissible, so for that reason, I'm going to release you as a juror, okay? Thank you so much. Have a good day. We appreciate your service. That was juror number 33. Next up, I have panel 7, juror 51, correct? Yes, juror 51. Good afternoon. How are you?
Good afternoon. How are you?
I'm well, thank you. All right. Try to relax. I know this is not the most comfortable of situations, but I have some questions for you, and then the attorneys are going to have some questions for you. There aren't any right or wrong answers to this. I'm sorry, I'm taking notes at the same time that I'm asking questions, so please excuse me. There aren't any right or wrong answers to this, to any of these questions. The point of the questions is for us and you to determine whether or not you can do your job as a juror in this case. That's why we're asking them, okay? So the only correct answer is the truth. You need to be honest with us and open about your opinions, your thoughts, your beliefs. Let me start with, you indicated that you have never heard about this case prior to coming here. Is that correct? All right. Do you have a position on the death penalty?
Not in particular. It's a form of punishment, I guess, or I really don't have an opinion.
Okay. Are you someone who believes that the death penalty should never be imposed in a case?
No. It should be imposed for certain criminals or people in that nature, like terrorists.
Okay. So let me go over these types of cases and what the law is in the state of Florida in a little bit more detail than what I gave you earlier. Number one, you can't even talk about the death penalty unless a jury convicts someone of first-degree murder. There's a guilt phase. At the end of that guilt phase, the jury votes guilty of first-degree murder, which means Someone intentionally killed another person and they had no legal reason to do so. It's not self-defense, it's not anything. It's, you just killed someone, all right? You with me so far?
Yes, ma'am.
And the jury has to have found that person guilty beyond a reasonable doubt.
Yes, ma'am.
Now you can have a conversation in certain cases about whether or not death is an appropriate sentence. There is no automatic sentence for death in Florida. So that second phase where you're going to have the conversation about whether this person who's been convicted of first-degree murder should be sentenced to life or death is called the penalty phase. In the penalty phase, in order to sit in a case like this, you have to be able to listen with an open mind to the state's aggravators, the reasons they believe death is the appropriate sentence, and the defense's mitigators, the reasons they believe life without parole is the appropriate sentence. You with me so far?
Yes, ma'am.
Right. So as you sit here today, having heard nothing other than a person has been convicted of first-degree murder, are you someone who would automatically vote for death?
No.
All right. If I added to that the fact that the person who was killed was a law enforcement officer, would that change your answer?
No.
If I added to that the fact that the defendant had a prior conviction for murder, would that change your answer?
No, it would not.
All right. Back to the penalty phase. You're in a penalty phase. You're sitting in the jury box. Can you listen with an open mind both to the aggravators and the mitigators? And by open mind, I mean not you're sitting there thinking, okay, I'll listen to you, and then I'm going to vote the way I was going to vote anyway. It means you can listen to it, you can absorb the information, and think about it and consider it. Can you do that?
Yes, ma'am. Because that's the only way you should be able to do it. You have to be able to take everything into consideration.
All right, perfect. So you can go through the process of weighing aggravators and mitigators.
Yes, ma'am.
If that process led you to believe death was the appropriate sentence, could you impose that?
No, I would not oppose it. But if all the evidence and everything led to that conclusion and they met everything that was required by law, yes, I can say I can oppose that sentence.
You could vote for a death penalty?
Yes.
All right. And if it all led you to believe that life without parole was the appropriate sentence, could you vote for that sentence?
Yes, I can.
Do you have any doubts about either one of those?
No.
All right, moving on to the insanity defense. The insanity defense is raised in the guilt portion. When you're trying to decide whether to find someone guilty or not guilty of what they're charged with. The defense has to raise it and they have to prove it, not the state. It's the only time the defense has to prove something in the guilt phase. So it's the end of the guilt phase. You've heard all the state's evidence, you've heard all the defense's evidence, and the defense has convinced you that he was insane at the time this occurred. Could you return a verdict of not guilty by reason of insanity?
Yes, I can.
And lastly, can you put aside, I told you about the conviction about Ms. Dixon and her unborn child. She was pregnant at the time. Can you put that out of your mind when you're trying to decide whether or not he's guilty?
Yes, I can.
All right. Thank you, sir. I don't have any other questions for you. Mr. Buxman, you may inquire. The lawyers are going to talk to you now.
Good afternoon, sir.
Good afternoon.
I want to start with a couple questions about the insanity defense. That's something that would happen and discuss the guilt phase of this trial, whether or not part of the trial that is designed to determine that the defendant committed these crimes. Okay? Because the insanity defense brings with it issues of mental health, I have a couple questions about, first is whether you or a close friend or family member have any experience with mental health issues.
Not that I'm aware of from like talking with my parents, but not that I'm aware of.
No close friends or anything like that?
No.
Some people in society feel that mental health issues are just made up, and it's a scam or something like that. Do you believe that? Okay. Based on that answer, I'm assuming that you would be able to listen to all of the evidence regarding the mental health issue, determine if a mental health issue exists in this case and what ramifications are, and keep an open mind as far as whether it's sanity.
Yes.
Shifting gears, moving ahead to the sentencing phase of this case, if we get there. For the purposes of these questions, the jury has already determined that the defendant was guilty of first-degree murder in this case. The jury has already rejected and found the insanity defense wasn't proven and wasn't a viable defense. Now we're moving to the penalty phase. In that part of the process, your job as a juror would be to analyze the aggravating factors and mitigating circumstances in the penalty phase. Now, when you were first started talking with the judge, she asked you about your feelings of the death penalty, and you kind of said you really didn't have an opinion one way or the other, right? Okay. And I think you made a statement that the death penalty is appropriate for certain types of criminals like terrorists, I think you said.
Yes.
Can you talk to me, elaborate a little more on that? What do you talk about?
Like, I was ex-military, so I spent time overseas, and just the way their belief is that they're just, you can't change that mindset. Knowing that, seeing them and how they lived and how they wanted everybody to adhere to theirs, that to me, and they also changed the way the society in general lives, that you can't have that. And to me, that's not good.
Okay, I think I understand. Thank you for your service. So if I'm correct in what you're saying, I'm not telling me, the mindset and the belief system of these types of terrorists that you dealt with overseas are such that the death penalty would be appropriate because you can't change their belief system.
Yes.
Can you envision a set of circumstances where the death penalty would be appropriate for someone that's not that type of terrorist, that type of person with those horrible...
Not without any facts or seeing any evidence of that prior to making that decision.
Okay. Let me ask it a slightly different way. If you were selected for this jury and you heard all of the evidence of the aggravating factors, you heard all the evidence of the mitigating factors, and you are back in the jury room, a hypothetical situation where you're talking about your friends and family and about, I could put that person to death. We're talking about a real life situation. If you felt that after weighing the aggravating factors and the mitigating circumstances that the death penalty was a proper sentence in this case, not for an overseas terrorist, but for an American citizen, would you be able to raise your hand in that room and say, yes, I think the death penalty is appropriate, and that man deserves to die for what he did?
Yes, I can do that. Weighing all of the evidence and the circumstances and seeing everything, because if I'm sitting back, I'm probably sitting down here for the first part, so I would be more inclined to say yes.
Okay. And the purpose of my questions was, were you of the mentality that if it was a terrorist situation, I could do it, but absent that, I could not? You just clarified that. Thank you. Once we get into a penalty phase, that is when you will hear evidence of the details and the circumstances surrounding these aggravating factors and mitigating circumstances. Now is not the time to discuss those things. But if you hear a variety of aggravating factors presented by the state, and those are factors that make this murder more egregious than other murders, and those aggravating factors, the more and more you hear of those aggravating factors, and they're really bad, they're egregious, and the pendulum starts swinging over towards death in your mind. No matter how far that pendulum got to death, would you be able to hold off a final judgment until you hear evidence of the mitigating circumstances?
Yes.
Okay. Regardless of what those mitigating circumstances are, could you listen to them, mull them over in your mind, consider them, and only then decide to give them any weight if they deserve it, and then make a decision?
Yes, I can do that.
So you can keep an open mind?
Yep.
That's what we're looking for, okay. Would you be able to give meaningful consideration or truly consider any piece of mitigation evidence that is presented to you, regardless of if at first blush you may be thinking, isn't important in my mind. Hold off judgment until you hear the details surrounding it.
Yes.
Okay. Thank you, sir. No other questions, Your Honor.
Does Miller remain quiet?
Hello.
Hello.
When Mr. Buxman asked you about if you would be able to, in a real-world scenario, vote for a death sentence for someone, you said, and correct me if I'm wrong, that if you were sitting out here for the first part, you'd be more inclined to say yes. Do you remember saying that?
Yes.
Okay. And so I want to talk a little bit more about that, if you don't mind. The first part of the trial is where the jury would determine if the state has proven Mr. Loyd guilty beyond a reasonable doubt, right? Or if the defense can prove by clear and convincing evidence he's not guilty by reason of insanity, okay? So if we're in the second part of this trial, you as a juror, if you're selected, would have already decided that Mr. Loyd is guilty beyond a reasonable doubt of the intentional, premeditated killing of an innocent victim. With me?
Yes, ma'am.
And in making that determination, you would have considered any defenses. In this case, you know we've pled not guilty by reason of insanity, but talking about more of a hypothetical case, if a jury finds a defendant guilty of first-degree murder, that jury would have considered any defenses available, like self-defense, for example, in finding that person guilty of intentional, premeditated murder. With me?
Yes, ma'am.
That defendant thought about it, meant to do it, and did it. No question. Got it?
Yep.
Is death the only appropriate penalty for that person who's guilty of that crime?
No.
Why not?
The evidence would have to keep you in that realm. You say, well, it wasn't just to say, okay, because he was guilty of the crimes. Is it right to sentence him to death? I can't say yes or no, because was it met? Were the circumstances unmet? Like the mitigating factors, there might have been something that I believe that you've seen or heard that led me to saying you can't sentence to death.
Okay. I just want to make sure that thing that we're talking about that you might have seen or heard isn't really us talking about him being not guilty. Does that make sense? There's no doubt about his guilt in determining life or death. So the scenario that you're talking about, or the circumstances, aren't things, or are they things, that have to do with whether he's guilty or not. Does that make sense?
Yes.
Okay. Knowing that the innocent victim is a law enforcement officer, does that change your opinion or make death the only appropriate penalty?
No, it doesn't change my decision. It wouldn't change my decision. My decision would be based on the evidence in the testimony and the other factors of the case and the sentencing portion of it, too.
Right. Well, and let me tell you this. In Florida, right, so the judge told you if we're in the second part of this trial, the state has to prove the existence of at least one aggravating factor beyond a reasonable doubt for the defendant to be even eligible for the death penalty. With me? Killing a law enforcement officer is an aggravating factor in Florida. Okay? And so some people say to me, listen, if I'm being honest about my feelings on this, if you kill a cop, death is the only appropriate penalty for you. Does that make sense?
Yes.
Tell me what your thoughts are.
Just because you kill a cop, there's still more to that story. I would still believe there's still more to that story. Just because the state proved that he, the defendant, the guilty party, killed the cop, there's still other mitigating circumstances that could lead you to believe that death isn't the only sentence.
Okay. When you say there's more to that story, could you elaborate a little bit for me, please?
There's always more to the story than just, okay, this is what everybody knows. It's the optics. I would call it optics. I'm guessing I don't really know how to explain it, but my view is that there's always two sides to every story. They're showing you just because he killed the cop doesn't mean, and the law enforcement doesn't mean that he needs to be put to death. It may have been something that I saw that maybe somebody else didn't see to say, hey, okay, let's not sentence him to death, but he can go live out his days.
Okay, and sure, and I think you actually touched on a really interesting thing, because mitigation, right, the state talked about how they have to prove aggravators and the defense can prove mitigation. Mitigation can come from anything. It can even come from the state's case, right? So you may see something in the case, the state's case in chief, that you think, I find that to be mitigating. It's not limited to just what evidence the defense puts on. Does that make sense? And so, sort of the same questions, knowing that the defendant has been previously convicted of another murder.
That shouldn't, he's already been tried and convicted for that. That should not weigh on this. I think the mic died.
It's a terrible microphone.
But that shouldn't weigh, that will have no weight on this, because it's this case he's in trial for, not that one, because that comes back to that double jeopardy. And as a juror, I can't do that to anybody.
I hear you. And that's exactly right. Again, I want to be, in the first part of this trial, where we're deciding if the state's proven him guilty, whether or not he's guilty of some other crime has nothing to do with this. Totally agree with you. In the second part, if we get there, and we're talking about life or death, again, it's an aggravating factor in Florida that the defendant has been previously convicted of murder, right? And so some people say to me, if I know he's already guilty of murder and he's doing life, then really for this murder, death is the only appropriate penalty. Make sense? Do you feel similarly?
Just because of the mitigation factors too. Okay, he's already serving life, that's, okay, why would this put him to death because he killed somebody with a badge? I can't do that.
Okay.
Just because he was convicted of a different crime, that to me, that crime, he's already been tried and convicted. That it's not going to weigh anything on my decision for this trial.
I hear you. And in those circumstances that we talked about, murder of a cop, already been convicted of another murder, do you think you could meaningfully consider the defendant experiencing the effects of racism? Like, in a way that I hear it, I internalize it, and it may actually have impact on what I'm going to do as far as life or death. Okay. Death is never required, not in any case, not in the worst imaginable case you can conceive of. With me? And so the second part of this trial, the judge is going to give a lot of instructions if we get there and you're selected. State has to prove the existence of one aggravating factor beyond a reasonable doubt. The aggravator is sufficient to warrant the death penalty, that the aggravation outweighs the mitigation. And then the last question is still, do you believe death is the appropriate penalty? And the answer is never required to be yes to that last question. Even if it's yes, 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 you can say no at the end. With me? If one juror votes for life, then the verdict will be life. Okay with that? We talk a lot about mitigation. Mitigation can be anything to anyone, and it simply means why one juror would choose life or not choose death. It doesn't have to be unanimous. It can be unique. It can be even something seemingly small, like a smile observed between the defendant and a family member. For that juror says, I observed that, I assign it the weight of life, I'm not imposing a death sentence in this case. Make sense?
Yes, ma'am.
For a just verdict to be returned, all 12 jurors' individual moral assessments about whether Mr. Loyd lives or dies have to be heard in this courtroom. Got it?
Yes, ma'am.
It's your duty, your right, and your responsibility. And it would not be a just verdict. We call it a miscarriage of justice if a juror's individual moral assessment wasn't reflected on the verdict form read in this courtroom. Make sense? Sometimes deliberation can get contentious. People have strong opinions, differing opinions, right? You're certainly not going to let anybody bully or badger you into changing your opinion if you've already reached your individual moral assessment. Right? And you wouldn't bully or badger anybody else. If you have reached a verdict and it is for life and it's not being respected by your fellow jurors, you can say, we're done here. I've reached a verdict. Deputy, please get the judge. We can go home. Okay? May I have just a moment, Your Honor? Yes, ma'am. Follow-up question.
That's fine.
Can I I just ask you, when you were talking about terrorism or a terrorist, what is your definition of a terrorist, please?
Somebody who can change society in the way people live day to day. And I do a lot of people believe in a system that just, it changes the way everybody in the country and in the world has to live.
And I think what I'm afraid of, I just want to make sure, because some people could perceive killing a cop.
No, that's not, no. With 9/11, those guys were terrorists, and I wholeheartedly believe somebody knew something but didn't say anything, and I can't do that. I just, to me, they changed the way we, as a society, lived for years, and we're still seeing the effects today.
I get it. Thank you, sir.
Either side need to approach?
No, Your Honor.
All right, sir. We're going to send you through to the final round of questioning in this case, and it is the final round. We'll be picking the jury from that group. So several things are about to happen. Number one, you're now a purple dot, no longer a yellow dot. Remember I told you we called jurors in by colors? I need to change your dot to purple. That's the final group. We're going to give you and the deputies are going to put that on your badge so you can remember. We're going to give you a package. It includes a slip of paper with the phone number that you need to call to find out when you're supposed to return. I don't know the exact date because I don't have enough jurors to call the purple group back. Honestly, I don't think it's going to be this week. I think it's going to be next week. But just to be safe, start calling tomorrow night. There'll be a recorded message eventually. There may be no recorded message saying anything about purple. That means you don't have to come back. Until you hear purple come back, this is your date, then you come back.
Okay.
That day, because we're picking the jury that day, we are sequestering the jury that day. So you need to bring with you your suitcase, packed and ready to go in case you're selected. Leave it in your car. You don't need to bring it into the courthouse. If you get picked, arrangements will be made for you to get it. And lastly, we're giving you, the sequestration package explains more about being sequestered, and it gives you a list of suggestions for what you should bring with you to being sequestered. And lastly, we have a letter in there for your employer to let them know that you're coming back. Do you have any questions?
No, not.
All right. Thank you, sir. You have a good afternoon. We'll see you next time. All right, juror in seat 53, please. Good afternoon. How are you?
Good, how are you?
I'm doing well, thank you. So I have some questions for you, and then the lawyers are going to have a few questions for you. There aren't any right or wrong answers to these questions. The reason you're being asked them is so that you can determine and we can determine whether or not you can do your job as a juror in this type of case. Follow the law, put aside your personal feelings, that sort of thing. So the only correct answer is the truth. Don't worry about what your answer is, just tell us the truth, okay? Let me start with, you've heard something about this case, is that correct?
Yes, that's correct.
Can you tell me what you've heard?
Yeah, I work for a statewide political organization, so I follow the media very closely and was actually working in the legislature at the time, so the hoopla that came from the local politicians, I heard about all of that.
You can be a lot more detailed than what you just were. You can be blunt about it.
Sure.
What is the hoopla that occurred at the legislature?
Sure. So I worked in the state legislature for the senator that represents this area during the time. So she made public statements about it and that stuff. And then subsequently, I worked in local government. So any of the memorial type things, I attended.
So you also attend memorials for fallen officers? Is that a yes?
Yes, yes.
Did you attend any of the memorials for Lieutenant Clayton?
Yes.
All right. And did you do that as part of your job, or did you do it for personal reasons, or both?
Both.
Okay. Were you part of the discussions in the legislature and the actions taken by the governor's office involving the state attorney that was removed from the death penalty cases here?
I don't believe so, but I did interview for a role in the state attorney's office when she was the state attorney.
Okay. And you said you're a consumer. I see what your job is. So you're a consumer of media.
Yes.
Did you follow the story closely?
Probably not as closely as a lot of people, but I dailies got them for every major newspaper in the state.
And did you do this since it happened until now, when I told you to stop?
Yes.
Okay. Did you also talk to folks about it, not only at work, but friends and family?
I don't think I talked about it much at work, other than any talking points or anything I had to write in regards to it, but personally, I probably didn't talk much about it.
All right. So tell me what you remember about when this happened.
Well, I remember it happening. Gun violence advocate. I remember having to pull out the good old, we need to change guns in this country stuff. And then I remember trying just to keep tabs on it if we need to make further statements, but that's probably about it.
Based on everything that you were involved in, because you apparently had quite a bit of involvement, did you form an opinion as to whether or not Mr. Loyd is guilty?
Yes.
And what is that opinion?
Yes.
Yes, he's guilty?
Yes, I do believe so.
Jurors have to be able to presume that Mr. Loyd is innocent until and if the state can prove he's guilty beyond a reasonable doubt. Can you do that, or would you start this trial thinking, yeah, I think this guy's guilty?
Probably would. I think I could get there, but it probably would take some work mentally to unthink of that opinion.
So you'd start out thinking he's guilty and hope that the information in the case swayed you one way or another?
Yes.
Okay, thank you. State?
State moves.
Defense? All right. This probably isn't the case for you. It would be very hard for you to forget all of that. Thank you so much.
Yes, thank you.
Have a good day. Thanks. You're excused.
Oh, I'm sorry.
Juror in seat number 56, please.
Thank you. Do I sit? All right.
How are you, sir?
I'm very well. Yourself?
I'm doing well.
All right.
So I have some questions for you, and then the attorneys may have some questions for you. There aren't any right or wrong answers to this. You just need to tell me the truth.
Okay.
The point of the questions is to figure out, for you and for us, whether or not you can do your job as a juror in these cases. So the only correct answer is the truth, okay? Let me start by asking you a couple of basic questions. You said you've heard about this case, is that correct?
That's correct.
How much have you heard?
A lot.
Okay.
Yeah.
Did you follow it pretty closely?
No, not at all.
Okay, so when you say a lot,
Just whatever came on the news at night.
okay.
Yeah.
Was this back when it first happened, or, throughout the years? What are we talking?
This is when it first happened. Yeah, I haven't heard anything recently. I don't watch the news.
Okay. So back when it first happened, were you also, were folks talking about it at work? Friends were talking about it, anything like that?
Not really.
No? All right, did you form an opinion as to whether or not Mr. Loyd was guilty at that time?
No, ma'am.
Okay. Tell me what you remember seeing on the news in as much detail as possible.
I remember hearing about a case of a gentleman killing his spouse, and a kid was involved or something like that. That's pretty much all.
Anything else?
No.
Do you remember seeing any video of anything else?
No, ma'am.
Okay. Do you remember anything about this case, about Lieutenant Clayton?
No,
No?
No.
You just remember the other case?
exactly.
The Dixon one that I told you about?
Yes, ma'am.
Okay. Do you think you could put that out of your mind and focus on this case alone?
Yeah, I mean, I've never did this. I'm a very emotional person. So anything that I do get involved with is going to be emotional for me. Simple. But again, it's all about the facts, not how you feel. Correct?
Correct. Your verdict and the verdict of the jury must be based on the evidence, as I told you, that you hear in this courtroom. And the state has to prove Mr. Loyd guilty. In the guilt phase, they have to prove him guilty beyond a reasonable doubt. The defense has raised the defense of insanity, which they have to prove by clear and convincing evidence. The defense has to prove it.
Okay.
So since I brought that up, let me ask you a question. If at the end of the guilt phase, when you're trying to decide whether he's guilty or not, the defense had convinced you he was insane at the time, would you be able to return a verdict of not guilty by reason of insanity?
Yeah, if everything points to that correctly, absolutely.
Okay. So let's talk a little bit about the death penalty. Do you have a position on the death penalty?
I do not.
Right. Are you someone who has a moral, religious, or personal objection to death?
No, ma'am.
Are you someone who believes, first let me tell you, first degree murder, as I told you, it's intentionally killing someone. You don't have any legal reason to do it. They're not attacking you. It's not self-defense. You just intentionally killed them, right? In order to even discuss death or life, the jury has to have found someone guilty of first degree murder beyond a reasonable doubt. You with me so far?
I am.
Okay, now you're in the penalty phase. You have to decide between life and death. But sitting here right now, without having heard anything else, are you someone who's thinking, if I convict someone of first degree murder, I'm giving them the death penalty?
No.
All right. Are you someone who is thinking, there is no way I'm ever sentencing anyone to death?
No.
Okay. If I add to the fact that the person who died was a law enforcement officer, does that change your answer in any way?
No.
And if I add to the fact that the person was previously convicted of murder, remember I told you he's been convicted of murdering Ms. Dixon and her unborn child, does that change your answer in any way?
No.
All right, you heard me describe what the process is like in the penalty phase.
That's
State
correct.
puts on aggravators, defense puts on mitigators. You have to be able to listen to both sides. You got to listen till the end. I'm not saying you have to believe or disbelieve anything, but you have to be willing to listen to it with an open mind. You can't be sitting there thinking, okay, I'll listen to you and then I'm going to vote the way I was going to vote anyway. You have to listen, process all of this, go back in the jury room, weigh those aggravators and mitigators. Can you go through that process with an open mind?
Yes, I could go through that process without being biased.
All right, and after you're done with that process, if you thought the appropriate sentence was life without parole, can you vote for that?
Yes. Yes, I can.
And if you thought it was death, can you vote for that?
I can as well.
All right. And I think my last question to you is, can you put the conviction for murder of Ms. Dixon and her unborn child aside during the guilt phase? It can be considered in penalty, but not in guilt. Can you put it aside?
Yes.
In other words, you can't convict him in this case because he was convicted in the other one. Can you follow that rule?
Absolutely.
All right, thank you, sir. I don't have any other questions for you, but I believe the attorneys do. Mr. Boxman, you may inquire.
Thank you, Your Honor. Good afternoon.
How you doing, boss?
Pretty good. You?
I'm very well.
I'm going to start with a few questions on the insanity. That's an issue that's going to be dealt with in the first part of the trial, the guilt phase of the trial. The trial part of the trial is going to determine if Mr. Loyd committed the crimes he's charged with.
Okay.
Because insanity involves some issues surrounding mental health, I've got a few personal questions for you. I don't mean to pry, but I got to ask a couple.
Sounds good.
Do you or a close friend or a family member have any experience or involvement with mental health issues?
Yes, my wife's sister actually has not ADHD, autism.
Okay. So based on that, you've obviously been around that individual with autism, right?
That's correct.
So I'm assuming that you believe that mental health issues are in fact real.
Yes, they
Okay,
are.
some people in society don't think they're real, but you don't subscribe to that. Okay. Would you be able to listen to all of the evidence surrounding the insanity defense? For instance, evidence that a mental health issue may be involved in this case. And if it is involved, what the ramifications of that issue are before you make a final decision as far as whether insanity is proven.
If it's presented, yes.
Okay, you can keep an open mind, listen to all the evidence before you decide.
Absolutely.
Okay. Shifting gears to the penalty phase of this case. If the jury finds the defendant guilty of first-degree murder, the guilt phase, we found it beyond a reasonable doubt. The jury has therefore rejected the insanity defense, found that that wasn't applicable in this case. We then would move into what's called the penalty phase, the sentencing portion. In that portion is the juror's job would be to determine after listening to all the evidence presented what the proper punishment should be, life or death. Okay? Now, this is not the time to discuss the details and the specific pieces of evidence that you may hear about the aggravating factors and the mitigating circumstances. That's for the time.
Okay.
The questions that I'm going to be really focusing on are your ability to keep an open mind and listen to everything before you make the final decision. So if we're in the penalty phase of this trial, the jury's already found him guilty, and now we're talking about punishment. The judge talked to you earlier about the fact that the victim in this case was a law enforcement officer. Now, if that is proven to you, that by Florida law is an aggravating factor that you can consider in determining the proper punishment. Make sense?
Yes, it does.
The judge also mentioned the prior murder that the defendant was convicted of his girlfriend, his pregnant girlfriend. That can't be used to determine if he's guilty of the crimes in the first part, but it can be used if you felt it was proven to you beyond a reasonable doubt as an aggravator of the punishment portion.
Okay.
So let's say that the aggravating factors of the victim was a law enforcement officer were proven to you, and the aggravating factor that he had a prior murder was proven to you, and these aggravating factors are starting to move your pendulum over towards, I think death is the appropriate punishment. And the aggravating factors that all the evidence you hear is really bad. It's leaning towards the death penalty. The question I have is, before you make a final decision on what the proper punishment to be, could you truly listen to and consider all the mitigating evidence, the evidence about the defendant's background, his character, his life that's provided by the defense, to see if that may bring your pendulum back towards life before you make a decision?
Absolutely.
Okay. And can you do that regardless of what mitigating evidence is presented to you, regardless of what is brought to you? For instance, say the defendant brings out that, say the defendant suffered the effects of racism as a child. At first blush, you may think, I don't know if that's really mitigating, but can you hold off judgment until you hear all the details and the evidence that deal with that before you make a decision? Can you do that with any potential piece of evidence that's brought to you?
Yes, I can.
All right. So if I were to ask you about 100 different possible mitigating pieces of evidence, would your answer always be, I would listen to it, I would think about it, I would process the evidence, and only then would I make a decision?
So everything will be considered.
Right. And after considering all of the aggravating factors and mitigating evidence, you decide what evidence what of those factors have been proven to you. And if they have been proven to you, you decide what importance or what weight to give that evidence. You can give it a little weight. You can say, it's proven, but it's really not important in my big decision. Or you can say, this piece of evidence is really important to me. You assign that weight.
Okay.
Make sense?
Yes, it does.
If after you go through that process, you feel in your heart that the death penalty is the proper punishment, would you be able to raise your hand, walk in here and say, the defendant deserves the death penalty for what he did?
Yes, sir.
Likewise, if you, after going through that whole process, you felt that life in prison was the proper punishment, would you vote that way as well?
Of course.
Is there anything in your background, your life, or your belief system that you think we should know about, considering we're trying to find jurors that can be completely fair and completely impartial in this type of a case?
Meaning?
If I was watching Monday Night Football last night and I look out the window and someone's driving away with my car, and I'm asked to come and sit in a grand theft auto case,
Okay.
I'm probably not going to be the most fair guy in the world.
Okay, understood.
So that's something in my background, and my experience that may make me not a good juror for that case.
Gotcha.
And there may not be, I'm just asking.
Well, growing up, no, I have been arrested, not for any felonies or anything of the sort, but I mean, I don't have any bias towards anybody or anything. You know, it's either you present the evidence, if it's a fact, and then you follow by it. I don't judge people.
Understood. Were you treated fairly by the police and the system in that prior issue?
Not all the time, I mean, but.
Would that affect your decision here at all?
No, not at all.
Okay.
Not at all. Everybody's different, you know? You just got to present what's available, take it into consideration, and then make your decision.
All right, that was asked.
All right.
Thank you, sir.
No problem.
Other questions, Your Honor?
Thank you, Mr. Bruxman. Ms. Miller, may I inquire?
Hello.
Hello.
Just a couple follow-up questions.
Okay.
And so something you said resonated with me, where you were like, it's about the facts, not my feelings. Right? Do you remember saying that?
Yes, ma'am.
So if we're in the second part of this trial, right, it's like a big trial broken up into two kind of mini trials. The first part is, can the state prove Mr. Loyd guilty beyond a reasonable doubt of these crimes? With me?
Yep.
Or can we prove him not guilty by reason of insanity?
Okay.
Okay? Only if he's found guilty of murder in the first degree do we go to the second part of this trial, right? Where then you as a juror would be asked to decide life or death.
Correct.
Okay? The steps of how we get to even considering the death penalty at the end of this second part. Has the state proven the existence of at least one aggravating factor? Okay? Is that aggravator sufficient to warrant the death penalty? Does the aggravation outweigh the mitigation? And the last question is death the appropriate penalty?
Mm-hmm.
And the answer is never required to be yes. Death is never required in any case, right? So you could say yes, 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 and still vote no.
Mm-hmm.
And there is no right or wrong answer. You have to apply the facts and the law as the judge gives it and vote with your conscience.
Exactly.
And so it's kind of a hybrid of hearing the facts, knowing the law, but still your feelings and your conscience come into play. Does that make sense?
I understand.
Okay. And so I want to back up just a little bit. When we talk about somebody who's found guilty of first-degree murder, murder in Florida, first-degree murder, is the intentional, premeditated killing of an innocent victim. That defendant thought about it, he meant to do it, and he did it. For you, is the death penalty the only appropriate penalty for somebody who commits that crime?
No.
Why not?
I mean, because there's not enough behind. I don't even know how to put it. Without hearing somebody's statement of what was going on in their mind during that time, what ended up happening, what was the situation, I can't really answer that question, you know, because at the end of the day, again, like I said before, it all depends on the subsequent facts, basically.
Okay.
I need to know what happened and what was the situation and what was going on in that person's head before I can undeniably say that person deserves death.
Okay, and I just want to clarify, I hear you, I get it. I just want to clarify one thing. So insanity, right, is it's a mental state.
Mm-hmm.
The defendant couldn't choose between right and wrong, basically, okay?
Mm-hmm.
I'm paraphrasing and oversimplifying.
I
Bear
got
with
you.
me. And so if you find somebody guilty to decide life or death, you would have ruled out not guilty by reason of insanity, okay?
Okay.
It doesn't mean that there's not other things going on. You just didn't think there was a defense to the crime. Does that make sense?
That does make sense.
Not guilty by reason of insanity means not guilty. There could be other mental health issues or other things going on. Could you still consider those things even if it didn't rise to meeting that definition of insanity? Does that make sense?
You kind of lost me.
Okay. So what's going on in a person's head is certainly relevant, okay? In the first part of this trial, if you're selected as a juror, you would be tasked with deciding if the state's proven Mr. Loyd guilty, right?
Correct.
And also if we've proven him not guilty by reason of insanity.
Correct.
And even though not guilty by reason of insanity is saying, I did it, but I was insane, it's still not guilty. Does that make sense?
I get what you're saying.
So if he's not guilty by reason of insanity, we don't even get to this second part where you decide life or death. With me?
Okay.
And so I just want to make sure that we're on the same page, and I think we are, that you're still able to consider what's going on in his mind, even if it doesn't meet the definition of insanity.
Of insanity.
Does that make sense?
Yes, ma'am. So, yes, of course.
Tell me why.
Because at the end of, so the word for insanity itself, that word itself is, to me, boggling. Because I could be insane right now, but you wouldn't know.
True, you don't seem insane.
Exactly. So, I mean, at the end of the day, again, it's all about the facts that is presented. Whether, I don't know how to actually get it out. I just need to hear.
Okay.
I need to hear from the goat's mouth, as they say.
Right, I get it. You're in healthcare, correct?
That's correct.
You are a COVID swabber.
That is correct.
Have the last 18 months been miserable?
No.
I have many follow-up questions for another time. The questions we asked about I asked and the state and the judge asked about somebody being guilty for first-degree murder and death being automatic for you, and you said no. Would that change if the victim was a law enforcement officer? So follow me. Some people say if you kill a police officer, then you are deserving of the death penalty without any other consideration. Is that you?
No.
Why not?
Because everybody's human. Police officers, I mean, they just have a badge. You know, everybody should be put in the category as the exact same as a human being, not just because of their title.
Okay. And as Mr. Buxman discussed, when we're in penalty phase and the state has to prove an aggravator before the defendant is eligible for the death penalty, killing a law enforcement officer is an aggravator. That's why we talk about it. And some people, we already talked about it. Same line of questioning. If somebody has been previously convicted of another murder and is serving life in prison, some people say for this murder, death is really the only appropriate penalty. How do you feel?
And then I would start leaning towards the death penalty when that evidence do come into play.
Okay, and you can, again, the defendant having a prior conviction for murder is an aggravator. And so it can certainly lean you towards the death penalty. The question is, hearing that alone without anything else, are you saying, you know, I'm really not going to be able to consider anything else if I hear about this prior murder conviction and life sentence? For this second murder now, death is the only appropriate penalty. Does that make sense?
Yeah, that's not how I feel. Again, like you always have you been saying, there's aggravators and mediators. I think that's what you were saying.
Yep.
Well, it all depends. You got to outweigh each other. You know, you just weigh all options, weigh all responses, all evidences, and then you make your conclusion. You know, things will stack up, things will decrease. It all depends on how the case goes.
Okay. Well, let me talk to you about a couple things, legal points. Death is never required. We already discussed that.
Yes,
not in
ma'am.
any case, not in the worst conceivable case you can imagine. If one juror votes for life, then the verdict will be life. Okay? Mitigation, you're going to hear it a lot. It literally just means why one juror would choose life or not choose death. It doesn't have to be unanimous. It can be unique to each individual juror. You don't have to agree on it. And it can be even something seemingly small, like a smile between the defendant and a family member, where for that juror says, I saw that and I assigned the weight of life to it, right? So some of these aggravators are huge, right? Prior murder convictions, law enforcement officer, that sort of thing. And mitigation could be something seemingly small, and a juror can still say, for me, in this case, I assign the weight of life to that, and I'm not voting for a death sentence. Make sense? With me?
Yeah, I'm with you.
You agree to that? Agree with that? Tell me what you're thinking, please.
Ins and outs. Again, I don't want to come in here with the mindset of this is what I think immediately, you know? I mean, everybody has their own opinions. You know, everybody has their own way of how they see life. You wasn't raised the same way I was.
Right.
And, you know, so it all comes down to individual judgment. And when that comes to the point, like I said, it points out to the ins and outs, the ways.
Right, and I'm not giving that example about the smile between the defendant and saying you have to find that mitigating. I'm saying that somebody could find that mitigating even in the face of huge aggravators and still vote for life. Does that make sense? Okay.
Absolutely.
In order for a just verdict to be returned in this case, all 12 jurors' individual moral assessments about whether Mr. Loyd lives or dies have to be heard in this courtroom.
Okay.
That's your duty, your right, your responsibility as a juror to make sure your individual moral assessment is heard in this court. Okay? So the foreperson, whoever selected to be the foreperson of the jury, writes down the verdict. But in the second part of the trial, in doing so, that foreperson is really just saying, I am writing down that this is reflective of all 12 individual moral assessments. Make sense?
Understood.
Sometimes things can get contentious while people are deliberating. Strong opinions, people have differences of opinions.
Mm-hmm.
You would certainly not bully or badger anybody to agree with you if they had a different opinion, right?
That's correct. I would not.
And you're not going to let anybody bully or badger you if you've come up with your individual moral assessment.
And that is correct.
In fact, if you've reached an individual moral assessment that the verdict should be life and it's not being respected, you can say, hey, listen, we're done here. I've reached a verdict. Go ahead and write it down. Deputy, please get the judge. We're done. We can go home. Can you do that?
Yes.
You have just a moment, Your Honor?
Yes, ma'am. All right. Thank you, ma'am. Other side need to approach?
No, Your Honor.
All right, sir. We're going to send you through to the final round of questioning, and it is the final round.
Okay.
We're taking your badge because we're changing your color to purple.
Oh, right, my favorite color.
We call folks by color, so now you're listening for the purple group to return.
Okay.
I don't know when you're coming back. I don't have enough people to call you back yet. I suspect it'll be next week, but just in case, start calling tomorrow night.
Okay.
And all you're listening for is purple dots return. If you hear nothing about purple, you don't have to come back yet.
Okay.
The day you come back, we're picking the jury and we're sequestering the jury, so you need to have packed. And leave the suitcase in the car. In case you get picked, we'll go get it. If not, you won't need it. We're giving you a packet. It has a couple of things in it. Number one, it's got the slip of paper that tells you the phone number to call to determine when you're coming back. It has a jury sequestration packet that tells you about being a sequestered juror in more detail, gives you a list of things we suggest you bring with you. And lastly, we have a letter for your employer telling them that you have been called back to report again to jury duty. Any questions?
None at all.
Thank you so much for your patience today. You have a good day.
You
You're
too.
free to go.
Thank you. Appreciate it, boss.
Juror in seat number 60.
Have him right outside.
Grab him. What'd you give him? Oh, dear Lord. Okay. Give me 1 second. I'll be right with you. Did you give them the paper he's supposed to have? Oh, okay. No, I meant, did you give the deputies the one with the correct name? Oh, okay. All right. Good afternoon, sir. How are you? Okay. All right. I have a few questions for you. There aren't any right or wrong answers to this. The reason we're asking you these questions is we need to determine, and you need to determine, whether you can do your job as a juror in this type of case. So the only correct answer is the truth. Just be honest, all right? Let me start with, you haven't heard anything about this case, correct? Okay, you need to move the mic a little closer to your mouth. Okay, yeah. The mic is a mystery, honestly, as to when it works and when it doesn't. Do you have a position on the death penalty? Have you ever thought about it before we brought you in? Okay. And all right, what were your thoughts? Have you ever talked about it with someone?
Oh, yeah, with friends all the time.
Let's try that one, see if that one's better.
A lot of the time.
And what was the content of that conversation?
It depends. There's a lot of things that go into it.
Okay. Let me go over in a little bit more detail for you. The death penalty in the state of Florida. As I told you, there's no automatic death penalty in this state. In order to even have a conversation about it, a jury has to have gone through a guilt phase and found someone guilty beyond a reasonable doubt of first-degree murder, intentionally killing someone with no legal reason for doing so. For example, it wasn't self-defense. There's no legal reason to kill this person, and you did it on purpose, right? So the person's been found guilty. Now you're in a penalty phase. Are you someone who believes that having found, and this is the only information you have, having found someone guilty of first-degree murder, you are always going to sentence that person to life? You're not even going to consider death?
Consider death, consider all the options.
All right. On the flip side of that, are you someone who believes that if you found someone guilty of first-degree murder, that person needs to die? You're going to vote for death every time?
Because it's situated. It really does.
So if I add to that fact, you found someone guilty of first-degree murder of a police officer, does that change your answer?
No.
And if I add to that, the person has been previously convicted of a murder, does that change your answer? Okay. As I told you, again, to even get to a penalty phase, you have to have made the decision that someone is guilty of first-degree murder. In the penalty phase, you have to listen to the state's aggravators. They're going to present evidence of that. Defense is going to present evidence of mitigators. You have to listen with an open mind. An open mind does not mean I'm sitting there listening until we get to the end so I can vote the way I was going to vote anyway. It means you're listening, you're absorbing the information, you're processing it. You're going to go in the jury room, weigh all these aggravators and mitigators. Can you go through that process with an open mind?
Yes, I'm looking at every situation with an open mind.
Okay. And if that process led you to believe that death was the appropriate sentence, could you vote for that?
Yes.
If it led you to believe life without parole was the appropriate sentence, could you vote for that?
Yes.
I told you that Mr. Loyd has raised the defense of insanity. That would occur in the guilt phase when you're trying to decide whether or not he's guilty, all right? If at the end of that, and the burden's on the defense to prove that one, state puts on their evidence, defense puts on their evidence, it's the end of the guilt phase and you're thinking, you know, they convinced me, I think he was insane at the time. Could you return a verdict of not guilty by reason of insanity?
Yes.
And lastly, as I told you, he's been previously convicted of the murder of Miss Dixon and her unborn child. She was pregnant at the time. Can you put that out of your mind in making a decision about guilt?
Yes, this is a separate case, yes.
All right. You can consider it in penalty, but you cannot consider it in guilt. Can you do that?
Yes.
All right. Thank you, sir. I don't have any other questions, but I believe the attorneys do. Mr. Buxman, you may inquire.
Thank you, Your Honor. Good afternoon, sir. I want to start with a couple questions on the insanity issue. That is something that's going to be addressed in the guilt phase of the trial, the portion of the trial to try to decide whether or not Mr. Loyd committed the crime. Because the insanity defense brings with it some issues regarding I have a little more personal questions for you about that. Do either you or a close friend or a family member have dealt with or experienced mental health issues?
I was in my program for psychology, and I was actually going for my master's in social work. And I had a lot with that.
So you're familiar with it, I guess, more than the average person?
Oh, yeah.
All right. Based on that experience and that interest, I would assume that you believe that mental health issues are in fact real in society with some people.
Oh, yeah.
Okay. Would your additional knowledge and experience in that program, that psychology program, would that hinder your ability to listen to the evidence, or would it enhance your ability to listen to the evidence and come to a conclusion?
I think it would enhance it because I understand it.
Sure. Would you be able to hold off making the final decision on insanity until you heard all the evidence surrounding the mental health issues in this case, if there are mental health issues in this case, and if so, what the consequences of those issues would be to the defendant's actions?
Yeah, not until everything has been presented to make a decision.
Stepping on to a different area now. For these questions, let's assume the jury has found the defendant guilty of first-degree murder. The jury has rejected the insanity defense, and we're now moving into a penalty phase, or what the proper punishment should be for the first-degree murder. The focus of these questions is really to see if you would be an open-minded and be able to consider all of the different evidence that is presented to you. And that's kind of the crux of my questions here. Before we get there, though, you mentioned that you have had extensive discussions about the death penalty with friends, coworkers, things like that. Were some of those discussions had during your educational background or your psychology courses or anything?
I've had that discussion multiple times with family members and friends.
If, let's assume you're in school, you're told by your professor, you got to write a paper on the death penalty. You got to choose pro, you got to choose con, and you got to explain why you chose that. What position would you take?
It's situational. It really does depend on a lot of factors. Okay. I mean, there's other extenuating circumstances. It's situational per case.
Can you elaborate a little bit?
Yeah, my coworkers were always, there was always the two extremes, but I always found myself in the middle of every discussion about it, because it's saying, well, what if this happened, or what if that happened? Because that changes it, and then you change their point of view because new evidence came up.
So I'm gathering from your answers, you're pretty much down the middle of the road. Some cases it may be appropriate depending on the evidence, some cases it may not.
Yep.
Fair enough, okay. The judge went through a thorough explanation of the death penalty process. So I just have a few different things. If we're at the death penalty stage in this case, the state would present evidence of aggravating factors. And you heard that we had a discussion with the judge about one of those aggravating factors could be that the victim was a law enforcement officer. And you've already said that just because the victim was a law enforcement officer, you wouldn't automatically vote death regardless of any of the other evidence, right? So let's say that the fact that the victim is a law enforcement officer was proven to you beyond a reasonable doubt. That is something as an aggravator that you can give whatever weight you felt appropriate to it. The judge also indicated that the prior murder of the defendant's girlfriend could be considered an aggravating factor, and if proven beyond a reasonable doubt, you can give weight to that. Make sense?
Yep.
So, say we have victim's a law enforcement officer, has a prior murder, and those aggravating factors are starting to move you towards the pendulum of the death penalty is the proper punishment. Can you hold off a final decision until you hear all the evidence of the mitigating factors? The mitigating factors meaning evidence of the defendant's background, character, things like that.
Oh yeah, I wouldn't make a decision until it's all presented.
Okay, because who knows what that mitigation could do to your thought process.
Yeah, exactly.
All right. Would you be able to listen to and truly consider and mull over in your mind any and all mitigation evidence presented to you before making a final decision?
I'd like to consider this.
All right. If, after going through that process, that weighing process, you felt, deliberating with the other jurors, you're talking about it, and you feel in your heart that life was the proper punishment in this case, could you come back and vote for that?
Yeah.
Likewise, on the other side of the coin, if you felt, not in a hypothetical situation, but you in this situation, if you felt that the death penalty was the proper punishment, you come back in this courtroom or raise your hand and say, I vote that this person deserves to die.
Yep.
Is there anything in your background, your experiences, your belief system that may make you not a good juror for this type of a case? And you brought up the psychological experiences and the classwork that you've done. Anything else that you could think of?
Nothing I can think of, no.
Okay, and not to imply that your psychological, your educational background in psychology would make you unfair, just as a factor of your life and your belief system. Oh, right. Nothing else?
No.
All right. One last question. You also, I noticed, work as a security guard.
Yes.
The fact that this case involves the murder of a law enforcement officer, would that, the fact that you work in a similar capacity as a security guard, would that affect your ability to be an impartial juror in this case?
I think it has a choice on what career they go into. So, I mean, it's all weighed the same.
Thank you, sir. I appreciate your time. Thank you, Your Honor.
Thank you, Mr. Buckman. Ms. Miller, Manhunt.
Hello. I just want to make sure. You have a BA in psychology
Yes, ma'am.
and currently in a master's program?
One semester away from the social work program.
Okay. Is that at UCF?
Yes, it was.
You discussed with both the judge and Mr. Buxman having extensive conversations with friends and colleagues about the death penalty. Tell me about those conversations.
They would always go in with, oh, well, if they've never suddenly made that choice, then yes, they should be put to death. But I would always say that there's situational things because there is, people do go crazy in situations. Blackout, things like that. That's what I would bring up.
Okay. And I'm not trying to belabor the point. You guys have discussed it at length, but insanity has been raised as a defense by Mr. Loyd, right? And so myself and my colleagues are going to try to prove that he was insane at the time of this crime. If we're in the second part of this trial, right, that means you would have rejected that as a defense. Does that make sense?
No, that works for
Okay.
me.
So if somebody's not guilty by reason of insanity, he's not guilty.
Yeah.
Right? And that means we're not getting to the part where you decide what the sentence is because he's not guilty.
Yeah.
With me? And so some people say, you know, if it's not insanity, it's really not going to matter to me. And so when you talk about things that are going on in somebody's head, I just want to discuss that a little bit more, knowing that if we're talking about penalty, you've already rejected the defense of insanity. Does that make sense?
I was following around the beginning.
Okay, let me try again. So somebody can have mental health issues, right? And they may not rise to being a defense to the crime of murder, right? Being a defense to the crime is a pretty high burden. Get it?
Yeah.
But there still may be mental health issues in play.
Yep.
Right? And so even if you've found somebody guilty, so if you've rejected the defense of insanity, you could still consider mental health issues even if they didn't rise to meeting that narrow legal definition of insanity. Does that make sense?
Yeah, we could, yes, yeah.
Do you think you could do that?
Yes.
Okay. One of the other things that you may hear evidence of is the effects of racism, right, on the defendant. And so when we talk about giving something meaningful consideration, it's not, oh, I heard it, and then I'm equally dismissing it. You know what I mean? It's, I'm hearing this, I'm internalizing it, and it could potentially sway me one way or another as to what the appropriate penalty is. Does that make sense?
Yes.
Do you think you could give meaningful consideration to something like the defendant experiencing the effects of racism?
Yes.
How come?
In the program, we studied racism and how it affects, like the invisible backpack, gender inequality in the workplace and other places. So racism does play a factor in decision making.
Even on somebody who kills a police officer with intent in a premeditated manner?
Yeah, it's one of the factors in the situation.
Okay. Death is never required, not in any case. Okay, and so the process, if we're in the second part of the trial, and it's a penalty phase, the state has to prove the existence of at least one aggravating factor, as they discussed, right? Is that aggravator sufficient to warrant the death penalty? Does the aggravation outweigh the mitigation? And then the last question is death the appropriate penalty? And the answer never has to be yes to that last question. You could say yes, 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 and still vote no. I'm not imposing death. Make sense?
Yep.
If one juror decides that life should be the appropriate penalty, then life will be the penalty. Make sense?
Yep.
We're going to talk about mitigation a lot. It is a legal term that means one juror would choose life or not choose death. It does not have to be unanimous. It can be unique to each individual juror, and it can be even something seemingly small, like a smile observed between the defendant and a family member. For that juror says, I saw that, I life, I'm not voting for death. Okay? In order for a just verdict to be returned in this case, all 12 jurors' individual moral assessments about whether Mr. Loyd lives or dies have to be heard in this courtroom. It would be a miscarriage of justice if one juror's individual moral assessment wasn't heard. That's your duty, your right, and your responsibility as a juror, is to make sure your individual moral assessment is heard in this courtroom. Okay? Sometimes when people are deliberating, they can get contentious, right? People, like when you talk about your conversations, people have strong opinions about these things. You would not bully or badger anybody to agree with you, right?
We all have their own opinions and perspectives, and that's what makes us all unique.
Yep, and that's what the law calls for, right? And you're not going to allow anybody to bully or badger you to changing your individual moral assessment, right?
No, definitely not.
I didn't think you were going to say yes to that. If you have reached an individual moral assessment and the verdict should be life, and it's not being respected, you have the right to say, hey, we're done here. I've reached a verdict. Deputy, please get the judge. We can go home. Can you do that?
Oh, yeah.
May I have just a moment, Your Honor?
Yes, ma'am. Either side need to approach?
No, Your Honor.
All right, sir. We're going to send you through to the final round of questioning. We will be picking the jury that day. So a couple of things are going to happen today. First of all, if you could give that badge to the deputy, please. We're going to change your color from yellow to purple. So I told you, we use the color to tell people when to come back. There's too many of you to call out numbers. So we're going to give you a packet. It's got several things in it. It's got a slip of paper with a phone number that you need to call to find out when you're supposed to report back for the final round of questioning. You're listening for the purple group. If you hear nothing, you haven't been called back yet. Eventually, you're going to hear purple group return. Don't bother calling before tomorrow at 5. The earliest you would be back is Friday, but I strongly suspect it'll be next week that we call you back. The day you come back, we're picking the jury and sequestering the jury. So you need to have packed a suitcase. Just leave it in your car. If you get picked, we'll make arrangements to get it picked up. If not, just drive home with it. There's a sequestration packet in there that gives you more detail about being sequestered as a juror. It also gives you a list of things we suggest you bring with you. And lastly, there's a letter in there for your employer to let them know that you're being called back for one more day of jury duty. Should you be picked, we'll give you a different letter for your employer. Any questions?
So I just call that number every day just to confirm
Starting tomorrow after 5, okay? And eventually you'll hear the purple group's being called back. I don't have enough jurors to call you back yet, so I can't tell you the date.
Okay.
Okay? Any other questions?
No.
Thank you so much. You have a good afternoon. All right. That was the last juror from panel number 7. We're switching to panel number 8. I can't hear a word you're saying. What? Sure. 5 minutes. All right, we're back on the record on State versus Loyd. Mr. Loyd's present with his attorneys. The state attorney's office is present. All right, we're on panel 8. Juror in seat number 3, please. One, two, three. Panel 8, we've got 3, 4, and 8. What? He's coming in at 9 o'clock tomorrow. Sure. Good afternoon, sir. How are you? Okay, we have a few questions for you. I'm going to start, and then the lawyers will probably have some questions for you. There aren't any right or wrong answers to these questions. We're asking you questions to determine whether or not you're able to do your job as a juror in this type of case. We all need to know it, including you. So the only correct answer is the honest answer. Just tell us the truth and we'll be fine. Let me start with, you've heard something about this case, is that correct?
Just on little news clips is all.
Okay, you got to move the mic closer to your mouth, sorry. The what?
News clips?
The news?
Yeah, 'cause I don't.
All right, what do you remember seeing from news clips? Anything? Okay. Did you form any opinion as to whether or not Mr. Loyd is guilty based on what you saw? In these cases, jurors have to be able to, in all criminal cases, jurors have to be able to presume the defendant is innocent unless and until the state proves they're guilty beyond a reasonable doubt. Can you do that in this case? All right, do you have any position on the death penalty? Yes. You what? If it's warranted, you're for it? Okay, what do you mean by that? I'm really having trouble hearing you. Is that mic working? Is it on? Nope. No, that mic is not working. Is it on?
This one. Can you hear me now?
I can hear you now.
I can hear me now, too.
All right, so tell me what you mean by if it's warranted.
It depends on what the person did. I mean,
okay.
Because shoot a child, that would be, in my opinion, that would be warranted.
All right.
Okay, many things.
So as I told you, there's no automatic death penalty in the state of Florida. It doesn't exist, even for shooting a child. We have a process, all right?
Well, you got to convict me first.
Okay, well, that's what we're going to talk about. First, you have to convict someone of first-degree murder, and first-degree murder is intentionally killing someone when you have no legal justification for doing it. It's not self-defense, you just intentionally killed someone. So, if you convicted someone of first-degree murder, would you automatically vote for death? Would you be thinking, first-degree murder, I'm voting for death? All right, let me add a fact to that. If it was first-degree murder of a law enforcement officer, would you be thinking, I'm voting for death?
No, I don't think it would automatically.
Okay. If you heard that the person had a prior conviction for murder, would you be thinking, I'm voting for death? No? Is that a no?
Sorry.
You have to answer out loud. Remember what I told you? Is that a no?
Question again, I missed it.
If someone had been convicted of another murder, they had a prior murder conviction, would that cause you to, without listening to anything else, just, I've convicted him of first-degree murder, I'm voting for death?
No.
All right. You heard me describe what the process is. First, there's the conviction. Yeah, and without that, nothing happens, right? So now there's a penalty phase. State's going to put on aggravators, what they believe are the reasons that you should vote for death. Defense is going to put on mitigators, what they believe are the reasons you should vote for life without parole. You're required as a juror, in order to do your job and follow the law, you have to be able to keep an open mind about this, all right? Meaning, you can't be sitting there thinking, yeah, go ahead and talk, and then so I can get to the point where I can vote for what I was going to vote for anyway. You have to be actually listening to what's going on, processing it, you know. Then you're going to go back in the jury room, you're going to weigh aggravators and mitigators, you're going to reach a verdict. Can you go through the process of the penalty phase and the weighing with an open mind?
Yes, ma'am.
And if that led you to believe that the appropriate sentence was life without parole, can you vote for that?
Good.
And if it led you to believe that death was the appropriate sentence, can you vote for that?
Yes, ma'am.
The insanity defense, as I told you, Mr. Loyd has raised that. When you're in the first phase, in the guilt phase, you're trying to decide whether he's guilty or not. It's the defense's burden to raise and prove insanity. So let's say you're at the end of that phase of the trial. State's put on all their evidence, defense has put on all their evidence, and they've convinced you he was insane at the time. If that was true, could you return a verdict of not guilty by reason of insanity?
Yeah, I believe so.
You'd listen? Could you vote not guilty by reason of insanity?
Yes, I believe good. Good.
Okay. And then my last question to you is, remember I told you he'd been convicted of the murder of Miss Dixon and her unborn child. She was pregnant at the time. Can you put that out of your mind when you're trying to decide whether he's guilty or not of this case?
Sure, yes, ma'am.
You can consider it in penalty, but you can't consider it in guilt. You understand that?
Yes,
All right, sir, thank you. I don't have any other questions. Mr. Williams, you may inquire.
Thank you, Your Honor. Good afternoon, sir.
Okay.
When you came in as a prospective juror, they asked you to answer some questions in writing, and then you turned them in. And there were a number of questions that were left blank on your...
Well, I messed up when I was filling it out. I did it on the computer.
Okay, so are you currently employed?
Disability.
Disability, okay. So, like, is that sort of retired? Would you consider yourself retired?
They retired me to consider me no longer employable.
Okay. Could you repeat your answer for her, please?
They consider me no longer employable.
So, okay. How long have you lived in Orange County?
About 3 years.
Right, and where'd you live before that?
In Georgia.
Okay. Bless you.
Valdosta, Georgia.
Valdosta, Georgia. All right, thank you, sir. So you previously, you were able to answer one question, that is that you were on a jury before?
Oh, that was, that's been a long time ago. Yeah, I was on a jury before, but it's been years ago.
Like more than 10 years ago?
Probably, yeah.
Okay. Do you remember if the case was criminal or civil?
It was a divorce.
It was a divorce. Okay. Did you actually deliberate and reach a decision?
Yes, yes, sir, we did.
Don't tell me what it was. Were you the foreperson?
No.
What did you think about going through that process as a juror?
Yeah, it was okay to me. I mean, they did the evidence, we went and talked about it, and then said what we were going to say, or made the verdict.
Okay. Anything about that that makes you want to be a juror in this case or not want to be a juror? What do you think, or could you share your thoughts with me or us about being a juror in this case where murder is the charge and the death penalty is a potential option?
You have to do your duty, do what you're supposed to do.
I'm not asking you to speak up because I can see
I'm sorry.
you talk really loud. It's okay.
You have to meet your responsibilities.
Okay, there you go. So you view it as your responsibility to serve?
Yes, sir.
Okay. Thank you, sir. So, have you or someone close to you ever dealt with mental illness?
No, sir.
There are those in our community who think that mental illness is not a real thing and that it's made up as an excuse. Do you feel that way?
No.
Right? Tell me about that. What do you think about mental illness?
Well, it exists.
You think it's real?
Mm-hmm. Yes, sir.
Okay. And if it were proven to you by the defense, given that belief that Mr. Loyd was insane at the time he committed this crime, could you find him not guilty by reason of insanity?
I could.
Keep that voice up.
Okay. I could.
All right. So I heard you tell the judge at least 3 times with different questions that the death penalty would not be an automatic sentence for you if Mr. Loyd were found guilty of first degree.
Yes.
Can you tell me why it wouldn't be automatic in any one of those scenarios that she posed to you? And these are not easy questions, so you need to take a moment, take all the time you need.
Well, maybe because you have to prove to me, I call it malice.
You call it malice?
Malice,
Okay.
malice, murder, or malice, whatever. You have to prove him guilty first, and then you have to prove I guess the malice be the right word?
The aggravators?
Yeah, aggravator.
Okay.
Sorry.
Is that the word you were looking for? All right. You're right. For the death penalty to be an option under Florida law, if Mr. Loyd was convicted of first-degree murder, we would have to prove at least one aggravator beyond a reasonable doubt. Do you remember what other evidence you would hear beyond aggravators that the judge was talking about?
The defense side.
Defense side?
Mediators?
Mitigators.
Mitigators.
That's right. And that would be anything in Mr. Lloyd's background or life experiences that they would argue to you are reasons why life without the possibility of parole would be appropriate. I'm sorry?
I said yes.
The key part to the process that was described to you is a willingness to consider everything before making the final decision. Would you agree with that?
Yes, sir.
So my question is, if you heard evidence that you used the word heinous a long time ago, you remember using that word? And it's okay. If you heard evidence that not only was a law enforcement officer murdered in this case, but that the murder occurred when she was on the ground and defenseless, and she was shot from close range, was intentional, like, you with me? And the judge told you that being a law enforcement officer was an aggravating factor under Florida law. She kind of alluded to that when she said you would consider it in the sentencing phase, but not in the case. Does that make sense?
Yes, sir.
Even if you found that situation to be aggravating, could you still listen to the mitigating circumstances before making a decision?
Yes.
Okay. If the defense were to present evidence to you that Mr. Loyd had suffered the effects of racism when he was throughout his life, could you give that meaningful consideration?
Yes.
You would decide how much weight to give it or how important it is, but you would be able to consider it.
Yes, sir.
Or if it were proven to you that he had had a difficult upbringing in his life, could you consider that?
I could.
Do you have any concerns about your ability to fairly and impartially go through this process as we've described it?
No, sir.
Is there anything in your life or background experiences that you think we should know about you, given that we're trying to select the most fair and impartial jury possible?
I don't think so. No, sir.
That's all I have. Thank you, sir. Thank you, Your Honor.
Thank you, Mr. Williams. Remember, remain quiet.
Hello.
Okay.
Whoops. It's been a long day. I apologize for asking you some personal questions.
Okay.
When the judge was speaking to you last week, I believe you discussed having neck pain.
Yeah, it's vertebrae.
Okay. And you have to take medication for that? I'm sorry, I thought you told...
No.
Did you tell the judge you had to take meds last week, or did I mishear?
Okay, no, I don't believe I did, no.
Okay, just you have neck pain and that occasionally you would need to take breaks?
They give me a topical cream that you put this for, what do you call it, inflammation.
Okay. And does that help?
Yeah, it does.
Otherwise, are you in pain?
Not a lot. It depends on what I do, which I learned not to do to make it.
Right. You're like, I'm not going to do this thing that exacerbates the pain?
Yes, ma'am.
Okay. Is it something that would affect you sitting as a juror in this case?
I don't think so.
Do you think you would experience pain sitting in that chair for long periods of time?
I'll get up and move around a little bit.
Okay. You discussed with the judge, too, today, that if someone murdered a child, that for you, death would be the only appropriate penalty in that circumstance?
Not necessarily.
Well, do you recall having the conversation with the judge about?
I said that would be a heinous crime to me.
Sure, I think everybody would agree with that. When you talk about the murder of a child, would you consider the murder of an unborn child, right? So a pregnant woman gets murdered.
Yes, ma'am.
Would you consider that in the same circumstances as you discussed the murder of a child?
Yes.
Okay. And so I want to make sure we're on the same page. I'm not trying to belabor the point, okay? This trial is really broken up into two different parts. The first part is where the state has to prove Mr. Loyd guilty beyond a reasonable doubt.
Yes.
Or we have to prove him not guilty by reason of insanity. With me?
Yes, ma'am.
The second part of the trial may never happen. It's only if he's found guilty of first-degree murder do we decide what the penalty is, right? That makes sense.
Yes, ma'am.
And so I just want to make sure, again, so we're on the same page. Murder in Florida is defined as the intentional, premeditated killing of an innocent victim. That defendant thought about it, he meant to do it, and he did it. And if he was found guilty of murder, that jury that made that determination would have eliminated any defense available to him, right? Like self-defense, that's a defense to a crime. And so anything like that, the jury who found him guilty would have said, no, he committed the crime of the intentional premeditated murder of an innocent victim, and he didn't have any legal excuse, justification, or defense. With me?
Yes, ma'am.
Is death the only appropriate penalty for somebody who commits that kind of crime? Excuse me.
I don't think so, ma'am.
Why not?
You have to do case by case, or I know, to me.
Sure.
Each case is going to be different.
Sure, and that's where we've talked a lot about what the law is and what the law is going to ask of you if you are selected as a juror.
Yes, ma'am.
Right? Right now, you are a prospective juror.
Okay.
And the only oath you've taken is to tell the truth.
Yes, ma'am.
And so we're having these conversations, if it were a month ago, right? We're just talking about the death penalty, what your feelings are, before you knew you were involved in this case. Does that make sense?
Yes, ma'am.
Okay. On top of it being the murder of an innocent victim, it's the murder of a law enforcement officer. In the scenario Mr. Williams just described,
Yes, ma'am.
right? Execution style, standing on top of someone, all of those things. Is death the only appropriate penalty for you in those circumstances?
No.
Why not?
There could be a lot of other reasons why he did it than just shooting him.
Okay, because he wanted to.
Wanted to, or he could be insane, I don't know.
Right, that's, could be insane. Right, that's what you said?
He could be.
Sure, and I'm glad you brought that up. So insanity is a defense to the crime.
Yes.
Right, if you found somebody not guilty by reason of insanity, you're finding that person not guilty. So we're not determining a penalty because the person's not guilty. Does that make sense?
Yes, ma'am.
And so knowing that this defendant who committed this heinous murder of a law enforcement officer wasn't insane, right? Because if we're talking about penalty, you would have eliminated that as a defense. Is death the only appropriate penalty?
Let's see. I think so, yes.
Okay. And then the other thing I want to ask you about is, you have heard that Mr. Loyd has been previously convicted of another murder of Sade Dixon, and she was pregnant. So it was the murder of Sade Dixon and her unborn child,
Yes, ma'am.
right? And so the judge went through great detail in saying, if you found this person guilty, well, let me try that again. Scratch that. You cannot use those facts in determining whether Mr. Loyd is guilty of this crime, right?
Absolutely.
Just because he was guilty of that doesn't mean he's necessarily guilty of this. Make sense?
Yes, ma'am.
But you can use it in deciding what the appropriate penalty is here. And so because Mr. Loyd has been convicted of another murder of a person who was pregnant with an unborn child, does death now for this second murder become the only appropriate penalty for you?
No.
Explain that to me when you talked about unborn child being the same as child.
You have to prove to me why you did it or what the circumstances were. You can't just say death penalty.
Right, that is the law, right? Is that, and there are truly no right or wrong answers here, right? We all, myself included, want to follow the judge's instructions, the rules, and the law. It's just about how you feel, right? And so some people say, listen, I hear you, but if I knew the defendant had been previously convicted of the murder of a pregnant woman and he committed another murder, then death becomes the only appropriate penalty.
We've been trying for that, so.
Right, but it is, and I don't want you to think it's not going to come up. It's going to come up if we get to the second part of this trial. And so that's the question is, knowing that fact, is death the only appropriate penalty in the second murder?
Objection, asked and answered.
Sustained.
You would probably not be surprised to learn that folks can have differing opinions on these sort of things, right?
Yes, ma'am.
12 people coming from different walks of life often feel very differently about things like the death penalty or whether somebody should live or die. Fair?
Yes.
Death is never required in any case, not in the worst conceivable case you can imagine, okay? And if one juror thinks that life should be the penalty, then life will be the penalty. Does that make sense? In order for a just verdict to be returned, all 12 jurors' individual moral assessments have to be heard in this courtroom about whether Mr. Loyd lives or dies, okay?
Yes, ma'am.
You're not going to bully or badger anybody to agree with you.
Nope.
And you're not going to let anybody do that to you.
No, ma'am.
Thank you, sir. I have no further questions. I do have a motion.
All right, let me see the attorneys at the bench.
All right, sir, let me clarify a couple of things with you. Remember what I told you the process is. There's first a conviction, then there's a penalty phase. Is there anything about the murder of a police officer or the prior murder of a pregnant woman that would cause you to automatically vote for death without fairly considering mitigation in this case?
No, ma'am.
Okay. So, do you have any doubt about that?
No, ma'am.
The description that you were given was of an execution-style murder of a police officer, and then you said, yeah, I would think so when asked, would that cause you to vote for death? And you said, I would think so. Can you tell me what you were thinking when you answered that way?
Only if sane, but I think that way. You have to first.
Right. Insanity is just a defense to guilt. So you've already convicted him, okay? We're pretending for purposes of all these questions. So insanity is off the table. Mental illness is not, but insanity is. It's two different things, all right? So insanity's gone. You're in a penalty phase. And again, like I told you, sir, the truth is the only thing I'm looking for, all right? It's what we're all looking for. And whether or not you can do your job as a juror. So can you listen to the mitigation with an open mind, or would the fact that this was as it's been described, the execution-style murder of a police officer, and there's a prior conviction for murdering a pregnant woman, would that be the end for you? That you're not really listening to mitigation, you're just thinking, this is a death penalty
I can
case?
keep an open mind.
Okay, so are you automatically thinking this is a death penalty case?
No, ma'am.
You're sure about that?
Yes, ma'am.
And you could vote for life even with all those circumstances if you thought that life was the appropriate sentence?
Yes, ma'am.
And have you made up your mind at this point about what the appropriate sentence in this case would be?
No, ma'am.
All right, thank you, sir. We'll be right back with you. Thank you. All right, sir. The good news is we don't have any more questions for you today, all right? But I'm going to send you through to the final round of questioning. And that group, we're going to pick the jury from that group. So if you'll hand the deputy your badge, he's going to give you a purple dot now. Remember I told you we call jurors by colors?
Yes.
So I need to change your color. Purple is the final group. We will be picking the jury from that group. I don't know what day it is. It won't be before Friday. It's probably going to be next week. But just to be safe, we're going to give you a packet. It includes a slip of paper with a phone number that you can call to find out if you're supposed to come back. You need to start calling that number on Wednesday after 5.
Okay.
Unless you hear them saying the purple group needs to come back, don't worry about it, okay? Eventually, you're going to hear it. That day that you come back, you need to have packed a suitcase, because if you're chosen, we're sequestering the jury that day. Leave it in your car. You're picked, we'll make arrangements for you to pick that up. If not, just drive home with it. We also include a sequestration packet in there. It gives you a lot more information about being sequestered and some suggestions about what you should pack and bring when you're,
I have one
yes,
question.
sir.
I don't have a car. Other than he takes me back and forth.
Okay, then we'll make arrangements for folks who are in your situation, all right? Since
Yes,
you
ma'am.
clearly can't leave your suitcase somewhere else, but we'll make arrangements for that. I'll make a note of it. Thank you. We also have, oh, you're disabled, so there's also a letter in there for your employer if you need it. Any other questions?
I don't have one.
Okay.
Unless you
Any
want
other
to call.
questions?
No, ma'am.
Good? All right, thank you so much. We'll see you next time.